um, um, what is prepared for you, where are the places where you're expected to go in terms of whether you need to excuse yourself or have an inconvenience or whatever, etc. But before that person comes, Dalton and Melissa will go first, and then we shall also have Mr. Nasakonde, who will talk to you. He's someone passionate about legal education, and he will basically talk to you about what he has prepared, about what the law is, how you can use the law to transform society. I don't want to preempt his package. So now I will hand over to Melissa and Dalton, and then afterwards they will hand over to Nasa, and then afterwards we shall have the person from OCOM. Thank you.
Good morning. My name is Dalton Chisule, and I'm one of the judges for today. And I welcome you all to Makerere School. So I'm going to be taking you, the competitors, the mooters, and also the general student body and the patrons about the technical bits of the rules and what is expected from you. So first, once you've been informed of the pairing, you will wait for communication directing you to where you're supposed to be mooting from or competing from. That is for the particular schools. And you are expected as a supporter to only sit in that particular room where your school is competing from. And you're not allowed to go and spot in other rooms where your school is actually not competing from. So that would mean that for the first 2 rounds, you'd be expected to follow your team as it is allocated, or to the room that it is allocated to. And then later on, the rule will only apply to the teams that would have broken off to the next stage. So that would mean that if your school does not actually break through to the next stage, you can actually attend either, of the competitions that are happening at that particular stage. Secondly, to the mooters, as you may be aware, you have 20 minutes in your particular, you have 20 minutes in which you're supposed to deliver your speeches. And in those particular 20 minutes, a mooter, you're supposed to spare not more than 3 minutes for rebuttal. And then your division should ensure that no particular speaker speaks for more than 12 minutes in total. And then you're also expected, the respondents, you're not expected to actually spare time for rebuttal, or rebuttal rather. So for your part, you can divide your time amongst yourselves without leaving any particular time for rebuttals. So rebuttals are only for the applicants, while mooting before judges, will be expected to demonstrate first the awareness of the law. That is, great regard will be attached to a person who cites the Constitution and the relevant sections of the Act. So those particular resources were available to you in your resource materials. And a demonstration of knowledge of the facts as well, and the substantial mooting, you mooting and demonstrating a link, your ability to apply that particular law to the facts will actually be an added advantage. It is expected of you to actually moot with decorum and address the judges with the particular titles that are provided for in your resource book. So even the moot rules. So you could refer to the judges as my lords, my honor, my lords, your honor, and things like that, your lordship, if you could. But just be sure that you're exercising decorum in your speech. You'll be expected to also use permissible language that is befitting of this particular competition. Yes. As the moot court is in session, The general student body and the patrons and everyone is expected to observe silence in order to enable the swift flow of the competition. Yeah, so with that, I'll now hand over to my colleague to further brief you on other relevant aspects.
Thank you, Dalton. Good morning. I hope we are all happy to be here. It's an honor to watch you moot today. Maybe to add to Dalton's voice, kindly note that today you're not students, you're not just mooters, but you're council, okay? So you've had an opportunity to interact with the question, and the assumption from the judges is that you're well prepared, either as applicant or respondent, yeah? Then maybe to emphasize court decorum, you can't have your devices at the table, but you are allowed to pass a note to your colleague. Kindly respect the other party when they are submitting, because judges are looking at these things. So when, especially as a respondent, you're supposed to respond. So kindly make sure you know what they are saying, and then you're able to deliver. Other than that, we really wish you well in the competition, and we're happy to have you. Welcome once again. I'll hand over to Nasa.
Hello everyone. It's a pleasure for me to be here. I can see many of you. I was in your shoes about 15 years ago when I was in high school. And we were very unfortunate. We never had these kind of opportunities. This is the first kind of moot for you guys. And I'm very grateful for these guys for organizing this. It's supposed to help you to have an understanding of what the law is and have an understanding of civic education. I'm told there's no more civics at primary, and there's no political education at secondary. So this moot is meant to give you an understanding of civic education, basic principles like constitutionalism, human rights, and as students, there are certain issues you're going to face, discrimination, oppression, suppression, and there's a need for you to know what the law is so that you can stand up for yourself. Another aspect about this moot is to inspire you to come here one day. When I was in high school, we had careers day, but it wasn't as effective as it should have been. The only lawyer I knew in my life was my mom's elder brother, and he died when I was in senior one. So I never got a chance to interact with the lawyer throughout my high school to get inspired. I always tell people in my high school I wanted to be a doctor, but I was never good at chemistry. So I had a tussle with what do I want, okay? When I first came to university, I did a degree in IT for 3 years. I worked for 1 year. Then I realized my calling was to be a lawyer. So I came back to university to do law, which means I spent 10 years here. So I wouldn't want you guys to be like me. I can't say I was confused, but there was no inspiration, there was no mentorship, there was no one to tell me, maybe you're good at poetry, you're good at literature, you're good at public speaking, you're good at arguing, so maybe you can think of a career in law. Our teachers kind of discouraged law. They thought we couldn't make it, weren't smart enough, and those things. So I would love for you guys to use this experience to inspire you and look at it as a preparation, okay? If you're in senior 3, think about senior 4, then think about what electives you're going to do in HSC. Most of you pass sciences highly at O level. Then the school administration tells you do PCB, do BCM, because the school wants to have a AAA in PCB or BCM, but your calling is a lawyer. So in my law class, I had classmates who were doctors, pharmacists, engineers, but they realized their calling was law, so they came back to do law. Okay, I had a classmate who had done BCom, SIPS, MBA. She was working in URA in a very top job, but she came back to do law and study with her daughter. Now her daughter had done PCM, at Namagunga because she got 9 in 8. She got 9 in 8. The sisters were like, look here, you've done well, do PCM. So she did PCM, got 17 out of 20. But the mom told her from when you were young, you wanted to be a lawyer, so you come and do law. So imagine you doing PCM, ICT, then you end up in law school with guys who have done literature. You know, she struggled with essays because she was good at calculating numbers. But now, she's a very good lawyer now, despite that struggle, and she's thriving. So I want you guys to use this experience to inspire you to become lawyers, but also to think about the law differently. We were very fortunate in our law school days. We were trained differently. The previous years were trained to be commercial lawyers, to be rich lawyers who drive Mercedes-Benz and G-Wagons and all those things. But our crop, we are different. We were trained to think of the law as uplifting society. And of course, our teacher, Dr. Kawumba, is over there. He emphasized a lot that don't look at the law as becoming rich. Yeah, he would always tell us, you guys are laughing at my car, but I love my car. And I love the fact that I can come and teach you guys, and I'm happy. I don't have to drive my car in town while looking sideways with tinted windows because I defrauded someone, because I entered a commercial deal and I was about making money. So we were trained differently, and our lecturers were very intentional that when you finish law school, please go back to society and improve it and make it better. Okay, that's why we are coming up with all these initiatives for the first time, because we want you guys to not think of yourself as very rich and we don't want to call ourselves learned friends, okay? We call ourselves council, but the Mutua Wansi, the guy in Katanga, doesn't really know about those things. They don't know about a lawyer. They can't even afford one. So we want you guys to think of the law as a tool to uplift society. And I want you guys to look at this moot problem and this competition as a way for you to appreciate how to uplift society. I tell people that in 2012, I studied about online learning when I was doing my degree in IT. But when we were being taught that, it was abstract. I didn't think it would happen, okay? Then when I was here doing my law degree in 2020, Makerere began its first online classes. And it took them 6 months to decide that we should have online classes because they didn't want us to lose time. But in 2012, I was studying about online classes. In 2020, I was doing them for the first time. Okay, but most of you come from very privileged schools. You know yourselves, I won't talk about it. But your schools can afford computer laboratories, they can afford online learning. But think of a school, let's say in Nakaseke, the moot problem, okay? Can you compete with that person in UNEB and they beat you and they perform better than you? Of course not. I always give an example of my father. My father went to a Church of Uganda school in Mukono and he sat P7 in 1969, okay? And he was the best student in the whole of Uganda, despite coming from a village school in Mukono. He beat people at Nakasero, Shimoni, Buganda Road, Chitante. And he was able to go to King's College, Budo, and able to go to Makerere University. Because of that, my sister was able to go to King's College, Budo, and Makerere University. Because of that, his eldest granddaughter, this year, will be joining Cambridge University to do medicine. But that ripple effect came from my father in 1969. It was able to go from him to my sister and to his granddaughter. You understand? So think of this moot problem in that context. And if you choose to become lawyers, if you choose to come to study the law here, I want you guys to think of those things. Don't be here and refuse to talk to people who are doing other courses, social sciences, and you call them dense people. No. Think of your law school experience as a privilege, which you must use to empower your communities, your people, okay, and the whole of Uganda. I'm the first lawyer in my family, my whole family. I'm the first lawyer. And I use that to tell people that because I'm the first lawyer in the family, I represent almost everyone. I represent my mom, I represent my cousins, because even my cousins can't afford lawyers. But because I'm the first lawyer, my niece, came to me and she said, after seeing you become a lawyer, I can also become a lawyer. So next year, she'll be joining King's College London to do law. You understand? So she was able to see herself in me. She lives in London, I live in Uganda, but it was so interesting that she had to travel, she had to fly to Uganda and come home to meet me and talk to me about joining law school. Okay? That is how much that effect is. So when you guys do this competition, think about all those things, okay? And that it should stop today. It should go all the way to your careers and your life. Other than that, I wish you all the best, and I look forward to interacting with you in the competition. Thank you so much.
Okay, thank you very much, Konde. Okay, morning everyone. Hello. Why are you guys so dull? Hello. Hi, okay, so my name is Umar Try from Boise. I'll be your tab master for the entire competition, so bear with my voice. I'll be giving you the pairings for the first round. I think you can just help me. Can give this to the judges. It's okay, I'll get them later. Yeah, the problem and then that. Cool. So, okay, let's just get right into it. So I'll be giving you the pairings for the first round. I'll be giving you one, the courtroom, two, the pairings like this team versus this team, and that will be it. There are runners around with tags that have volunteers or volunteer that are in blue. They'll help guide you to your particular rooms. I hope that is clear. Okay, now that I have your full attention, let's dive into it. I hope you also recall your team names. Great. For courtroom number 1, Justice Chisache versus Justice Tibatemwa. Chisache versus Tibatemwa. Courtroom number 2, Egonda Ntende versus Barishaki. Courtroom number 3, Justice Batema versus Justice Gaswaga. Courtroom number 4, Justice Mubiru versus Justice Wamala, but I've been informed none of these teams is yet here, so yeah. Courtroom number 5, Nagawa versus Chiabwire. Oh, I'll just go again. Okay, it's okay. Courtroom number 1, Justice Chisache. Can I just have, yeah. Chisache versus Tibatemwa. Good. Courtroom number 1. Courtroom number 2, Justice Egonda Ntende, yeah, versus Justice Barishaki. All right. Courtroom number 3, Justice Batema versus Justice Gaswaga. Good. Courtroom number 3. Courtroom number 4, Mubiru versus Justice Wamala. Neither of them are here. Courtroom number 5, Justice Nagawa versus Chiabwire. All right. So best of luck. Break a leg. Oh, that is it. Okay, you have any questions? Oh, the sites. Oh, sorry. Okay, so if I read your name first, you're applicant. If I read your name last, you're respondent. So in room number 1, Chisache, applicant, Justice Tibatemwa, respondent. In room number 2, Egonda Ntende, applicant, Barishaki, respondent. Room number 3, Batema, applicant, Gaswaga, respondent. Room number 4, Mubiru, applicant, Wamala, respondent. Nagawa, applicant, Chiriawide, respondent. Any more questions? None. So best of luck. Yeah, so you can follow anyone with a blue tag or red tag and ask them for your room. Remember to roll after the door. This is your room 1. Room 2? Yeah, room 1 you're staying here. Just for that. To put in our rooms. Room 1 is here, room 2 is on the other end of this building. Room 3 is the other side. So room 3 is for room 5, there is the bars.
So I'll be here now. I'll be doing 11 minutes. Yeah, that's right. This is a dream come true adult. Oh my god.
If you're moving, just what's the size? Where are the applicants for this group? Just to let you know, you speak from where you're seated, right? Yes,
Just to keep quiet and listen. Nothing with interruption.
Then you all stand, right? Everyone, you stand, and then you all sit in this seat. Are we together?
Jones, the applicant Grace Nabunya and Samuel Katumba versus Nakaseke Bright Future Secondary School. Applicant.
May it please this honorable court. My name is Lenry Juliana, the senior counsel for the applicants. Along with me, my lords, is my co-counsel, Alana Chirabo. We shall divide this honorable court's time as follows. I will use 10 minutes to handle issue 1. My co-counsel will use 8 minutes to handle issue 2 and reserve 2 minutes for rebuttal. My lord, I maintain that this honorable court has unlimited and original jurisdiction as provided in Article 139 of the Constitution. In addition,
we have
my lords, I maintain that this High Court has unlimited and original jurisdiction as provided in Article 139 of the 1995 Constitution. In addition to this, Section 3 of the Human Rights Enforcement Act, which is read Section 2, describes this High Court as a competent court. However, my lord, my clients are asking for a compensation of 70 million, which exceeds the pecuniary jurisdiction of the Magistrates Court. I will. Without further ado, my lord, I will handle issue 1, which is whether the exclusion of people with disabilities into the alternative classes under imposed financial burden on their parents violates Article 21, 30, and 35 of the 1995 Constitution. My lords, my arguments will center around Article 30, 35, and 21. For my first argument, my lord, it's the applicant's contention that the respondents violated Article 30 of the 1995 Constitution. Education is both a human right in itself and an indispensable means of realizing other rights. My clients assert that the respondents, in taking them to alternative classrooms, did not cater for Article 30, my lords. In addition to that, my lords, our Constitution provides that they have a right to education, and this has not been fulfilled in this regard. At Article 24, under the United Nations Convention on the Rights of Persons with Disabilities, it provides for inclusive education for my clients, my lord. However, in paragraph 9 of the facts, my clients were taken to alternative classrooms, and at last they were offered outdated means. The United Nations Convention on the Rights of Persons with Disabilities.
So you're relying on Article 24 does that convention, is this court, can this court, sorry, is it obligated?
It's not obligated, but I first stated Article 30 of the 1995 Constitution, which is a right to education. Article 24 is just a supplementation to the Article 30 of our Constitution. It provides for inclusive education for persons with disabilities, my lords. Inclusive education is not about separate rooms as evidenced in paragraph 9 of the facts. It is not about outdated learning instruments that my clients are provided with. Since our books of law do not define outdated instruments, with reference from the 4th edition of the Black's Law Dictionary, outdated means something that is no longer in use. My lord, my clients are offered something that is no longer in use. Such means cannot involve inclusive education.
You're making very good submissions, but is the right that you're referring to an absolute right, and there are any allowance for exceptions to be made in
education is not absolute. However, in this case, we argue that they were still discriminated in this right to education because some people were getting the education fully, but my clients were not getting it fully, like the rest.
Correct to that, but still the exception that in this case there was a reason as to why discrimination was happening. So it just
the discrimination was happening against my clients. It should have been good, but they were not getting the same standard. Other students were getting only artificial intelligence material, but my clients were offered outdated learning material, which is therefore a violation of article.
sorry for getting into your time, but we'll get into it. You realize again, you told us that the right is not absolute. The right to education is one of those rights classified as social rights, correct? The realization of which, again, is not exactly mandatory in the state. So there is a concept known as progress realization. Do you know about it? Great. So again, if you are the school in this case and you're trying your best to ensure that everyone in your custody gets the education that they deserve, should be punished for it and be called discriminatory.
In this case, if I were a school, I should be punished for it because by giving other students things that are outdated, this means that they are not with the same quality. They're not providing the same quality education to both the students that are in the school. And with that, my lord, I will take us to in the matter of Ikoru versus Idiofu in the High Court. Court held, my lord, that it is the obligation of a school to ensure that they include the candidates' statistics, and excluding the candidate would be unlawful, unlike some circumstances. In this instant case, my lord, in paragraph 8 and 9 of the facts, my clients were told that they were going to be, their national statistics were going to be excluded from the national rankings of the school. This is unlawful, my lord, as this is discriminatory and this is not inclusive education. I will proceed to my second argument. The applicants aver that their right to respect and dignity was violated contrary to Article 35, Clause 1 of the 1995 Constitution. My lords, this takes me to the fact that in paragraph 9, my clients were taken to alternative learning classrooms. They dreamed of growing and laughing alongside their peers and growing in their academic life. But when they were taken to these alternative classrooms, where they were termed as the left behind class, my lord, this was not really good for their dignity and their respect, contrary to what our Article 35, Clause 1. In addition to that, my lord, the respondents...
What would you suggest the school do? Because the other alternative would be they don't study at all. So if the school is trying, at the very least, I would say this is just an occupational hazard. That, true, that there is going to be some, you know high school students. They're going to laugh at you, they're going to laugh at the class in which you are. That's just part of the daily grind of being in high school. But don't you think that it's better than not studying at all? Would you fault the school for putting for trying? Would you extend them some grace?
My lord, I do find the school at fault because they did not follow Article 21 of the 1995 Constitution, which states that the school is supposed to provide equal protection in all spheres for persons with disabilities. In this case...
So just a minute. So you said Article 21 of the Constitution, yes, right? Does Article 21 create obligations on the school or on the state?
On the state, but in this case, the state is working through Nakaseke Bright Future Secondary School because Nakaseke is a government-aided school.
Yes, so in that case, okay, so the government is helping the school, so you're suing the school, not the state? Don't you think the school has no means, even if it tried? I mean, they have tried, they have told you, we are waiting for the state. So don't you think the best person to really fault would be the state, not necessarily the school?
I believe both are at fault because in this case the school also failed to ensure protection for the people with disabilities in all spheres of life.
Okay, so give me a practical, practical scenario. What would you do if you were the school?
My lord.
Within the means, because remember they don't actually have money. There's no money. What would you do if you were the school?
I would ensure, if I were a school, I would ensure that the students are able to study all together with the others because it fulfills Article 21, Clause 1 of the 1995 Constitution. In addition to this,
wouldn't that be without still the discrimination because you're making them study with other students who have no disability, right? Meaning the learning mechanisms that are going to be applied will be similar across the board. But you also recognize that these individuals have disabilities that then require them to have specific attention. So how then do you balance the two, having them studying their fellow students and then also taking into account their limitations?
my lord, I'm taking into account the fact that the students feel like second-class citizens in this alternative learning rules, meaning that there is psychological torture, hence they cannot actually study, despite the fact that the alternative learning rules are supposed to be for study. In this case, it is better that we contain the students with disabilities with the rest and pop up in the artificial intelligence, as they will feel together, hence they are able to actually realize their full academic potential where they don't feel stigmatized, my lord.
Your time is up, but you can take a minute and just complete your
My lord, it is our prayer that the court holds the respondents with a compensation of 70 million to the applicants. In addition to this, a public apology for the psychological torture that they caused to my clients, making them feel like second-class citizens in their own school and being referred to as the left-behind class, my lord. It is so our prayer, much obliged, Your Honor, I submit.
Ladies and gentlemen of this honorable court, my lords and our land friends for responding. As earlier introduced by my co-counsel, I am Muzati Alana Chirabo, addressing issue 2. I am here to demonstrate, my lords, I am here to demonstrate that the collection of biometric and personal data without consent violated the right to privacy. Under this issue, I'll be fronting 3 arguments. Argument 1 is that the collection of biometric and personal data without consent violated the Data Protection and Privacy Act. Argument 2 is that the same collection of data violated the ICCPR. Argument 3 is that the respondent's actions did not pass the test of limitation under Article 43 of the 1995 Constitution. My lords, I will now proceed to my first argument. It is the applicant's submission that the collection of biometric and personal data without consent violated Section 8, Subsection 8 of the Data Protection and Privacy Act, which states that no child's data shall be collected without consent of any parent or guardian. It is evident from paragraph 6 of the Act that Nakaseke Bright Future Secondary School under the Ministry of Education collected personal and sensitive data such as facial scan, fingerprint, and voice recording with no consent from its necessary.
Yes, please. Is there an exception to this general rule of collecting data from the resource of the exceptions, and why the exceptions would be applied in this case?
Yes, my lord, there are exceptions. The exceptions are under Article Section 8, Subsection 11C, that it must be necessary to comply with the law and that it must be used for statistical research. But my lord, under my third argument, I'll be talking about why the...
You can address actually that argument as well. Yeah. You answer the question, please.
My lord, therefore, I will proceed to my third argument. In the Supreme Court case of Charles Onyango versus Attorney General, it was held that for any limitation to be allowed, it must be lawful. Number 1, it must fulfill a legitimate aim, it must be necessary, and it must be justifiable in a democratic society. My lord, I understand that the Data Protection and Privacy Act is a law and that the objective is education, but I will show that the third and fourth requirements were not met. Starting with the third requirement on necessity. In the Supreme Court case of Charles Onyango versus Attorney General, it was stated that for any limitation to be necessary, it must be proportionate. The respondents collected a lot of data which is more than necessary for education. only the facial recognition.
Which part of the data was the AI one?
My lord, under paragraph 5, you can see that only the facial scans were accounted for. Not the fingerprints or the voice recordings were not accounted for. This concludes that they collected more than that was necessary for the purpose of education. Going on to the fourth requirement, that the limitation must be justifiable in any democratic society. My lord, which democratic society would allow excessive data collection of minors? Worse if it's being stored in servers outside of Uganda. My lord, may I proceed?
Maybe just educate the schools on how exactly this AI works, so that we can get a full picture of why it's wrong to take this data and why it's excessive. Because from what the court understands, and I believe probably the respondents will argue that this is very necessary data. You need fingerprinting for encryption. You need facial recognition for encryption. If you want to protect the data, you have to encrypt it in one word. If it's unencrypted, then it's going to be subject to abuse by third party. So that could be, it's necessary. And you also argue that probably many countries do this anyway. So, and on the argument that you've just been making, the data is stored on servers outside of the country, I would like to understand exactly how that is a problem. If within the country we do not have the facilities to store the data, wouldn't it be in the best interests of the young people that actually store the data in a place where it's going to be really secure? So could you just address us on that? How exactly does this AI work, and further buttress your argument on it?
My lord, the AI collected fingerprints, facial scans, and voice recordings. The AI has been known to make automated predictions, as seen in paragraph 6b, where some students were told that they would not pass vocational training. The same AI works in a personalized way, as personalized tablets were given out, but people who could not afford these personalized tablets shared in groups of 10. But I think that the AI collection was not necessary because on many learning platforms, you log in with your email, with your credentials, not your fingerprint, not your facial scan, only that you were.
But how this court understands AI is that AI works on data. It has to receive data. It has to get data. I believe that you are very. Have you addressed your mind to court case of New York Times against OpenAI? Have you? Yeah. So that was a case in the US where New York Times newspaper was arguing that the creators of ChatGPT had used a lot of data from New York Times and they were using it in their own, to train their own model, ChatGPT. So when you ask ChatGPT a question, it can give you an answer, but part of those answers are gotten from New York Times. You understand? So how we understand this is that AI really works by getting information. It needs the information for it to work. Right? So if you're asking this court to bar the state and the school from gathering that information, then how will the AI work?
My lord, first of all, the data collection was not considered. Second of all, if this data was necessary, as the respondents were saying it is, why did they account for the voice recordings? Why did they account for the fingerprints? If it was really necessary for the data to be used in the education of the student, then I expect it to be explained in the case file, which it is not. So I assume that the data collection of the fingerprints and the data collection of the fingerprints and the voice recording was not necessary because it was not accounted for. And that's why my argument is it is not proportional because they don't need it clearly.
Okay. Please address your second issue. I believe you haven't spoken about it. Your second sub-argument.
My lord, therefore I'll proceed to my second argument. My second argument, which is that the Article 17 of the ICCPR was violated. My lord, Article 17 of the ICCPR provides that no subject shall be No one's data shall be subject to arbitrary or unlawful interference with their privacy, and clause 2 obligates the state to protect data subjects and the applicants from such interference. As already demonstrated, the respondents.
There is a similar question that I asked you earlier. Why would the ICCPR be applicable in this court? Like why are you citing what value does it hold for this court?
The ICCPR is an international law and therefore persuasive in this court. As already demonstrated, the respondents did not care to obtain consent from the data subject's parents. My lords, I emphasize that consent must be specific. That means that me and bringing my child to school does not give the school permission to anyhow collect their data, especially since this involves AI, which is a high data security risk. My lord, it's therefore submitted that Nakaseke Bright Future Secondary School, Nakaseke Bright Future Secondary School, under the Ministry of Education and Sports, failed in its international human rights obligations.
Maybe before you take leave of that, I'm just a little curious. Now that you're addressing privacy and that kind of thing, have you looked at the General Data Protection Regulations or the GDPR? You've looked at them? No, not the DPP. That's Uganda. There is a law in Europe called the General Data Protection Regulations, or the GDPR, which gives us some pretty good insights on what data privacy really is. But even if you haven't gone that far, could you address? You've been mentioning quite a few technical terms, yeah. So could you perhaps define for us what a data subject is, or a data controller is? What are those entities?
My lords, a data subject is a person from which data is being collected,
Mm.
and a data controller is a person who is collecting the data.
Okay. And what exact obligations would you say a data controller has if they collect data? What is required of them to do?
They are required to provide adequate measures of protection. They are required to look for the subject's consent,
Mm.
and I think that those are the only ones that have really addressed my mind concerning this case.
Okay.
So
Right. Thank you.
Before your time runs out, you mentioned something quite interesting. You said the school violated its international obligations under the ICCPR. Just help this court understand, is the ICCPR, does it bind the school or does it bind the state? And then in that case, who violated what?
The ICCPR is binding as it's international. It is merely persuasive.
To the court it is persuasive. But I'm saying, you made the statement that by the school not getting consent of the data subjects, it violated, should have been Article 17, I think, of the ICCPR. And my question is, can a private entity like the school be held to be in violation of an international statute, let me say? Is the obligation imposed on private entities, or is the obligation imposed on a state? Does it make sense?
Yes. No, I think that it lies on the state through which the school works for. So technically, since it's applied in the state, it is also applied in the school, meaning that the school and the state have failed to fulfill their international human rights obligations.
Okay. Thank you so much. Do you have, please make your reliefs.
My lords, therefore, we pray that this court grants us compensation of 70 million Uganda shillings, and that the collection of biometric and personal data without consent is deemed to have violated Article 27 of the 1995 Uganda Constitution.
So maybe before you run away, this 70 million you're asking for, what is it for exactly?
Throughout this whole drama, my clients have incurred a lot of mental damage, and they have faced psychological and physiological torture. And so we're requesting 70 million not only for compensation, but amount that they pay to cater for this AI, but also for their mental trauma and the hospital.
Okay. So do you really think, just this is off record, do you think that the school will be able to give you 70 million when it has been crying that it doesn't have money? Can this court give an order that would be very difficult, if not impossible, to fulfill?
I think that it can, because it has had, let's say, over 70 students, 1.5 million shillings, and an additional 900,000 shillings.
So it can really afford the 70?
It really can,
Okay.
especially with the open space.
Okay, sure. Thank you very much.
This is Honorable Court. My lord, I am Mr. Manuel, the head counsel here of the co-counsel of Mr. Todd, representing the respondents in our secretary education. We will address two issues. One, I will address the issue in question, whether the measures taken for children with disabilities, including alternative classes and optional specialized devices, represent reasonable accommodation and progressive realization within the school financial and technical limits. I will address this under one head of argument, which is the right to education being subject to progressive realization based on available resources in 11 minutes. My co-counsel will address the second issue, which is that data collection is lawful, necessary and proportional and serves legitimate aims such as promoting education safely and preventing exam malpractices. We'll argue this in 9 minutes. Moving on to the first issue, which talks about education and discrimination. The first argument is on the right to education being subject to progressive realization based on available resources. My lord, note that we have Article 2 of the International Covenant on Economic and Social and Cultural Rights, which talks about progressive realization, that the state should take targeted steps on realizing education. We understand that states in themselves can have certain things like economic constraints, and therefore we don't expect them to be providing maximum education like Uganda providing maximum education that is provided in the USA. Therefore, in pursuit for progressive realization, we give them some core time to provide some education in realizing the norms of education in a minimal time.
Counsel, we appreciate your efforts to progressively realize the right to education. However, there is a very important point that the applicants raise, which is, number one, you are giving these students with disabilities, you're giving them material that is outdated. Is that progressive enough for you? Do you believe it is?
I feel it's progressive in the sense that if we didn't give them outdated textbooks, the alternative would be them going back home to sit and sleep, which is not education at all. We think in progressively realizing education, we took steps in giving them alternative classes where they had AI-generated content and alternative material that provided basic education, progressively realizing the right to education.
So there is something also, now that you've talked about Article 2 of the ICESA on progressive realization, that article also creates certain obligations, yeah? Before you do progressive realization, there are certain things that you're supposed to do. Regarding the right to education, what are those things, and has the state done those things?
There are two factors under which the progressive realization cannot relate.
Mm.
The one is education being non-discriminatory, right? We feel in our sense, education was not discriminatory at all.
No, it's not really the discriminatory nature per se, but there is something called a minimum core obligation. Have you ever heard of those?
Yes.
What are the minimum core obligations regarding the right to education? And in this instance, have you fulfilled those minimum core obligations?
Yeah, the minimum core obligations are simple. Providing these students with this education on a comparative of them not getting education is that the alternative classes we gave them were tailored to their needs because they needed to understand the reading, and the classroom was tailored to their needs. The smart class AI that was introduced was not in any way meeting their needs because it didn't have special screens that they could use in order to interact with the same class.
I'm finding it hard following that argument, because if it's true that these alternative methods were tailored to their needs, if that was true, then you would see better education among those students. In any case, you wouldn't have to blot out their names from the National Register so that you do not shame the government and the school, the statistics. You want to blur the statistics. So my understanding is that whatever alternative education you are giving them was probably not as sufficient as you're making the court to believe.
Okay, I think the alternative, therefore, was the whole cause of the problem was the introduction of smart class AI. By paragraph 8, it explains that smart class AI is still in its pilot phase, and international suppliers have not yet localized software for disabled learners in this case. Since it is under pilot phase, no one has ever implemented it. We expect such mistakes to come along in the process of discrimination, and we don't think though discrimination happened even if applicants argue that, because it is not the school that discriminated, it is the students.
So you agree that indeed there was some kind of discrimination?
We agree that indeed students felt bad, but it is not the blame of the school, because we tried to
Yeah, they felt bad, but why did they feel bad? Because the argument of the applicant is that this whole feeling bad is as a result of the discrimination itself, right? And they argued quite passionately, Article 21, they said, see, the Constitution says you shouldn't discriminate, and maybe if I could just pick your mind, would you say that there is certain circumstances in which discrimination may be allowed?
Yes.
Which circumstances are those?
I think under circumstances of fulfilling the public interest. That is, in instances where the interest of the public society achieves success of the school, the school itself wants to get fame and more students. Under those circumstances,
so you can discriminate.
Allow discrimination.
Have you looked at Article 43 of the Constitution? Did you?
Yes.
What does it say? Did you have a copy of it? Yeah, could you just pick it up and read it?
Just a second. Yes.
43.
Article 43. The general limitation on fundamental and other human rights and freedoms. I'll quote close to subsection C. It guides on how rights should be limited. It guarantees that public interest under this article shall not permit any limitation of the enjoyment of the rights and freedoms prescribed by this chapter beyond what is acceptable and the most
that is to see. You've jumped the gun. If you read Article 43, let me read it for you, because I would like for this to also be a learning exercise. So, Article 43, says, in the enjoyment of the rights and freedoms prescribed in the chapter, no person shall prejudice the fundamental and other human rights and freedoms of others or all in the public interest, right? Then 2, it says, the public interest under this article shall not permit political persecution, detention without trial, any limitation on the enjoyment of the rights and freedoms prescribed by this chapter beyond what is acceptable, okay? Then, when you go to 44, okay, because 43 leads you into 44. 44 tells you, notwithstanding anything in the Constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. 1, freedom from torture, cruel, inhuman, degrading treatment and punishment. 2, freedom from slavery or servitude. 3, a right to fair hearing. 4, a right to an order of habeas corpus, right? So the question that I asked you was for you to give us that limitation that the applicants argued quite passionately, by the way. They said that the 4 aspects in Article 44, Article 43, those and which are also given in Charles Onyango Bill, 2 of them were not fulfilled. They said necessity, and what was the second one? They said that it did not fulfill necessity and proportionality. Okay? So, explain to this court.
I will start with necessity.
Yes.
In this case, again,
Mm.
we assert that it was necessary for these students to still follow education and get classes where they could receive this education. It was proportionate to their needs because under that system they could still get education. In a class where smart class AI was still introduced, it wouldn't be proportionate because there still is no way in which those students can study. So for terms of proportionality, the alternative class makes it proportionate. The second, which is interest, right? I think in interest of the learners, their interest is to receive education at the end of the day. Bare minimally, basic education is as described by progressive realization of education by the state. We provided them with bare minimum education, at least that they could get some education, they could be able to read and write as a state. We think in interest, they have interest of.
Would that education you provided them be enough to put them at par? Yeah, I'll give you an extra minute. Would that education given to them be at par with their peers? Because the whole idea is that they should, in the very least, be at par with their peers, in one way or the other.
They would be at par with their peers because since this is still still a pilot project which someone has never interviewed.
They would be at par. Why then do you feel it necessary to take them off the school records?
We feel in interest of public, in the pursuit of public interest, taking them off the records in the meantime, which is as temporarily change, makes it important in the progressive realization of education.
Does it really? Does it? Do you feel like by taking them off the record so that their results do not reflect badly on the school is in fulfillment, one, of public interest, but also secondly, it's in realization, progressive realization of their right to education?
Yeah, because I think if it is a pilot project and a temporarily smart class AI, with time, if there are problems with it, we can find means that come along with it. Because paragraph 9 also talks about the idea that I think paragraph 8 also explains that the international suppliers have not yet localized software for the disabled learners, meaning in the next phase of the implementation of the pilot project, would be in best position to provide these learners with a smart class AI that helps them with their needs.
Right. Thank you very much for your very passionate submission. You can now hear from your colleague.
May please this court, for purposes of records, my name is Mr. Joel Co-Counsel on the respondent side, and I'm going to argue on issue 2 on the respondent side under one head of argument. That issue 2 is the data collection is lawful, necessary, and proportionate and serves the legitimate aims such as promoting education safety and exam malpractice. The first head of argument. The right to privacy permits lawful proportional limitation for direct interest. Yes. I'll quote Article 43, limitation of rights limitation of fundamental and other human rights and freedoms. Clause C, Clause C and subsection C, Clause 2 and subsection C guides on how rights should be limited. It guarantees that public interest under this article shall not permit any limitation to the enjoyment of rights and freedoms prescribed by this chapter beyond what is acceptable.
Pass the laws.
Yes, my lord.
There is an argument that one, you didn't take consent. You didn't ask for consent when you were collecting this data. What justifiable reason do you have for doing that? And secondly, they also argue that the data that was collected was more than what was necessary.
Yes.
Just address us on those two heads of arguments.
First head of argument, without the consent of their parents. Yes, we admit we collected this data without the consent of their argument, without the consent of their parents or guardians. But then it is acceptable and demonstrably justifiable in a free and democratic society. Why did we collect this data in the first place? Firstly, we have to maintain exam integrity. We do not want these students to, in the first place.
What injustice would you suffer by asking the parents to give you consent for their children's data to be collected? Would it in any way jeopardize that consent? Would it in any way jeopardize the examinations that you're speaking about?
Yes, consent is twofold. Firstly, they could give in the consent or even refuse to give in the consent, but it's for public interest. That is to say, the parents could in and of themselves.
Had they refused to give you the consent, had you asked them and they refused to give you the consent, those are, I guess, are also two different things. Did you try and they said no, hence you proceeded to say, in the interest of the public, we will proceed to collect the data anyway? Did you try? Because in this case, it seems like you just decided to proceed with it. Because you see, for you to say it's demonstrably justifiable, you must at least show that there were efforts that had been undertaken to either get the consent or show that the getting of the consent would impact your examinations or whatever it is negatively. So in this case, what was that reason for you to skip the requirement on consent?
Okay, as lead counsel said, this is a pilot project. We expect imperfections here and there, and we promise that in the next phase we are going to better up this. But then the taking of this biometric.
So is that an admission that indeed you violated these people's right to privacy?
Yes, it's an admission that we violated these people the right to privacy, but then we think it is justifiably and demonstrably acceptable in this.
But then you see, society. You cannot violate and then you say, but it is justifiable. Once you say that it's true, we violated the right, that in and of itself, the court then ends and we award them the 70 million and everyone goes home. Because you've just literally told us, yeah, we actually did, we violated. It's an admission. Unless, of course, you say we limited the right, okay? But we have actual reason why it was limited in this instance. And that actual reason should take us to the exceptions that the applicant argued. Because the applicant argued that there are exceptions to collecting data, okay? Still under the DPPA, under Article Section 8, there are actual exceptions. So could you address us on those exceptions and how exactly you fall within that exception?
If you don't mind, pardon me, my lord.
The applicant argued that under Section 8 of the DPPA, which provides for consent, there are exceptions to it, right? And those exceptions are still found under that, you know. So could you address the court on those exceptions and how exactly your client falls within those exceptions?
Yes, the biggest exception is for public interest, right? If at all our action is for the betterment of the education service that we are in and of ourselves ushering in, and it's for the betterment of the public interest in those kinds of regards, then we think we are justified to limit the right to privacy and to limit the right to privacy and the fundamental human rights of these individuals, my lords.
Yeah. Let's us look at that. So I believe you probably hadn't properly addressed your mind to that, because this is a very important point, especially dealing with minors. The data of minors is quite sensitive, and you want to protect them. So if you look at Section 8 on personal data relating to children, okay, you are not allowed to even collect that data unless there is one prior consent, okay, of the parent or the guardian. Okay? 2, it is necessary to comply with the law. So there must be a law that is telling you you must collect this data.
Yes, my lord.
Okay? And 3, it is for statistical and research purposes.
Yes, my lord.
The wording of these 3 is in fact cumulative. It's not that you can fulfill one and then leave the other.
Yes, my lord.
Right? So in this instance, you did not get prior consent
Yes, my lord.
of the parents.
Yes, my lord.
And you have said that is because?
It's because we want to better up the... No, it was under 2 folds. Firstly, it is a pilot study. We expect imperfections here and there. But then secondly, why we then limited the right to, privacy and data protection is because it is for the betterment of the, of the education system that is provided. We want to better it up, and we need this information to firstly gather up their attendance and even exam integrity in those kinds of places.
I'm finding it a bit hard to follow that argument, a little hard. You say it's because you want to better the program, and then secondly, because a pilot study.
Yes,
none of these is an exception. None of them at all. In fact, if anything, they are the very same reasons why you're supposed to get that consent. Because a pilot study, by its nature, is experimental. So you need to get the consent of the parents before you can experiment, because anything can go wrong in these experiments. Secondly, you want to better the algorithm using children's data. As a parent, I would like to know exactly how my children's fingerprints are really going to better your algorithm. Without them, you can't. You may need to explain it to me properly so that I can understand it, which I think is the whole reason for getting consent, don't you think?
Yes, I think so. But then when this program was introduced in this school, parents welcomed it with warm hearts and, with regards, because it had shown drastic...
So there is constructive consent. The fact that they were happy with it shows that they were...
But then secondly, because it is for statistical, information and storage, we need to follow up these students' performances. We need to follow their attention in class and attendance, so that justifies us to limit the right to privacy and even consent of these very individuals and these students. My lord.
Yeah. So address the argument of the applicant on restriction using the Onyango-Bo criteria that they set out.
Restriction using the...
Yes, because they set out the case of Onyango-Bo. You've read that case? Oh, you haven't. So that case establishes restrictions in which instances can you restrict certain rights. And they said that, yeah, the state may have fulfilled the first 2, but the other 2 are problematic. And they raised the question of proportionality.
Yes, my lord, and necessity.
And necessity.
Yes,
okay? So address us on those 2. And as you do so, I don't know if you've read the GDPR that I asked them about, the General Data Protection Regulations of the EU.
Yes, my lord.
You have looked at them, so you can put that, your answer, bundle both of them together. So you can tell us what the GDPR says and your argument on those 2 key issues.
First key issue is on necessity. I we see it is necessary for the new educations. My lord, my time is up. I would request for more 5 minutes.
No, 5. You have 2. 5, my friend. 5 minutes is a lot.
Okay, thank
you have 2.
In those 2 minutes, let me address the issue of necessity. I find it necessary for this school and institution to take up and take that information, personal information and data of these students. Why? It is for the betterment of this education system. We need to follow up their attendance, we need to follow up their attention in school, but then more so, we need to follow up things like examination integrity, and that's what is necessary for an education system to be effective, and that's what you want in the first place. But then secondly, on the idea of proportionate, was it proportionate then? They are asking that, was it proportionate then for us to take the data without their consent or without the consent from their parents or guardians? I think it is proportionate because we have to follow, because it is for the public interest, as I earlier explained, and there was no way we could execute all these flaws, execute all these all these proceedings without the collection of that data. It is necessary and it is proportionate. But then more so, my lords, we think this is a pilot study. We expect imperfections here
I'm
and there.
sorry, I know your time is fast spent. However, on the point of the collection being proportionate to the use of the data,
yes,
the argument was you collected much more than would
it
be
was necessary.
Yes. Just address us on why for you think the amount of data that was collected in this case wasn't much more than what was actually necessary.
I think the fingerprint, I'll just explain what each kind of information
Exactly,
is necessary.
yeah, that's what
the
you want,
fingerprints are in and of themselves to get the attendance. Facial scans are for attention in class because that's what the clause under facts, under paragraph 2 status. They say that the fingerprints and facial scans were taken without the consent of these parents. Fingerprints were just necessary for the attention, for the attendance as a roll call, then facial scans for the attention because we get to know that this is an AI. It has to deal with things like gadgets. So a lot of diversions and a lot of diversions for things like attending on to what the education system would require. But then we need these fellow students to take us to just take a step more permanently and then go on to and attend the lessons and attend the education programs, my lords.
Right.
So if there are no further
please give your prayers.
We pray, my Lord, that this court does not hold the respondents accountable to pay 70 million because we explained to you that the need that why we limited the rights of these people is proportionate and it was necessary then. But then also we pray that this court does not guarantee the respondents a public apology. But then also we find it misleading for the applicants to come and argue that the school has enough money, the 1.5 and the 900,000 they are collecting from the students, because that is to implement and ensure that every child gets this kind of gadget, not for the school in the first place. So yeah, if there are no further questions, allow me to give the floor for the next speaker. Thank you.
All right, thank you so much. I was advised that you have some points for rebuttal.
My lords, whereas the respondents argue that their actions were out of progressive realization, progressive realization is not disparity in standards. It is not taking my students, my clients into these alternative rooms and giving them outdated material. This defeats progressive realization and goes against Article 35, Clause 1 of the 1995 Constitution. In addition, the respondents argue that removing my clients from the national ranking statistics of the school is out of public interest. But my lord, in the matter of ICORU, the High Court matter of ICORU versus the Board of Governors of Ediof Secondary School, the court held that where the statistics of certain students have to be removed, this is unlawful, my lord, and this is what the respondents did to my clients, my lord. It is therefore so our prayer that the respondents are held accountable for going against Article 30, 35, and 21 of the Constitution, my lord.
Right, thank you so much for that rebuttal. I believe that now we have come to an end of this round, and we will be giving a few brief remarks before we can proceed to the next. We are going to give a few remarks, and then that should help you proceed to the. So I'll let my colleague first give his remarks, and then you can give us as I'm writing.
Okay. Thank you. Sorry, what school? Ontario. Okay. All right. As my colleague fills up his form, thank you so much for the session. It was a good one, and I know how nervy sometimes it can be to participate in some of these things, but I think you all did great. You answered the questions, you didn't let them slip, which is also good. Of course, we have different criteria that we use for ranking who said what and whether what you said was persuasive enough, but the mere fact that you answered the questions is good enough, right? It's a good start, that is. Just feedback to both teams. So when the judges normally are asking you questions, in most cases, it's because they want to lead you to a certain direction, and they want to hear that exact thing that they're asking for, right? Now, I know when you're preparing, normally you have everything set out in a straight line. I'm going to say this, then after that I'll go to this. But I think you saw when some of you came and then we told you start with your second or third argument, or let's go this other direction instead of what you have prepared for. So the expectation from us is you should know your case in and out, right? If we require you to take a different direction, it shouldn't be very difficult for you to switch to that direction and then come back to your line of argument that you were making originally. So it's important that you are one and part of your case, right? Then still on us leading you to where we want you to go, you are answering, some of you are answering the questions again from the perspective of this is what I have prepared. But if we are asking and we want you to tell us about the exceptions, go directly to the exceptions and, tell us what the exceptions are, how they apply to your case, etc., etc. So you have to be very keen on what the judges are telling you. Then the other one, again, I know at your level perhaps you haven't interacted very much with some of these laws. We were asking you questions around international law, the ICCPR, ICSR, and their application. But you have to keep at the back of your mind that in this case, the state signs onto these agreements, right? It's not private entities, so you cannot hold me accountable for what the state has decided to sign itself up to, unless you can make the argument that I work on behalf of the state, or I and the state are one as a private entity. Okay, so those are some of the things that you have to take away for your next rounds. But otherwise, I think, yeah, you did fairly well. One last thing, maybe before David comes in, you carry your material with you, which it's not a problem, right? It's not a problem, but we also wouldn't expect you to be reading off it, because sometimes it can actually disorganize your flow. Going back to the first point that I made of you being one and part of your case. So if you're reading from your paper and then I lead you to a different direction that is not on your paper, you realize that you have to start flipping pages, and can actually make you lose your train of thought. So just embrace your case, okay? Yeah, thank you so much.
Right. So I took note of a few things that I thought were important. So for an exercise like this, of course, we do not expect you to know all the law like lawyers would, know everything offhand. But there are what we call the bare minimums, the small, tiny things that either show that you have done more than just preparatory reading, okay? And you kind of understand a little bit some of this. So some of the questions that I was asking were more taking you to the bare minimum, okay? So have you understood that concept? It seems easy, but it has a whatever to it, right? So what I always would say, even in other moods with lawyers, would be always pay attention to the bare minimum. Those simple, tiny things that seem very easy to just pass by. Pay attention to them, okay? So for example, a question, I liked how the applicants brought in the question, the argument of jurisdiction, saying, no, bring this case under Article 139 and, the Human Rights Enforcement Act. There is, in fact, a part of the Constitution that directly speaks to the Human Rights Enforcement Act, right? The article from which the Human Rights Enforcement Act was, in fact, made, and it's not 139. So 139 is about the High Court. Beautiful, amazing. But there's somewhere it comes from. Yeah. So I'll not spoil your reading. You can check it out as you go about your whatever, and perhaps you would address your mind to it. Of course, that does not affect your performance per se, because even some lawyers don't know where the Human Rights Enforcement Act comes from. So it's one of those things that would make you excellent. Now, the performance is outstanding, but as they say, in a room full of mediocre people, any action above average is excellent. Yeah? So where we expect all of you to have all these laws and all these good things, that those good tiny things, when if someone knows it, you're like, ha, yeah, that person did their work. You know, they did more than just a few whatever. The other thing that my colleague has just talked about is the application of the laws. You know that courts work with law, yeah? Please be very careful if you make, if you go more than 2 sentences without referring to a law, yeah? That law can either be the actual law, a constitution, a statute, it can even be case law. And sometimes it can even be, you know, writings, you know, someone has written about this somewhere. It's very, very important. We thrive on authorities, okay? So if you can add a few of those, you'd be absolutely good. The other is, it's called ingenuity. So ingenuity is the ability to think on your feet, yeah? When you come to a moot court, and in fact, court itself, you are expected to think on your feet. There are certain questions you'll be asked when it just needs you to think outside the box. And I believe both of you teams have done a pretty good job with ingenuity, but it could be improved, okay? That can be something like giving an alternative argument, all right? This would especially be good for applicants, you know, when you suspect that the respondent is going to make an argument, and that argument is going to make your case weak. So what you do is you address that argument before they bring it on. So while the respondent may argue this, this is what we say here. So by the time we get to the respondent, we now have questions for them. The applicant said this. So what do you say now? You get. Those are called alternative arguments, and they are really, really good. For the respondent, it's always good for you to attack the argument of the applicant head on. Don't run away from it. As the applicant is speaking, if you notice, most of our questions were like, the applicants argued this. What do you say? When the applicant is speaking, pay very keen attention to what they are saying, because you are responding to their arguments. Okay? So if you do not pay attention to their arguments, it's going to be very hard for you to respond, because you come with your own arguments, and then the court is asking you, but that's not what the applicant is saying. The applicant is saying something entirely different, so what do you say about that? So you need to have that at the back of your mind. So be very attentive as they are speaking, and as a respondent, attack their argument directly. Start with their strongest argument of this is the basis, the crux of the argument is this, and this is what we are saying. That would not be applicable, or that is not the case, or they are misrepresenting the facts, or they are lying to the court, etc., etc. Yeah? But that's what a respondent, a good respondent, does. Okay? Then lastly, this was on concessions. I got this a lot from the respondent. Don't just concede. Now, concessions are good, but they have to be tactical. Okay? You have to be very careful before you concede on a point. Yeah? Sometimes judges will ask you a question just to help you argue it better. Not that they want you to concede on it, they want you to argue it better. So they are trying to see whether you can really think, pull it out, the rabbit out of a hat. You know, I think the first respondent did that really well when I took him to the question of derogations. You know, Article 43, what do you think? And he quickly figured out that I'm trying to drive to discrimination on whether or not it is derogable or otherwise, right? So that is, so you don't just concede on a matter quickly, yeah? You first listen. Sometimes if the question is unclear, you can ask the judge to rephrase it as you're thinking. Could you rephrase that? Could you rephrase that question as you're thinking? And then find an ingenious way of making your point without necessarily conceding. Only concede if you have a better argument. So you may concede on one part, but then now advance your argument on a much more important part. So for example, you could concede that, hey, yes, there are four aspects of whatever derogation, right? That Onyangobo says. However, on the first two, yeah, probably there might have been some issues, but on this other one, or if I ask you a question on Onyangobo and you didn't read it, you don't say, no, I didn't read that case. You say, I may not have addressed my mind to that, but I addressed my mind to this other case. Or there is this other authority that would make my point for me. So you concede that, yes, you did not read this, but you have something better that you're going to offer the court. You understand? So that's what we call a tactical concession. Concede on one, then get them the other side, okay? So those aspects, I believe would make an even better round, but this was a good round. I absolutely enjoyed it. Some of you guys argue better than some law students that I've actually met. And the arguments we were making, I was thinking, how did you learn this in high school? Man, for us when we were in high school, we were trying to fight not to be suspended from school. But you guys have done a really good job, and I'm very exceedingly proud of this round, okay? So good luck in your next rounds, and yeah, this court is now...
Other updates to come. This session is done.
Hi everyone. Hello, all the boys in here. I hope we are. Because the carry for round two are ready. And we're about to go. I'm sorry I kept you waiting. I won't next time. It's teams are here now. Okay. Welcome back from the first round. So as usual, coach room number 1. They go down 10-day applicant. Can I say good thing? I think yeah. They go down 10-day. They're not here. They go down 10 days, main answers. Is it there? Okay, so coach number 1, a good 10-day, proceeding as applicants against Chiabuye, respondent. Coach number 1 here. Coach number 2, on the extreme side of this building, Justice Tibatemwa. Yeah, you're proceeding as applicant versus Gaswaga as respondent. Gaswaga. Okay, cool. So, coach number 3, Justice Parishaki. Barishaki. I think that's how I phrase it. Here it is. Where are they? Something over here. Mango, Karimpe. Okay. Barishaki proceeding as applicant against Justice Wamala. Wamala as respondent in coaching number 3. Barishaki against Wamala. Barishaki applicant, Wamala respondent. Coaching number 4, Justice Mubiru. Mubiru. Guys, you code names. I can't keep reminding you all the time. Oh, Mubiru has just arrived. Has my coach checked in? Hold on a second. Justice Muru against as applicant versus Justice Fatima. Justice Fatima? Okay, good. You're in coach room number 4 and the respondent. Coach room number 5, Justice Tisache as applicant against Justice Nagawa. Nagawa? Yeah, cool. So that's coach room number 5. So, the Guardian is not here, Mobiru is not here. Is Wamala here? Wamala is here. So the Guardian day, Mobiru, and the Chinese.
That team for courtroom 3, are you all here? Where is applicant for courtroom 3?
Barishaki is not here.
So courtroom 3 is not
Yeah.
here. Is courtroom 4 closed?
Courtroom 4 is Mobiru versus Fatima. Mobiru has just arrived. Fatima is here, I think. So they can be proceeding.
Fatima, okay, if you're here and you know where you're supposed to go.
Courtroom 3 is LLD, so we're moving to the building. So you go, this is where you are in the morning. So
Good afternoon. I and Martha will be your judges for this round. I just want to confirm the teams. Do we have Team Chiriawiri and Egundantende here? And Team Chiriawiri is applicant. And Egundantende? What's you're the applicant. Yes. What side did you argue in the first round?
Applicants.
So just switch. Did you argue respondent in the first round? Just to confirm, Egundantende is the first speaker called Namirembe and the second speaker Muzaki. Okay, kindly share with us the speaker names. You too. Team Chiriawire, one person please send us the names of the first and second speaker. Same thing for Team Egundantende.
Good afternoon. My name is Kabasinguzi Martha Moyonjere. I'm going to be the chair for this round together with
Harry Mwesigwa.
So the applicants, court is ready. When you're ready, you can start.
May it please this Honorable Court, for purposes of the court's record, my name is Ayenda Axlin, appearing together with Counsel Balukalo Diana on behalf of the applicants in this matter before us. My Lord, we appear before this Honorable Court pursuant to Article 50, Clause 1 of the 1995 Constitution of the Republic of Uganda as amended, as well as Section 3, Subsection 1 and Subsection 7 of the Human Rights Enforcement Act of 2019. My Lord, we have been allocated 20 minutes of this court's time, and I shall use 10 minutes to submit on the merits of issue 1, and my co-counsel will use 7 minutes to submit on the merits of issue 2, and we shall use 3 minutes for our rebuttals. If this gives court a clear roadmap, I beg to proceed. Much obliged, my Lord. My Lord, my issue 1 is on whether the exclusion of learners into alternative classrooms and the additional burden imposed on their families, violates Articles 21, 30, and 35 of the Constitution of Uganda by discriminating against them and denying equal access of education. So, my Lord, I'm going to urge out my issue in 3 limbs. My first limb is whether the exclusion of learners with disabilities and imposition of additional financial burden onto their families violates Article 21. My Lord, Article 21 provides for equality and freedom from discrimination. Also, Persons with Disabilities Act, Section 6, subsection 1, it calls for an institution of learning which enables a learner with disability not to discriminate the learner on the basis of his disability. My Lord, also the legal action for people with disabilities, in the case of the legal action with people with disabilities, Versing Attorney General, case number 146 on 20th May of 2014, it called that if there are measures to be taken in order to limit the fundamental right of a person, they should be demonstrably justifiable and in a free and democratic society. So, my Lord, if you look at the facts, paragraph 9, we see that Grace Nabunya and Samuel Katumba were taken out of their main learning classes and put into alternative classrooms on the basis of their disability. My Lord, the fact that these applicants took a step and took these learners into alternative classrooms, that's already discriminating Article 21, which calls for freedom from discrimination on the basis of your disability. Also, my Lord, we see that when these learners were put in those alternative classrooms, their classmates in the AI-based classrooms began regarding their classroom as a left-behind class. My Lord, that is tormenting, and actually it's torturing, meaning these applicants also very
Council.
Yes.
Question. Are the actions of the students who are calling their fellow students calling their class a left-behind class attributed to the school?
That's obvious, my Lord. What makes up a school are the learners and the teachers at large. So, my Lord, if the learners call their class a left-behind class, that's already showing that they are discriminating it as a whole school.
Council, a follow-up question on that. For there to be a violation, in this case you're claiming it's discrimination, there has to be an obligation assigned to the obligation bearer. So what obligation does the school have in making sure that the students don't call the other students with a disability any derogatory terms?
Much of this, my Lord. From the Persons with Disabilities Act, Section 6, subsection 10, it calls for an institution of learning that enables a learner with a disability to provide the necessities that will help him in his disability. So, my Lord, this school has an obligation to provide what is required for these learners to learn with their learners, to prevent them from calling their fellows a left-behind class.
In this case, what would the school then provide to prevent that?
Much obvious, my Lord. The school would have looked for measures, for example, bringing these learners leaving them in their original classrooms, the AI-based classrooms, but providing interpreters that will help them understand the work of AI in their normal classrooms, prevent their learners, their fellows from calling them a left-behind class.
Okay, Council, let's get practical here. You have a class of 100 students. You have 2 students with visual impairments. You're saying that they are left in this class with interpreters, whilst the other 98 are able to use these AI-based tablets, where, for example, in that room would the interpreters stand because they are not necessary for the rest of the 98 students, and yet you're saying that they are left in these classrooms?
Much obliged, my Lord. According to the Persons with Disabilities Act, Section 6, subsection 1, it calls for an institution of learning that enables a learner with a disability not to discriminate that learner on the basis of their disability. So, my Lord, what do I mean by this? I mean that if that school already enrolled these learners with disabilities, it is meant, okay, they should, yes, the interpreters may not be necessary for these other learners, but here we shall not discriminate these ones just because they are disabled, that we shouldn't provide the teachers for interpretation.
Council, my question is, do you think that there is a duty for the school to teach both learners with disabilities and learners without in the same class? And where is that duty?
Much obliged, my lord. The duty of the teachers is to ensure that every learner gets an equal education, no matter their physical appearance. So if this school has an obligation of making sure that every learner gets an equal education, they are meant to look for ways of making them learn in the same classroom with the able people to ensure that they get equal education.
Council, I don't buy your argument on that. The school would argue that they are placing them in different classrooms so that they are able to give them interpreters or alternative modes of giving whatever basic education it is to them. Leaving them in the same classroom would mean that they are not recognizing their difference.
Much obliged, my lord. That would not be a problem, but the fact that even after placing them in the alternative classrooms, the school decided not to include their results in the overall school statistics, meaning that they still discriminated them. If they had not done that, in the normal learning system, they still included them. But the fact that they took a step and claimed to be providing extra services because of their disabilities, but did not include their results in the overall national rankings, that's discrimination, my lord. So, my lord, to continue, also the imposition of extra financial burdens. This violates Article 30 because we see from the nature of the school that the school, first of all, is government aided. Second, the parents the parents that educate their children from government aided schools are these parents that do not maybe afford private schools, which are expensive. So, my lord, the additional fee, the school claims that in order for these students to get equal education or quality education, the parents are meant to add an extra 1.5 million shillings to the 900 already existing price for the AI tablets. My lord, these families will not be able to get that education. And if they do not get that education, the head teacher claims that if we do not buy the customized AI tablets, the learners are going to remain in the AI classrooms. And if they remain there, that means the students are going to keep on calling them left behind class. And my lord, this can be evidenced by paragraph 8, the second last line. From the facts, it really shows that after them remaining in that class, Grace Nabunya, a visually impaired student, becomes withdrawn, claiming that she feels like a second-class citizen in her own school. My lord, students are vulnerable people. So this would have caused maybe committing a suicide, This is educational discrimination, my lord.
Council, my concern with your argument is that the right to education is a right that can be progressively realized. To that extent, it's not to be fully realized at once, unlike other rights. That is to say that as the school is carrying out this pilot study with the AI tablets, it's given room to experience or to make these mistakes as it realizes the right to education for even children who have any physical impairment. So what's your counter argument to that?
Much obliged, my lord. We see from the Persons with Disabilities Act, section 6, subsection 4, states that an institution that enrolls a learner with a disability and is government aided, it should provide assistive devices, that is to say, screen readers, that will help the learners with disabilities to be able to ascertain their right to education. So, my lord, this school is meant to, yes, a right to education is progressively realized. So, what the school should do in order for it, of course, since they're still realizing it, it should keep these learners in their classrooms with interpreters, with their fellow students, because, my lord, education is only about being in a class, but it's about interaction with peers in an inclusive environment. So, my lord, this school is meant to leave the learners in their original classrooms and provide the necessities for their disabilities in order for it to ascertain their right to education. With that, I beg to yield the floor for my co-counsel.
having heard from my co-counsel, once again for purposes of the court's record, my name is Counsel Baluka Loy Diana, on behalf of the applicants on this matter before us. My Lordship, I've been allocated 7 minutes of this court's time to submit on issue B of this case before us today. My Lord, before I go into the substance and the merits of my issue, I would first want to submit in that the actions of the respondents totally violated the minimality principle, which states that the data collector shall not use or process any data, which states that the data collector shall only use or process or collect data after pertaining consent from the data subject, whereby they tell us it must be specific, it must be informed, it must be freely given, and it must be unambiguous action. My Lord, to head into the merits of my issue, submitting on the issue that whether the compulsory collection of biometric and personal data violated the right to privacy, that is Article 27, which provides right and the right to privacy of all persons, home and other property. My Lord, in this case today, we see that Section 7 and Section 8 should be read in tandem with Section 8 under the Data and Protection Act. My Lord, we see that Section 7 truly provides to us that no person will collect data without consent from the data subject. My Lord, in the same way, we see that Section 8 truly provides to us that no one shall collect data without consent from the parents or any guardian, as long as they're collecting a child's data.
Counsel, are there no exceptions to those provisions?
My Lord, if we are to look in the case law of Bobom Global versus Russia, it provides to us the exceptionals, whereby they tell us if you want to interfere or limit any fundamental right, then you have to meet the legal action, you have to have the legitimate aim, and you have to have the necessary, it must be necessary in a free and democratic society. But my Lord, what do we see in this case? Yes, the respondents may argue that it was legal, maybe according to Article 43, they may say it was legal. But my Lord, in this case, we see that it was not necessary. They are claiming that it was necessary to collect this data. Moreover, my Lord, it was compulsory, according to the issue that I'm submitting on. It was compulsory.
So the collection of that data, wasn't it necessary to provide education to the student?
Much obliged, my Lord. My Lord, according to the facts that we do have in this case today, it is nowhere indicated that there was any circumstance, maybe some war, maybe anything that would forbid them from getting consent. My Lord, therefore on this issue, the respondents have to truly justify that.
On the issue of consent, you cited that consent is supposed to be unambiguous. However, within Section 2 of the Data Protection and Privacy Act, consent may also be collected if it is an affirmative action. And my question is, don't you think that the act of the parents of purchasing these tablets, because they were being purchased by the parents on behalf of the students, don't you think that that qualifies as an affirmative action that shows that the parents consented?
In addition, just in the same to his question, the parents admit and sign certain forms for the children to be admitted in the school. The school's obligation is to provide the best education that it possibly can, which includes these tablets that are required for students to learn. So, like he said, it's actually an affirmative action that they've given this consent for that data to be collected to monitor the students' learning. So I don't see any problem with that, and it seems necessary to me for this information to actually be collected.
Much obliged, my lordship. On the first question of my lord about the affirmative action, my lord, I still stand on my point that there was no consent, and for a reason that, my lord, yes, we agree that the parents bought the tablets and everything, but if we are to look at the facts, that is paragraph 6A, we truly see that there were rumors that were spreading that this information was stored on servers outside Uganda.
Exactly, are those rumors proven in any way?
Much obliged, my lord. My lord, according to Article 50 of the Constitution of Uganda, 1995 as amended, it truly tells us that if at all you feel like your right is being threatened, then you have the right to go into the substantive court and report this. My lord, that is where we stand and say that we feel our rights are being violated.
So, Council, is your claim of violation at the point of hearing the rumors or at the point of actually giving in the data?
My lord, I was still coming on that very issue. So, on that very issue that rumors were spreading, that truly shows, that something truly shows that yes, even though these parents bought the tablets, according to the definition of consent in section 2 under the Data Protection and Privacy Act, it must tell us that yes, it must be specific. Why do you want me to buy this? What are you going to use it for? Where is my data going to be as in kept? But these rumors themselves justify that they never gave these people the specific information, because these rumors weren't going to be there if at all they knew that yes, our data is stored in this and this. But these rumors themselves justify the fact that this information was not specific.
So no alarm came from the parents at the point of buying. It only came after.
Much obliged, my lord. We believe that this
is... And it came not because of the lack of consent, but because of the prices, right?
Much obliged, my lord. We well know that this is a government-aided school. Once a parent takes a step and takes their child to a government-aided school, then it truly shows. My lord, I see my time is up. I beg for a few minutes. We see that. Yeah. Thank you so much. We see that this is a government-aided school, and by the time I take my student to a government-aided school, then I truly cannot afford. So anything that will come up, maybe they're saying this and this and that. Since I want to truly try my level best in this government-aided school to at least show that, yeah, I'm doing some good standards for my child, of course I'll have to buy the tablets. And we know that in most cases, these parents who take their children to government-aided school, they're not that much educated. So anything that will come up, they will just submit in. And even these, the respondents will see maybe because of illiterate, they won't give them the specific information they're meant to get. They will just buy because it is for the sake. My lord, on the second issue about the rules and regulation, I still stand that there was no consent, my lord. If it comes to the right to privacy, there are no negotiations in this matter. This is my privacy that is truly accounted for in the Constitution of Uganda. My lord, in this very court, I would love to set up a rhetoric question. Should we rather throw up the constitution that was put to govern this country and follow the rights that have, the rules and regulations that have been put up by just a school? Should they step on my rights because I've maybe put in consent on the rights and regulations of my school? Now if one day they come up and they say, you know what, tomorrow morning we are all moving naked. Just because I consented, does it mean I don't have a right to come to this court and give in my case? I'm like, no, my rights have been violated. So my lord, I therefore submit in that no consent was got from the data subject, and I stand on that. As I conclude, my lord, I pray that this court may count the respondents guilty for violating Article 27 and what my pre-counsel has submitted. Thank you so much.
So the respondents, you have 2 extra minutes. Kindly allocate and distribute that in your time.
My lords, I'm very much obliged. My name is Yiga Eric, and I will be presenting alongside my co-counsel, Ramon Asmero. We are here today to represent the respondent in this case, which is Nakaseke Bright Future Secondary School. My obligation within 11 minutes of this court's honorable time is to submit on issue A, and within 11 minutes still of this court's honorable time, my co-counsel will present on issue B as well as say our prayers. If I may, my lords, I would like to present my opening statement. Your Lordship, what stands before this court is not injustice. It's a difficult balance between rights and responsibilities. This is not a case about neglect. It's a case about Nakaseke Bright Future doing its best within its limited resources to actually see that every child gets the best. My lords, I'm going to be addressing whether the measures put in place for these disabled students, including their separation into alternative classes, as well as the option of specialized devices, represent reasonable accommodation and progressive realization within the school's financial and technical limits. My lord, as the respondents in this case, we contend that they indeed do. And under that, I have 2 heads of argument. The first about progressive realization, and second about reasonable accommodation within the school's technical limits. My lords, if I may, I would like to move on to submit on my first head of argument. My lords, the principle of progressive realization is enriched in the human rights. The principle of progressive realization is enriched in the Human Rights Act, Section 13, as well as Article 2, Clause 1 of the International Covenant on Economic, Social, and Cultural Rights. I read alongside the case of Sehad and others versus Mulago Hospital. It is stipulated under Article 2, Clause 1 of the ICESA that state parties might not achieve everything right away, but must continually improve conditions given their resources. Secondly, it states that they must do what they realistically can. My lords, as presented in the facts, in particular, paragraphs 1, 2, and 4. Nakaseke Bright Future is a government-aided school with very limited resources. However, it embraces this pilot project to be able to improve gradually and continually the conditions of education within their limits as a government-aided school. They embrace this project that ends up bringing a 46% increase in performance within just 2 years of introduction. That is from 2022 when the pass rate was 21% to 2024.
Councillor Eric, from what I got from the applicant's submission, their argument is not on the right to education, mainly, which firstly I appreciate that you quote for us the ICESA, and my extended assumption is that you're also aware of the ICCPR, the difference between the rights provided for in the ICCPR, which are political rights, including the right to freedom from discrimination, which is not a right that can be progressively realized. So their argument is on the discrimination that is being faced by a certain number of students while they are getting the right to education, not on the right to education.
Very much obliged, my lord. That issue actually brings me to my second head of argument, which I'll address as soon as I tie up at head of argument number 1.
No, go straight to that.
Very much obliged, my lord. My second head of argument in today's case is the existence of measures of reasonable accommodation. According to Article 2 of the Convention on Rights of Persons with Disabilities, reasonable accommodation shall not impose disproportionately on the provider, despite the fact that they have the obligation to provide it. What does that mean? That means that in as much as you have the obligation to accommodate these disabled students, it shall not impose disproportionately on you. What does this mean? According to General Comment number 6 on equality and non-discrimination by the Committee on Rights of Persons with Disabilities, a 4-part test is presented of what reasonable accommodation is actually supposed to look like. The first element of this part test is that it should be interactive and flexible. Secondly is that it should be individualized. Third is that it should be timely. But fourth and most important in today's case is that it should be proportionate. Proportionality means that in as much as it needs to fulfill the needs of the person being affected, it must fall within the provider's capacity.
In terms of proportionality, Council, and what you've just submitted on, these are 2 students, right?
Yes.
Who are persons with disabilities. These 2 students, according to the facts, only require tablets of about 1.5, the extra 1.5. 1.5 times 2 is 3 million. Yeah. Are you saying that that is an amount that your school cannot meet and that would disproportionately affect its financial standing? Is that your argument?
Very much obliged.
As you answer that question, in relation to the requirement of it being interactive, right?
Yes.
Paragraph 9 of the facts. The students are provided with outdated study material in comparison with the rest of the students who are getting updated material with these AI tablets. Is outdated material still interactive? Does it fully provide for their right to education?
Still on it being individualistic, yeah? We have Grace Nawenya, student, who is saying that she's disproportionately affected, her mental health is affected, she feels downcast and all that. Was she consulted in any way before this measure was brought to her? Do you think that her views were taken into account to tailor a response that is suited to her needs?
Very much obliged, my lord. I'll proceed to answer the questions that have been presented. On the first issue from your lordship, was the 1.5 times 2 something the school couldn't afford? Your lordship, we need to put into account what a government-aided school actually looks like. We need to characterize, we need to picture what life in such a school looks like. What life in a school with a 21% previous rate actually looks like. Such schools often have trouble paying teachers, and mind you, teachers in such schools receive pay as low as 200,000. These are schools whereby there are very few teachers. These are schools whereby feeding the children is a struggle. Your lordship, we think that 3 million is indeed a very high cost for this school to pay. And there is need for parents of these particular children to collaborate the school and actually try to come up with a reasonable solution to accommodate these children better. Secondly, on the issue of being individualized, these are people that were taken to separate classes. Taking them to separate classes is not to discriminate them. It's to see that they are best taken care of. The issue of outdated books is not something that's very pressing in today's case. What do I mean? I mean that outdated books are just like an extra that was added onto these tablets that they were actually given. What does it mean when they are put into alternative classes? It means that they are going to use the same tablets as their peers in the separate classes, but they are going to have interpreters within these other classes. They're going to have people to show them what to do, people to interpret them, people to take care of them. We think that they are best taken care of, and the issue of outdated books is not very big, because at the end of the day, they are just a supplement to the main method of teaching these people, which is the AI tablets. Third on that.
Council.
Yes.
I appreciate that you mentioned that the 3 million is a disproportionate amount to put on the school. Wouldn't the applicant then argue that it's equally a disproportionate amount? While 3 million is a disproportionate amount to put on an institution, imagine how much more disproportionate it is to place on an individual parent.
Your Lordship, I acknowledge the fact that it may be disproportionate, but we see that the school is putting into place measures of progressive realization to see that at the end of the day, these children are brought up to speed right away. Putting them into separate classes is just a temporary option that can be solved if these parents pay the 1.5 million. However, it's not compulsory, and as indicated in paragraph 9 of the facts, the head teacher confirms that they are looking at options to outsource more specialized tablets for these disabled students to be able to accommodate them better. Maybe even take them back so that they study at the same level of these children, of their peers who are within these classes and are able. We think that it fits within the measures of progressive realization and reasonable accommodation.
Council, on that argument of progressive realization, she submitted to you and she asked you a question that non-discrimination is an immediate obligation. It's not subject to progressive realization. Don't you think that your measures were discriminatory, and on that ground alone this court should find you in violation?
My Lord, I'm very much obliged. We
specifically address us on the issue of not including them in the national rankings.
Very much obliged, my Lord. Very much obliged, my Lord. We contend that the issue of separation into alternative classes is not to discriminate them. It's to provide better for them within the financial and technical limits of the school. We contend that it's more reasonable than leaving them in a class whereby they are going to be laughed at and mocked by their peers.
Agent, and sorry for taking up your time. Please add that minute on your rebuttal time. Is the effectiveness of a measure weighed on what it's supposed to do or on its result? Because if a measure's effectiveness is weighed on its result, your action of putting students in an alternative class did not in fact yield the result that it was supposed to yield, and to that extent the court would be more inclined to find you in violation unless you convince us otherwise.
I'm very much obliged, Your Lordship.
Because as you're answering her question, it looks like you are setting up these students to fail and you expect them to fail. And that's why you don't want to include their results in the national rankings. Yeah. Do you really think you're providing the inclusive education that the PWD Act envisages? So answer those questions in sequence and then you can proceed.
Your Lordship, on the issue of setting up these children to fail, we contend that even under normal circumstances, even in the traditional setting of books with no disparity between abled and disabled, disabled students come off as low performing. They are low. Your Lordship, as seen in various UNEB results, it is often seen that students that are maybe blind, that are maybe have handicaps, they are unable to write properly, have a certain disadvantage. That disadvantage amounts to, that disadvantage that is proportionate to their results. That means that if you put a class of 100 students that are able into a classroom and a class of 100 students that are disabled into a classroom, statistics show that these students that are able will perform better. Not because... No. No, my lord, I'm not contending that. What I'm saying is that their expected low performance is not because of the poor teaching measures. The school has tried as much as possible to be fair to everyone. However, some things just can't be denied. They just can't be ignored. The disadvantage they have because they are disabled can't be ignored. On to the second issue about removing their results from the national rankings. We need to realize that this is a pilot project. That means that we are testing it out on this school and we want to see the results so that we move it across the country to attain the benefits we have attained with it here in Nakaseke Bright Future Secondary School. That means that the national track record matters a lot for the benefit of the whole country in general. We contend therefore, my lords, that it was necessary for the benefit of the greater good of the whole nation as a whole. It wasn't done to discriminate against these disabled students. If I may be of no further indulgence, your lordship, I seek leave to yield the floor to my co-counsel.
Much obliged, my lords. My name is Hermon Asmara, second speaker, second counsel for the respondent. I'll be using 11 minutes to address issue B. Before, I seek leave of court to make my opening statement. My lord, we have been always told to fear fire. However, it's from fire that we are able to see gold's finest. Similarly, data isn't a hidden camera in the classroom for us to fear, but rather it's a map that shows us where students are getting lost and how we can guide them on the right path. My lord, I'll be handling issue B that states whether the data collection is lawful, necessary, proportionate, and serves legitimate aims such as promoting education, safety, and preventing malpractice. My lord, the counsel for the respondent indeed submits it was lawful, necessary, and proportionate. My lord, I submit this under two heads of argument. A, the right to privacy isn't absolute, and B, this passes the permissible limitation test. My lord, I proceed to my first head of argument. Under Article 27 of the Constitution of Uganda, that protects the right of people, which our applicants say that it has been violated, this is, however, read alongside Article 43, Clause 2C, that says, any limitation shall not be beyond what is acceptable and demonstrably justified in a free and democratic society. This is also further evidenced in a law case of Charles Onyango, Oboa and Amor versus Attorney General under the Constitutional Appeal 2 of 2002. My lord, this is evidenced in our facts that Nakaseke, which exists in Uganda, that is a democratic society, follows this, but then also too, this was done for the evidence of the attendance of the children in classes. But then also...
Counsel, is it your submission that before these tablets were brought to the school had no way of tracking attendance? And to that extent, is it therefore a necessary step to take to is it a necessary step in any case? Because if you argue attendance, it's saying that the school had no tracking attendance of students and performance before, which is not true.
Much obliged, my lord. This is evidenced in paragraph 1 that says that Nakaseke had high school dropouts and poor performance at 21%. So this shows that attendance tracking is something that could have caused to a poor performance. My lord, I proceed to say then further, this is shown still in paragraph 4 that this performance then increased to 67%. This is something that is very important to the school. My lord, I proceed to our second head of argument, that is, it passes the permissible limitation test. And this is under 3 heads. It's a 3-part test. A, lawful, B, necessity, and 3, proportionality. Under lawful.
Yeah, as you're addressing us on the lawful argument, tell us, did the school have to obtain consent? And if not, what are the necessary exceptions under the law?
My lord, the school in this scenario did not attain consent. However, under section 7, subsection 2B of the Data and Protection and Privacy Act, it says that this can be done by a public body for a public good. And this is further evidenced in paragraph 2A, which shows that the Ministry of Education was doing it in order to improve on the education of the school.
Section 7 and the exceptions that fall there under are general provisions. I think the more important provision is section 8, which specifically speaks about personal data relating to children. And under section 8, the only exception is either it's necessary to comply with the law or it is necessary for research and statistical purposes. Do you think those exceptions fall into what the school did?
Yes, it does. This was a pilot study, so that means it was for research. But then also, secondly, it passed through the permissible limitation test. My lord, I proceed to my argument. Under the Syracuse principles, that is, the right to privacy may be limited. However, if it's lawful, necessary, legitimate, and proportional, then it passes the test. And in this scenario, from the paragraph 2, we see that this indeed passes. To my next principle, that is necessity. This simply means that it's needed to achieve a legitimate aim. We see that the legitimate aim here was education. My lord, under section 7.
A few minutes ago, you submitted that the legitimate aim or the purpose was research. Was it research or education?
My lord, in this case, we have different issues at hand, and research is part of education. So I think we submit that both of them are entangled. My lord, I proceed to say that under section 7, subsection 2 of the Data Protection and Privacy Act, it says that no data is to be collected unless authorized by law. And we see that this is the Ministry of Education, therefore it has been authorized by law. My lord, under general comment number 25 on children's rights in relation to the digital environment by the Committee on the Rights of the Child, paragraph 67, it says that children's personal data are processed to offer educational, health, and other benefits to them. And in this, it's evidenced in paragraph 1 and 4, where it was needed to improve on their performance. When our applicants ask, was this necessary? My lord, yes, indeed, it was necessary, because it was used to monitor attendance, to improve on their education, and to do research. My lord?
Let's go to the third test of proportionality.
Yes, my lord.
Your school collected fingerprint data, they collected facial data and scans, they collected biometric and all other sorts of information that I think would go against the minimality principle. Do you really think it was proportionate to achieve your objectives of research and education? In other words, was it the least restrictive means or the least restrictive data collected?
And Council, while you're answering that, paragraph 6B of the facts, the impact that these AI tablets actually had on the students, with them being able to predict their future and limiting children with the predictions that they give, does that still fall within the criteria that you set out?
Thank you, my lords. Much obliged. to the first question of proportionality, I was heading to that. That's the third principle. It says that the benefits gained must outweigh the harm achieved. And this is under Article 17 of the International Covenant on Civil and Political Rights under the Syracuse Principles. It states that it shall not be excessive or arbitrary. And this is then definitely proportional. And still under paragraph 10, we see that this wasn't violated. Therefore, my lord, I still further quote from General Comment 27 on the Human Rights Committee. It says, it must be respected not only by law that frames restriction, but also in application. Therefore, in this case, my lord, we see that it was proportionate in order to have the better future for the majority.
You see, you've quoted for us the law, but you've not really applied it. Yeah. And my question is one of application and engaging with the facts. We have a school that is collecting excessive data, more than is necessary, yeah, to achieve an aim. And my question is, did your school use the least restrictive means necessary in this instance? Did you need biometric data? Did you need facial scans? Did you need fingerprints? Did you need all that? Voice recordings and all that to achieve your objectives that you've spoken about?
Much obliged, my lord. We submit that education is a key aspect for these children. Furthermore, having the fingerprints, the voice recordings was the best means for them to have their performance improved. We believe this was right because we see in paragraph 4 that the performance increased to 67 just in a short period. Therefore, it's proportionate. Moving to your next question, my lord, of the predictions. My lord, it says in paragraph 2 that this was a pilot survey. So, therefore, this was just for a short period of time. But then too, we cannot ignore the benefits and only look at the harms. Meaning, under the predictions, it also tells the students whether their future is going to be bright. For those whose future is going to be bright, they will definitely be motivated to keep working hard. Therefore, the predictions had benefits.
Council, we are having sacrificial lambs of certain students, give them away for the purposes of research. Is that your admission?
My lord, if majority versus minority is to win, then we think would rather go with that 2% being sacrificed since this is a pilot survey.
But isn't the Constitution supposed to protect the rights of minorities?
Yes, my lord, much obliged. However, most of them pass through the permissible limitation test. My lord, I proceed to make our case prayer. We therefore pray that this court to make a finding that the data collection is lawful, proportionate, and necessary. My lord, as the second counsel, I make our final prayers. My lord, the respondent prays that this honorable court, 1, declares the respondent's collection of biometric and personal data of students was lawful, legitimate, and constitutionally permissible. But secondly, dismiss the applicant's petition in its entirety with costs. And 3, affirm that educational institutions in implementing reasonable and proportionate digital systems act within the permissible limitation test of rights to safeguard students and maintain accountability. We so pray, my lords.
Much obliged, my lord. I raise on behalf of both the councils for the applicants to provide us submissions on the rebuttals from the respondents' case. So, my lord, to begin with, the respondents claim that the segregation or the putting of these students in alternative classrooms was an accommodative measure for a reasonable accommodation. But, my lord, this measure fails all the three of the proportionality test, and my lord, we know that the proportionality test is accumulative. If you fail one, the whole test becomes invalid. So, my lord, the first one is that the measure should be able to meet the objective in the question. And my lord, the measure is that every child should receive a right to education. But what do we see here? When these learners were put in alternative classrooms and taught with outdated textbooks, with AI-generated materials, still their results were not included in the overall national rankings. And still, the respondents stand up here and claim that the persons with disabilities are usually poor performers. But my lord, let's put this in real life. If you look at my school I come from, we do have a lot of disabled students. But my lord, what they say is totally wrong, because the students at my school, literally the disabled are way better than these normal people. Which means that we should also look at them getting their right to education. They should, these respondents violate, actually their actions violate Article 30 of the Constitution of Uganda as amended. It states that every person has a right to equal education. So if you put these people in this room and you do not include their results in national rankings, is that education, my lord? My lord, proceeding to the other test, the other test of the proportionality test is that it should not be unfair. My lord, taking these students in alternative classrooms, that's already unfair. That's already violating Articles 21, which they claim that they did not violate. So my lord, continuing, the third test provides that its impact should not be beyond what can be taken. But my lord, what does this cause? After them being put in alternative classrooms, the students feel withdrawn. For example, Grace Navunya, she feels withdrawn. And my lord, there's no way you can study when you're feeling withdrawn. That's all the stigmatization. And also, they respondents claim that from the facts which shows that many students were dropping out of school was because they were not monitored. And they claim that once you embrace the AI learning system, you're going to monitor the students, you're going to know their attendance, and that's preventing what? School dropouts. But my lord, that's not evidenced anywhere. Even in real life, even though they take roll calls every morning, we still see learners dropping out of school. This is not because they're not using AI-powered tablets. It is from their hearts. So my lord, I think that them claiming that the AI tablets taking the personal data is going to prevent school dropouts is not correct. That's violating Articles. They claim that this will violate Article 43 of the Ugandan Constitution. But my lord, if you look at Article 44 of the Uganda Constitution, which provides for the regable rights, and they claim that if you keep taking, if you take these students, Grace Nabunya and Samuel Katumba, in alternative classrooms, that you're providing a right to education, yet in real sense they are not. My lord, we go to school to learn, and in the soul learning, we expect ourselves to be given assessments. And if you give me assessments and you not include me in the school's overall statistics, am I learning? Also, my lord, continuing, they continue and claim that they claim that the benefits gained were what? Were they underweighed the problems, because, my lord, this is not true. Because from the facts itself, we see that after them bringing the AI-powered tablets, or even collecting the private data, it was against toward outside countries. Isn't that threatening national security? How sure are we of the security of the country where you put your storing my information? I beg for 1 minute to conclude. As obliged, my lord. With that, we therefore humbly affirm that the segregation of applicants violated Articles 21 and 30. Also, the disclosure of their disabilities by singling them outside because of their disabilities into alternative classrooms violates Articles 24 and 27. It also violates the affirmative action, because the affirmative action calls for favoring these students. My lord, taking them out of class is not favoring them. That means they violated. So we pray that this honorable court finds the respondents' defenses unsustainable and upholds the applicant's prayers in full. Therefore, as I conclude, I pray that the respondents may be found guilty for violating the law, and also they should compensate for the applicants. We pray that they may compensate 30 million to ascertain the damages caused, because one, our respondents were stigmatized, and mental treatment is expensive. So we are saying thank you to that. With that, I beg to rest.
Okay, thank you so much for that amazing round. I'm going to give general feedback, so I won't necessarily focus on a specific team. But what I can say is that it was a good round. You guys had the art of persuasiveness. You endeavored to use the law well and to try to use the facts to your advantage for both sides. I'm going to keep this brief because we have another round, but in terms of areas of improvement that I can note and that I can speak about is that every time the judges ask you a question, try to take wind of the direction that they are trying to give you, and try to go there and use that to your advantage, because many times questions are not to throw you off balance. Questions are just for you to clarify. Secondly, try to see, especially when you're making arguments about limitation of rights, etc., try to see how you balance all interests and not make what can be termed as an immoral argument. Yeah, that basically it's better maybe for us as long as we are getting a benefit, etc. Usually in human rights, it's not just about the benefit that you receive, but it's about a measure that tries to be holistic, and it takes the approach of upholding the rights of everyone, not just the rights of a particular group. Another thing I can say is that in the successive rounds, as you are selecting your sources, try to see which sources are better to use first. In other words, the hierarchy of laws. You can start with Ugandan sources first and just hint on them to show that they are also relevant before you go to international sources or vice versa. So try to see how to buttress. Both sides are important, so one should not be ignored to the benefit of the other. That's what I can say. Otherwise, it was an amazing round. Thank you so much, and I wish you the best in the next round.
So I would like to thank the participants for giving us a very impressive round. I can confirm that the way all of you, with no exception, presented is equal, if not better, to the way some university students present their cases during Moots. And that's extremely exceptional. I would like to give, I think, a little feedback on what can be improved in successive rounds and successive competitions that you will take part in, especially in the human rights space when dealing with persons living with disabilities. Try as much as you can to avoid certain wording like normal, abnormal, that may come off as insensitive. So try to put that in your submissions. Then, of course, when asked questions, just follow that direction. Don't try to persist that I was going to submit this. In most cases, the judges have had these arguments over and over. If they're asking you a question, it's because they want you to drive a certain point home. It's usually for your benefit. If not always, it's always for your benefit. Thirdly, And lastly is on rebuttals. And this is not directed to the applicant team. You did extremely well, but I know that in successive rounds, you may be applicants, you may be respondents. So try to, one, in rebuttal, rebut what has been raised by the respondent team and what do you think is the most contentious part basing on the questions that the judges have asked. What do you think that the judges asked the respondents that they haven't clearly responded to that you can take advantage of to win the argument? And then also not to raise, obviously, new points in your rebuttal. The same applies to any respondent team. Respond. We understand that you have your structured arguments that you've come with, but you'll meet an applicant team whose arguments will completely not be in line with the arguments that you've prepared. So respond. So for example, if the applicants raised point A, address the court and mention that whilst the applicants mention this, our submission and the legal provisions provide A, B, C, and D, not coming with a new argument that's not responding to what the applicants raised. Other than that, I think you did extremely well, and I can't wait to what each of you will become in the next few years. I'm extremely impressed.
Some patrons are going to be in the room where they had their breakfast. Let us have our tea break in the cafeteria. But we are let's go in the guys.
Oh,
no, yeah.
So the jury, I'm going to do this. Okay,
Oh, yeah. Yeah, take turns.
I'm like this.
I'm saying behind there.
Yeah, you're allowed. Yeah.
Yeah. Firstly.
Hello everyone, good afternoon. So the breaks are in, but first we'll have a communication. Harry, and then
Okay. Hi guys.
Hi guys, can you hear me? Yes. Okay, how are the rounds? Okay, so he's going to announce the breaks, but before he does that, I just have a few administrative issues to pass. So we are breaking to quarterfinals. That means 8 teams. So we are dropping 2 teams, quarters, then semis, then finals. So this is what we are going to do. As you notice, we have lunch waiting, and we also have time issues, right? It is coming at 4. So this is what we are going to do. Once the quarterfinal breaks are announced at the rooms, the teams that are breaking immediately go to your rooms. Yes? The teams that have not broken, you are allowed to watch in your room. Yeah? So the rule about scouting no longer applies to you if you're out of the competition. That's number 1. Number 2 is that immediately after the quarterfinals, let us all come here. Yes? When we come back here, we are going to have a group photo. Yeah, because we see the sun is leaving, setting. So we are going to have a group photo with the officials on those stairs. After a brief group photo, we shall come back to this room, and then he's going to announce the semi-final breaking teams. When the semi-final breaking teams are announced, the semi-final breaking teams will immediately be the first to go and have lunch together with the judges and the patrons. Yes? Immediately after they have had lunch, they will move directly to their rooms. Because we will announce the breaks and the crew. We are going to give you a time within which we expect you to be done with lunch as a semi-final team. And then after, you will move to the rooms and have the rounds. Yeah? We are doing this so that we can save time and we can all leave this place early. Is my communication clear? Yes. Immediately after the semi-finals, come back here and we shall have the finals. Yeah? Yes. Okay.
Are the finals going to take place here?
Yes, the finals are going to take place in this room.
Okay, guys. So one. Hello, everyone. Once again. Okay, I will do 5 past. So I'll announce the break. That is from number 1 to number 8, and then also tell you the pairing for the next round. Okay. So breaking in position number 1 with 367 points from the 2 rounds and 2 wins in each of those rounds is Team Egonda Ntende. Breaking in position number 2 with 348.5, still 2 wins, Justice Chisache. Number 3 with 319 points, still 2 wins, Justice Nagawa. Number 4 with 314.5, still 2 wins, it's Justice Chia Wile. Number 5 with 307.5, Justice Barishaki. Number 6 with 299.5, Justice Gaswaga. Number 7 with 295.5, Justice Batema. And lastly but not least, 291.5 points from the 2 rounds, Justice Tibatema. Yeah. So for each of those things, if I read your team name, you send a representative and they'll come and pick lots for which side they'll be on for this time round, and then we can proceed to our room. So for the first room, courtroom number 1, which is this one, we'll have Egonda Ntende and Tibatema.
So one representative from each team.
Egonda Ntende and Tibatema.
Pick from one of these and then you tell us the size. Respondent.
Which one? What is
So this team has
This room has intendant Tibatima, right? In this room, eh? Intendant is applicant?
Next up, Chisache and Batima. Chisache and Batima. Chisache. That means Batima is applicant. Nagawa and Gaswaga. They're not for this. Oh, sorry. Nagawa and Gaswaga.
Hello? Hello?
So, Egonatende is applicant, Tibatema is respondent in this room, courtroom number 1. Courtroom number 2, Batema is applicant and Tisachi is respondent. Courtroom number 2 is on the other end, near where you're having breakfast from. In courtroom number 3, Nagawa is applicant and Gaswaga is respondent. Courtroom number 3 is on the other block when you go out of this building. And then courtroom number 4, we have Chiawiye as applicant and Barishaki as respondent. Courtroom number 4 is down.
The lower, yeah, that room down there. Right, so the rounds begin in.
The judges are already there.
The judges are already waiting. So please move to your rooms. By 15:25, that's 2 minutes from now, the rounds will begin. All the best.
Hello? 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 Does this mic work?
Yeah, it does, I think. They were using it. Try it.
Hello?
Hello, hello. They were what? You have buttons.
Yeah?
Do you have buttons?
Yes, me I have.
Ah, that's good.
Hello? Please write down your names and the teams, and write down the names in order of what? Speaking, okay? Number 1, number 2, right? I have. So it is 15:27 East African time. So we shall be starting at 15:30 East African time. So I've given you 3 minutes to settle down and also give me a list of your names. As we wait for my colleague and the bailiff, thank you so much. So at 15:30 East African time, the applicant will step forward and begin their case. Bailiff, please confirm with the second judge. Her name is, please confirm, eh? So it's 1 minute to 15:30, but once you see my second judge walk in, if she gets seated, then you can start. Is that okay? Thank you. For the audience, this is an academic session, so I won't be harsh on you, that side, but it's advisable you remain as quiet and calm as possible to enable your colleagues engage in this process. You're allowed to be happy, but you're not allowed to scream or get excited or clap your hands. If you feel happy, you can pass a note to your colleague about something, but there's no need for a reaction. Over and above, we're excited to have all of you here, and I hope this process will be fulfilling for you and educative. So, wait to start, because sweet, get us 2 ballots. 2 ballots. Okay. So we are joined by my colleague. For these purposes, my name is, for these purposes, Justice Nasa Konde, and I'll be presiding over the High Court of Uganda. Next to me is my learned sister, Justice Martha Kabasinguzi. Once the bailiff sits down, he'll call the session to order, and then we will start. I personally wish all teams the best of luck, and see you on the other side. I hope you know how to use the microphones.
Yes.
You press to mute, to pause, then you press again to speak. Is that okay?
Yeah.
Thank
Am I
you.
clear? Am I Am I clear?
You're now audible. Counsel, you can start.
Your Lordship, may it please the court. My name is Iga Eric, alongside my co-counsel, Herman Asmerom, and we are here today to represent the applicant in today's case, and that is Grace Nambuya and Samuel Katumba.
Counsel, please use the other microphone. It's much better. The other one. Yes.
So, use this microphone.
It's on.
Your Lordship, Your Lordship, may it please the court. My name is Ziga Eric, and alongside my co-counsel Herman Asmerom, we are here today, we appear in court today to represent the applicants, Grace Nambuya and Samuel Katumba. Your Lordship, within 10 minutes of this court's honorable time, I'll be addressing issue number 1 in today's case, and within 9 minutes of this court's honorable time, my co-counsel will be addressing the second issues as well as saying our prayers. My lords, before I proceed to make my presentation...
Counsel, do you have a right to make a rebuttal?
Pardon?
Do you have a right to make a rebuttal?
My apologies, my lord. We will reserve 1 minute for rebuttals. My lords, before I present my case, I seek leave of court to make my opening statement.
Proceed.
In a world that should have embraced their disabilities, these children were punished for it. This is a case of justice for those whose only crime was being disabled. My lords, the issue I'm obligated to address today is whether the exclusion of children into separate classes called alternative classes and the financial burden imposed onto their families violates Articles 21, 30 and 35 of the Constitution of the Republic of Uganda and directly amounts to discrimination and denies them equal access to education. The applicant submits that it is indeed a violation of the above stated laws. The applicant therefore makes 2 heads of argument to address the above stated issue. The first about the right to education, but secondly also about the right to equality and freedom from discrimination. My lords, I will proceed to the first head of argument from the applicant side, the right to education. This principle is enriched first of all in Article 20, Clause 1 of the Constitution of the Republic of Uganda, as well as in Article 30 of the Republic of the Constitution of the Republic of Uganda, read alongside Article 13 of the International Covenant on Economic, Social and Cultural Rights as interpreted under General Comment number 13, paragraph 6 to be exact, by the Committee on Economic, Social and Cultural Rights, which provides a 4-part test of what education should look like. The first test is availability. The second test is accessibility. The third test is acceptability. And lastly, adaptability. Accessibility means that education should be physically and economically accessible to each and every individual without discrimination.
Counsel, does accessibility encompass free education?
Very much obliged. Yes, it does. Yes, my lord.
Counsel, does the right to education include the right to free education or the right to affordable education?
My lords, the accessibility element of the 4-part test includes right to education that's economically and physically accessible. Under economic accessibility, that includes things that it should be affordable, but also, if need be, it should be free because everyone has a right to education. If I may proceed.
What level is education supposed to be free as a must? Or to make it a bit easier, between primary and secondary education, which one is supposed to be free?
My lord, we contend that education that's essential, education that everyone has a right to, is primary education and secondary education. There is no value, there is no measure of value to what education should be free and what education shouldn't. We contend that education in all its forms is supposed to be
a government that's progressively realizing this right. It's set to choose between providing completely free primary education or completely free secondary education, and one of them has to be subsidized.
Which of the two would the applicant rather have?
The applicant would rather have primary education because it's more essential. However, in case the government is able to, it's supposed to progressively realize secondary education as well, because education is a very crucial part of development and is a human right provided for under the Universal Declaration of Human Rights, and we contend that it's very important.
Proceed.
My lords, I was still explaining the tests of limitation of what education should actually look like. We look at adaptability, which basically stipulates that methods used in educating should be flexible to the needs of diverse learners and changing societies. Evidence of violation of these elements of the 4-part test is in paragraphs 8, 9, and 10 of the facts. First of all, there is a financial burden imposed onto parents that actually their children should pay an extra 1.5 million for their students to actually.
Council, just to take you back to your previous argument and in line with the argument that you're trying to make, the government has supposedly provided free primary education and at secondary level subsidized the same and only required parents to pay an additional fee to enable that students get quality education. Wouldn't the school or the government argue that they have in fact fulfilled their obligation to that extent?
Your Lordship, I'm very much obliged. To answer your question, part test number 12, element number 2 of this part test states that education should be physically, economically accessible to everyone without discrimination. By excluding some students from class because their parents can't afford tablets, we contend that this is a violation of the non-discrimination element of this part test, and we have reason to believe that this is in violation of the law, and therefore the respondent should be held accountable.
The respondent would then argue that they have firstly provided alternative classes and not fully excluded or even excluded enrollment of students with disabilities. They have been enrolled and when need arose provided alternative classes with special attention from the teachers and other supportive educational material. To that extent, they would then argue that they have satisfied the test of them being physically and economically accessible.
Your Lordship, if I may, when you look at the facts, particularly in paragraph 9, these children are taught with AI tablets and outdated books. There is need for equality when we are providing the right to education. Rights are inherent, universal, and independent according to Article 20, Clause 1 of the Constitution of Uganda.
Council, before you go there, how do you want this court to determine if we have created an appropriate balance in terms of discrimination? Should we look at a numbers game or we look at a quality game? For example, if 1,000 students are able to access education and 2 miss out, but that education that is missed out is on average quality. So do we look at the quality that is missing out or do we look at the numbers? So how do we strike the balance between 1,000 and 2 or between the aspect of the education has to work for everyone?
Your Lordship, there is no sacrifice in human rights. Everyone is entitled to human rights and they should have equal access to these particular human rights. If you say that we shall provide quality education for 1,000 and leave out the 2, it's not fair because you're violating these people's rights. You're making them feel unsafe in a society that is supposed to be their own. You're leaving them out, and as applicant, we contend that these 2 shouldn't be left out. If we are providing quality education, we should provide quality education for everyone, and if some people are going to be left behind, there should be measures of reasonable accommodation to put them at the same level as their peers that have an advantage.
Council, paragraph 8, and given the fact that you submitted that it's in fact a right that can be progressively realized, The head teacher of the school has confirmed that the lack of immediate funds to provide this and only required parents to chip in a little bit to help with this. I don't see how the school is in violation of providing access. In any case, they have provided the AI-generated material and even bothered to make it hard copy for the children who have any impairments to be able to access this. I'm finding it hard to believe that we should find the school in any violation.
To add to my learned sister, what can be the bare minimum in your view in terms of what the quality looks like? What is the baseline or the below mark, below which we shouldn't accept anything to go?
Your Lordship, by putting these students in alternative classes and giving them AI tablets, of which these students consent to the fact that they are dead machines to them, because Grace Nambuya doesn't have a screen reader function, making it a dead machine because she simply cannot see. Samuel Katumba cannot hear, has a hearing impairment. There are no subtitles, there is no sign language. Therefore, when they put them into alternative classes and give them these AI tablets are dead machines. What they do to supplement that is provide them with outdated material. We contend that this is putting them at a lesser level than what their peers are and amounts to discrimination. There is no equal access to education between these disabled students and the able students. Secondly, on the question about the bare minimum, my Lordship, we do not disagree with the fact that there has been significant improvements. What we demand is that the applicants actually receive this equal access to the education that has been improved. We contend that these applicants should have measures of reasonable accommodation that put them at the same level as these other students whose right to education has been progressively realized. Yeah. In light to these submissions, we pray that this honorable court will hold the respondent liable for the violations of human rights that they have actually committed as per Section 10 of the Human Rights Enforcement Act. My lords, if I may be of no further indulgence, I seek leave of court to yield the floor to my co-counsel.
Much obliged, my lords. My name is Hermon Asmero, second counsel for the applicant. I'll be using 9 minutes to submit our case and make our prayers. My lord, I'll be addressing issue B that states whether the compulsory collection of biometric and personal data without consent violates the right to privacy under Article 27 of the Constitution. My lords, as the counsel for the applicant, we contend that indeed the compulsory collection of biometric personal data without consent violates the right to privacy under 2 heads of argument. That is, A, the right to privacy is protected by law, however, it has been violated in this scenario, and 2, principle of data protection and collection. Proceeding to my first argument. My lords, under Article 27 of the Constitution of the Republic of Uganda, as well as read under Article 17 of the International Covenant on Civil and Political Rights, interpreted by Committee on Civil and Political Rights, under General Comment 16, it states that to the extent which privacy includes is personal data and information. This is further evidenced in a law case in the matter of an application for enforcement of human rights by Carl Halley under Miss Cause 88 of 22. My lords, this is further evidenced in our facts, paragraph 6A, where this was done without any consent. It's also further evidenced in paragraph 1, where this survey or this pilot survey started in 2022, and by 2024, where they had the 67%, this was still going on. My Lord, these are 2 years of violation of the right to privacy. My Lords, imagine that. We cannot bear to have that moving on.
Council, at the core of the right to privacy is consent. And one would argue that consent is not absolute and it has exceptions. So in this particular set of facts, the respondent would argue that the consent here did not be obtained given the nature of the project at hand. So what would you say in line of that?
Much obliged.
So, and whilst you're answering that question, and in line with paragraph 2 of your facts, the Ministry of Education and Sports, in fact, consented to this pilot study being done, and it's the one in charge of the education systems in the country. I therefore find it hard to harmonize you saying that there was lack of consent. And even then, the parents, by allowing or enrolling their students in these schools, give an implied consent that their students are actually supposed to be given any study material in these schools. So I find it very hard for you to say that there was no consent.
Much obliged, my lords. To your question of the consent, my lord, under Section 7B of the Data and Protection Privacy Act, it states that a child is someone below the age of 16 years. And this Nakaseke school, we believe, has students that are below 16 and they can't make their decisions on their own. Therefore, the consent of the parents is very important. My lord, to your question of the ministry already giving consent, we believe and submit that as long as the child is below their parent, it's the parent who has to make the final decision. The ministry is more like a second party involved in this pilot. Therefore, consent of the child is still something very important. My lord, I proceed to our second argument.
Council, before you leave that point, the Ministry of Education and Sports is in charge of what's provided at schools for meals, is in charge of setting the curriculum. Is your argument then saying that since the parents are the primary caregivers and therefore give the primary consent, that they give consent to all that is done in the schools? Or you're only picking a part of it that you think is not favorable?
Much obliged, my lord. We acknowledge that the Ministry of Education does all and it has got the consent. However, for this to be efficient and the applicant's right is not violated, we submit that the two must consent to have this running within the school, whereby one of the parties hasn't yet got the consent. Therefore, it infringes on their rights.
Council, to sum it up for you, is the consent required for the curriculum, or is the consent required for the data in terms of student performance as per the curriculum? Is there a need to have consent for the curriculum to be rolled out, or is there a need to have consent for the statistics, basically the performance of students regarding the curriculum? Which of the two requires consent, and who can give consent? Is it government or the parents?
My lord, both require the consent, but one requires it to a large extent, the privacy. That is why the issue I submit before you today is whether the compulsory collection of biometric personal data without consent violates the right. My lord, to your second question, the government and the parents have the right to give the consent, which in this matter, the parents haven't. My lord, I proceed to our procedures under principles of data collection. My lord, any of these principles cannot work independently. They're interdependent, meaning three of them need to be protected. A, under consent. Article 16 of the Convention on the Rights of the Child says that no child shall be subjected to unlawful interference. That is under, as well, Section 7 of the Data Protection and Privacy Act. That states no data is to be collected without consent. Again, under Article 17 of the ICCPR, interpreted by the Committee on Civil and Political Rights under General Comment 16, emphasizes consent and legality to data protection and privacy. However, my Lord, we see this has been violated in paragraph 6, part A, where no consent was got. My Lord, I proceed to our next principle, non-infringement. Section 10 of the Data Protection and Privacy Act says that no data shall be collected, held, or processed in a way that infringes the right to privacy. It further shows under Article 34, Clause 7, that special protection to orphans and vulnerable children should be emphasized. This has been violated because even the disabled children's parents haven't got this. My Lord, to the last principle of security and confidentiality. General comment on 25 on children's rights in relation to the digital environment by the Committee on the Right of a Child, paragraph 67, emphasizes that privacy is vital to children's agency, dignity, and safety. My Lord, if this is not done, it results to identity theft and emotional distress. This was got from a report of a special rapporteur on 15th January.
Has there been any harm as a result of collecting this data from the students? Any harm that's in the facts that's been caused?
Much obliged, my Lord. Rumors have it that this goes... Yes, my Lord. And I believe we cannot forego them because according to Article 50 of the Constitution of the Republic of Uganda, if anything puts a threat to your right, then you have the obligation to go and report it. So in this case, we cannot forego that because it's a rumor.
So Counsel, just so I get you right, you've come to this court, no evidence, just rumors that could have been brought up by probably a competing company that wants to supply the tablets, and we should base on that to find the school in violation.
Counsel, as you answer that, when determining a breach to privacy, is a threat as more damaging as the actual breach? And in terms of cybersecurity, are you better off preventing a threat than dealing with the actual damage?
Much obliged, my Lord. To your first question of the rumors, my Lord, in this case, we provide enough evidence. However, in case we are to base on the rumors, for now, there has not been any harm. And that is why we need the parents' consent, that in case there is any harm, the parents are to report it and they are aware of this. My Lord, to your second question of the data protection, we believe that at the end of it all, it's been done for the good.
Proceed.
My Lord, to my argument where I had stopped, I beg for 30 seconds to make our final prayers. My Lord, the security and confidentiality is something that we cannot bear to forego. As the applicant's counsel, we pray that the court makes a finding that the nature of which data was collected is a violation to the right of privacy. My Lord, we make our final prayers. The applicant prays that this honorable court, under Section 9 of the Human Rights Enforcement Act, firstly, puts a measure aimed at the cessation of the continuing violation of the human right of privacy, education, and equality of children. Secondly, issues guidelines ensuring informed parental consent and protection for children. And lastly, restoring the dignity, the reputation, and the rights of the victim and the persons closely related with the victims. My lords, we so pray.
Counsel for the respondent.
May it please this honorable court, my lords, I am Sime Arnold, the lead counsel, together with Counsel Moyesa Joel, representing the respondents, Nakaseke Bright Future Secondary School. We will discuss two issues for the respondents. One in question of whether the measures taken for children with disabilities, including alternative classes and optional specialized devices, represent reasonable accommodation, progressive realization within the school financial and technical limits. I will argue this under one head of argument, and I will argue it in 11 minutes. My co-counsel will argue the second issue in key question of whether the data collection is lawful, necessary, and proportional and serves legitimate aims such as promoting education, safety, and preventing exam malpractice in 9 minutes. After that, my lord, I make a request to start with an opening statement.
Proceed.
My lord, when students are provided with a bare minimum education, even in instances where they could not get education, the applicants think it is a bad world. We cannot stand for that world where students don't go to school. We think that is the world the respondents provide to you. I'll go then to my first issue, which talks about the education and discrimination. I'll discuss it under one argument, which is the right to education is subject to progressive realization based on available resources. Article 2 of the International Covenant on Economic, Social and Cultural Rights, which talks about progressive realization of rights. As a state, we think the state, my lord, should take targeted steps of realizing education. In paragraph 8 of this article, it explains the introduction of this smart class AI as a pilot project. This means that it is a project no one has done before, and it is something that is in experiment. It also further explains that the smart class AI is still in pilot phase, and the international suppliers have not yet localized software for the disabled learners. This explains how learners are unable, or the disabled learners do not have the equipment to cope up with the smart class AI. And we think it is a matter of time since it is progressively realizing the right to education in this system. The only problem, therefore, is putting these learners in a separate class. In progressive realization of education, we think it is according to Article 30, education is a right, and everyone should have a right to education. Given that education is not an absolute right, what we do as a school is provide it as a fundamental right, and bare minimally, students have to go and study. That's why we separated them and put them in a class where we gave them materials and AI-generated content. To magnitude, this amounted to the same things they were studying in their former classes, and I think on that ground it became fair. Also, we continue under this state that a state of full intervention. Yes.
My problem with the school's actions are clearly excluding the results of those students from the national results that were being submitted. Yet it argues that it was still giving the bare minimum. So why were they not included in the results clause?
So according to paragraph 10 of the facts, which says that the performance reports will not be included in the school's overall statistics to avoid distorting the improved national rankings. According to Article 43 of the Constitution, which talks about general limitations on fundamental and human rights and freedoms, Clause 2 talks about public interest, that talks about what is acceptable and demonstratively justified in a free and democratic state of what is provided in this constitution. If the public interest was to fulfill national rankings and overall performance of the state, therefore we took initiative to limit these students' ability of registering them into and removing their reports into the national rankings.
Council, my problem with that though is you have a state that's required to plan effectively for all students. It cannot do that without their data and performance being included in the national rankings, because it will not know. The state will plan based on the fact that the school is providing it with students who are ably excelling.
I'm obliged, my lord. My lord, since it is progressive realization of rights, and this is a pilot project, makes the idea of removing their reports a temporary idea, meaning we could still implement their reports after the pilot phase has been done and the and the technology system for catering for their needs has come in the second phase of implementing the pilot system.
Council, my problem with that is the school could have had another alternative, giving supplementary rankings and indicating that these are from a certain set of students who have this problem. That would have been less restrictive, but they did not do that.
They did it to generally fulfill the public interest of having overall performance and higher ranks, because the higher ranks were following the idea of initially in paragraph 6, where students had started performing in paragraph 4, where students had started performing well. We don't want to go back, because it talks about the second factor of progressive realization, that there should be non-retrogression. That is, if you have taken further steps in education to improve the education, why then should you go back down? And realizing this becomes
Council Arnold,
yes.
While you're saying that they are progressively realizing and there shouldn't be non-retrogression from that right, it still remains the fact that in fact these students who you're excluding are not performing any better because of their exclusion. It's not realizing what you think that it is realizing. They're being excluded, their rankings are not being recognized, therefore the state is unable to plan to solve this because it's not provided with that information in the national rankings.
Council, to add to that, is the school more concerned with the optics of how the program looks like as opposed to how the program is doing? Because from a bird's eye view, especially from my learned sister, it seems to her that the school is more concerned with what the public perceives the program to be as opposed to what the program is actually doing. So how do you address the fears or the skeptics or the doubting Thomases that this thing is not working and you're trying to make it look like it's working?
My Lord, I will address this to the right of education not being absolute. This is further extended, or the right to limit education in this case is granted by Article 14 that talks about the general limitation of fundamental rights and other rights. My Lord, of the 100% students we have in class, 98 are excelling. We cannot stop the excellence of 98 students by 2% students. What we do is that we give them a separate class where they also receive bare minimum education. We are progressively receiving some sort of education as opposed to non-education in this case. Excluding...
So, is it a numbers game in terms of 100 versus 2? Or is it access to justice? So as a court, do we look at the numbers or do we look at what is just and fair? Because
I think fairly in looking for the public interest, we would equally look at the numbers of the 98% students.
Council, the applicant's argument in that regard would be their argument and contention with the school's actions is not primarily based on the right to education that you claim rightfully so can be progressively realized. Their argument is that while you're trying to progressively realize this right, you're denying the children to access a right that's a political right, that's an absolute right, and therefore cannot be done away with under no circumstances.
I'm obliged, my Lord. My Lord, I don't think it is true that we are denying these students education, because putting them in a different alternative class means that we are giving them equal materials that they used before to study, outdated textbooks that they could have used to study. These were supplemented with AI-generated content, the same content that is being used in the Smart Class AI. So I don't think under this case, education is being denied to the students.
Council, address this court particularly to paragraph, is it 6? Regarding the school's obligation on making sure that the students in its campus or that are under the school are not name-calling the students who have special needs.
I think students name-calling the other students who have special needs is not the problem of the school, because the school cannot take up all demands of students' bad manners. We have tried to discipline students, and this generally happens in everyday society. They try to discipline students in school, but it is by the nature of the students that they go on and call their fellows that members of the left behind class. So I don't think that is to blame.
But does the school have any obligation in that regard?
The school does best what it can in disciplining the students, but when students go further and call names to that class, it is not up to the school to be blamed for that.
Proceed.
Okay, I will proceed to also Article 34. I'll proceed to Article 34 that talks about rights of children and the best interest of children. This is further extended by Article 21 of equality and freedom from discrimination. We gave them a separate class which attended to their own needs, because ideally what applicants would be arguing is that this smart class AI brought harms. I think under a system where, my lord, that smart class AI was not introduced, you wouldn't attend to the needs of these students anyway. What happens is because they will stay in a class with other students and stay at an unbalanced level. When you put them in a separate class, and that is why we have streams within schools, so that we can know the special needs of students and attend to them principally, because we want to attend to them. So these alternative classes attend to the needs of these students. They cannot use smart class AI, and therefore we give them outdated textbooks which they can use to attend to the needs of basic education. I think under this article we prove why you much more likely have outdated content. The applicants also, we pray to talk about outdated books. They are found in their need. Note that mental change, which is caused by the students, is something we are willing to concede to, because these students have caused mental change and they have caused some sort of like mental trauma to these students. But this cannot be to the blame of the school and the school. So my lord, I beg for 1 minute so that I can like sum up my case.
Proceed to do that.
I think in the idea of progressively realizing education, the school also took further steps in sharing costs. They took further steps in saying that at the beginning, the parents can pay 900 and they can pay the rest. They also took further costs to tell the parents that if you want this smart class AI that caters for your children, you pay 1.5. When parents complained, the school took an initiative to put these students in an alternative class, a different class which could cater for their needs. So the school took initiatives in trying to make sure that these children still receive education. And with that, my lord, if there are no further questions, I lay down the floor for my co-counsel.
May it please you, my lord, for purposes of records, my name is Mwewesa Joel, co-counsel from the respondent side. I'll be taking you through issue 2 of the respondents, which is whether the data collection is lawful, necessary, and proportionate and serves legitimate aims such as promoting education, safety, and exam integrity. I will argue this in one head of argument, that is the right to privacy permits lawful and proportional limitation for the public interest. In reference to Article 43, which is about the general limitation of fundamental and other human rights, it then, under Clause 2 and subsection C, it guides on how rights should be limited. It guarantees that public interests under this article shall not permit any limitation of enjoyment of the rights and freedoms prescribed by this chapter beyond what is acceptable and demonstrably justifiable in a free and democratic society. The reason as to why, my lord, we limited the rights of privacy and even consent of these kinds of children by taking out their personal information and data without the consent of their parents, as it should be, as it is guided by the rights on children, is because we are guided by this article, where we have to limit the rights, where we limit some rights to what is acceptable and demonstrably justifiable in a democratic state. We limited them not because we intentionally wanted to limit the rights or infringe on the rights, but it was because of the greater good of the public service we are giving. That is the quality of education. Education is not just a cheap principle. We need to follow up with education that is, AI infringed, AI dominated, we need to cater for the attention, for the attendance, and even to measure and even to cater for things like exam integrity. That is why we take facial scans to cater to properly follow up the attention of these students in class. That is why you have to take their fingerprints to properly follow up their attendance of these classes and also cater for exam integrity.
Council, was that not being done before they introduced these AI tablets? The school was the monitoring attendance, exam integrity, was all that not being done in the ordinary traditional mode of education to necessitate this?
Yes, my lord, it was done, but then this is a new education system that is dominated by AI, so it would be best monitored. The attention and the attention and the attendance of students would be best monitored using the AI, given the personalization of AI tablets for each kind of student in this regard, my lord. My lord, team. My lord, applicants come and assert that the data protection has no harm. Actually, they agree to it. They say that the data we took should be urgent and should be to keep the urgency of children, dignity, and their safety. And they again concede that it had no harm because they based this on rumors. My lord, that's misleading. Firstly, this court should not base on rumors because those are not facts. But what we then need to understand is why this data was being collected in the first place without the consent of these parents. Yes, my lord.
These concerns that you're calling rumors are being brought up by parents who are the primary caregivers of these students, and I believe should not wait for the worst to happen for them to come to this court.
Following up on that, are there situations where consent can be excused, especially if there is no harm?
Yes, my lord. Following the Data Protection and Privacy Act, CAP 97, under Clause 7, about consent to collect, process personal data, under subsection B, part 1, it guarantees that personal data may be collected or processed where it is necessary for proper performance of a public body or proper performance of a public body. And in this case, we are seeing educational duties, it is a public body, and then this then guarantees us to collect this personal information, even limiting the rights to privacy. But then also, under the same act on data protection and privacy, under clause 8, a person shall not collect or process data relating to a child unless the collection or progressive is therefore for research or statistical purposes, my lords. We think this is a pilot study, and henceforth makes it something for research and statistical purposes, my lord. Hence, we then are justified to collect this data, even when you are limiting the rights of this very.
My concern with you naming it as a mere pilot study is that while it's named as that, it's the same being used to grade. Because if it was just a pilot study used just for educative purposes, but the examinations that are being graded at the national level are done using the traditional way that was previously used, then we'd understand that it's a pilot study, but there is an alternative mode that is being used. But it's a pilot study used to grade students and exclude some of them.
Yes, my lord, but if I may be allowed to correct you, this is a pilot study on how integration of AI in the education system would, progress with education performance of the students. That is why it does not apply to all schools in Uganda. But then among the selected few, Nakaseke Bright Future is right. This means that it is not widespread everywhere, and so even when it is used for national grading, it is then to assess the integration or even the performance of AI integration in the education system. That is to say, the data collected under this system is to grade whether the integration of AI in the education system is doing greater or harm, my lord. Yes, my lord. I'll then proceed to the prayers we get from the team respondents. My lord, according to paragraph 5 of the facts, AI system is uses facial recognitions and to monitor the attendance and attention in classes, that's promoting education safety, exam integrity, and through prevention of cheating. My lords, other instances of collection of personal data without consent is acceptable in a demonstrably justifiable in a free and democratic society. But this is for the betterment of the education system that you're having provided. Henceforth, this is a public interest. And plus, it is a pilot study. We expect imperfections here and there, my lord. Hence, there will be perfections in the later phases of this pilot study. Therefore, we pray, my lord, that this court finds it justifiable for us to limit the rights of these students and collect the data, because it is for the greater good, and even we are allowed by the Data Collection Act and is under Clause 7 and Clause 8 to collect this personal data if it is for education and statistical research, but then also for proper performance of a public body and in which education duties are among. My lord, if there are no submission, I pray to your law.
Applicants, proceed with your rebuttal in 1 minute.
My lords, may it please the court. Discrimination cannot be progressively realized. It must be ended immediately. Much as there was an improvement in the results attributed to improvement in the education, some students were left behind. As presented in the facts, these students were put into alternative classes and given tablets they couldn't use, in addition to outdated books. That is very unfair. Secondly, their results were excluded from the school statistics. That is very unfair. Why do we think it's unfair? Because it makes you feel left out, as shown in the facts, where Grace Nambia actually says that she feels left out in her own school, in her own society. We contend that children shouldn't be made to feel that way, no matter the justification. There is simply no justification to discriminate a child. Much as education is important, it should be improved as each and everyone is having equal access. Secondly, on privacy, what would it take to print out consent forms and give them to parents? Much as they argue that their aims are legitimate and there is justification to limit privacy, what would it take? Are there less intrusive measures of actually coming up with these benefits that they are seeking for? My lord, I pray that you make finding that respondent is in violation of the rights of equality and freedom from discrimination, education and privacy. We so pray.
Thank you so much, both teams. I'd now love to proceed to my comments. And I believe both teams have done well. And as a judge, one of the hardest points is determining who deserves to win more. I believe always both teams win, but there's a team that deserves to win more. And it's always a very difficult perception or balance for me. And regardless of how this goes, I believe you've done well. You've done very commendable. You understand the law. You understand the principles. And you've applied the principles very well. I'd like to proceed to the comments. There's some improvement, especially going to the next rounds. The first one is with regards to how you perceive questions. Most of you perceive questions like we are attacking you, which is not the case. Questions are meant to test your understanding of the law and principles. So you get more marks from answering questions than from submitting what you have. So always treat questions as a conversation between you and the judge. So for this to be effective, it has to be a conversation between the bar and the bench, as opposed to a conversation from the bar to the bench. So always make sure that there's an interaction between you and the bench. If you notice that there is no interaction, then most likely we are either lost or we are bored. And that is not good for you. So always make sure that there are questions coming from our side and that you're answering them. Now, you don't answer questions with the law. Okay? You answer questions with your own understanding of what the question means to you. Then you can support your answer with the law. So first answer the question in your own understanding and then support your answer with the law. If I ask you a question and you go straight to the law, what I interpret that to mean is that you're telling me to shut up and to let you go on with your case. So always answer the question with how you understand it. Okay? Then after that, you can justify your answer with the law. For example, if I ask you, counsel, do you believe a separate room is good treatment? Your answer should ideally be, my lord, in as much as a separate room doesn't look considerate given these circumstances, a separate room ensures that disabled children get special attention and treatment in light with their condition. This is supported by the fact that the legal regime provides that government and schools should take special interest in disabled people and ensure that they get extra attention and consideration. So a separate room in these circumstances doesn't amount to discrimination. It just amounts to special attention. So you've answered my question with your own understanding, and you've backed up your answer with what the law says. In my answer, you never heard me talking about any law or any section. No. But I'm showing you that I understand your question, I am answering it, and I understand the law. So we know the law. We know the Data Protection and Privacy Act. We know the sections. Okay? What we don't know is how do you understand the law. That is what we are looking for. We're not looking at you telling us the law. We're looking at you telling us how you understand the law. Because this competition is meant to help you appreciate and apply the law. It's not meant for you to showcase to us how much law you know. Because we are lawyers, you're not. We definitely know the law more than you. So this is not a competition of, I know the law. Okay? Another thing is, when you become lawyers in future and you practice, a judge is never wrong. And you can never correct a judge. Okay? So I had someone saying, my lord, I want to correct you. You can never correct a judge. A judge will never be wrong. Okay? What you do is to appeal a decision of a judge. You don't say that judge was wrong, no. You just say, I am appealing the decision of that judge. So you cannot correct a judge, you cannot correct the court. Okay? You're lucky we are a bit reasonable because we've been on your end, but someone else will just, from that moment, your moot is done because they're going to fire you the meanest questions and they're going to make sure you fail. So at no point should you as a mooter think or even imagine that from that side you're better than the people this side. It can never happen. It will never happen. It should never happen. So one of the things we take very considerate in our profession is what we call collegiality. Respect of the other side. So you don't bring arrogance, you don't bring pride, you don't bring wiseacring into the profession or into the law. Most of you have heard of the problems one of our colleagues is facing, and those problems come from him having a confrontation with the bench. As a lawyer, you can never have a fight with a courtroom, a court, or a judge. With that, I'd love to give my learned sister a chance to... Another thing before I go there is always understand that when we're asking you questions, some of us, as you've seen, she was playing bad cop, I was playing good cop. So you should have noticed that whenever she was asking you a question that you don't understand, I was coming in to give you direction. So always look out for those two judges. There is always a bad cop and a good cop. So know which judge is directing you to where. So if I ask you between primary and secondary education, which one do you think should be free? If you're saying secondary education should be free, and I'm saying between the two which one should be free, automatically you should choose primary education because it's the opposite of what? You understand? So if I give you a clue and my clue is opposite yours, then automatically you should click that what I'm saying is correct, what you're saying is wrong. You don't persist and try to fight the process. Okay? So with that, I'll give my sister a chance to talk.
Thank you very much. I must say that this has been an extremely good round. At a moment, I thought we were in a final round because the teams are both equally good, and I think the audience can also attest to that if they are not being biased that they come from a certain school. But that being said, in addition to the comments that the chair of this moot has made, I want to comment on decorum and how you stand in court. You start off very well, and then 5 minutes in, you're putting your hands behind. They ask you a question, you bend your shoulders. All that is noticed because while for you, you're only focusing on what you're thinking about to present, I'm looking at you, I'm not thinking about anything else. So the judge will see all the facial expressions that you make when they ask a question. They'll notice almost every mistake that you'll make. So try to give them as less chances of noticing how uncomfortable you are with a question that they have asked. 2 is still on answering questions, like he mentioned. I may not be offended because I probably don't have an ego when you say, let me correct, but people have egos, serious egos that can be bruised by anything that you say. So be very careful if any of you goes to the next round, or even in other moods that you will participate in. Be very careful with how you address people. When I used to moot, I think I used to do this. If the judges have introduced themselves, and you think that at any point they asked a question that, or you think that they are playing bad cop, or you think that, or you're made to believe that they are not in your favor, say Justice NASA, because they will know that you paid attention to them from the very beginning, that you're aware of their position, you're also aware of their name. In more practical moots, of course, now I understand your students, you do not have access to phones. If you're facing a panel and you know what it is, if they have written or published any articles, if they have litigated any cases, if their area of specialty is in a certain line, cite the law or rely on the laws or the books that they have written. It helps, because at the end of the day, we are all human, so it will make someone more inclined to give you probably higher marks. But whatever human and non-offensive mode you can use to soothe a judge's egos to make them inclined to believe in your argument, or even because if you call out someone's name and they were just seated back, they'll definitely lean in and try to listen more to you. So maybe you can use that in your other rounds or in the future. And then lastly is on rebuttals. There were very, very key contentious things, or there are always very key contentious things that come up in a round. You have 1 minute of rebuttal. Attack specifically that. Because at the point of rebuttal, everyone has already made their case. It's only left between deciding if it's a final, who takes it or who does not. So try to use that in the next rounds or in the next modes. Otherwise, I wish you the very best, and thank you for a very good round.
That is all from us today. Ideally, we would say court is adjourned, but we're not in real court, so you guys can leave at pleasure, and I hope it has been fulfilling for all of you, and I wish you the best, and looking forward to seeing you, as always, on the other side.
Welcome back to the quarter finals. I'm told it was hot. We wish everyone the best. So in the meantime, let us go there, have a photo moment, and then after the photo moment, we shall come back here, announce the teams which are proceeding to the semi-finals, and then we can have lunch. Yeah? Okay. Let's Right, let's move on. Let's move on. we have come.
Okay. Hi guys, welcome back from that particular session. The photo moment, the quarterfinals. So we are going to announce the teams that are breaking to the semifinals. But before that, I would like to put across an announcement. So there is that gentleman there, he's called Joram, with a red tag. That one, you can raise your hand again. So for the teams that have not broken and are not proceeding to the semi-finals, please take the gowns, only the gowns, back to Joram, yeah? So you will give them the gown and then you tell him the team name so that it ticks you against his list. Yeah, that is it. Now I will hand over to Umar, who will explain how the teams are breaking in terms of whether it's a winner or loser or things like that. And then also secondly, the teams that break to the semi-finals immediately go for lunch. So let us act in an orderly manner. The teams that break will be the first ones to go for lunch. The patrons also are invited to go for lunch. And then immediately after the teams which break have gone, the rest of you can also go. There will be a runner, Alicia, and Sweetie. They will guide you in terms of how you can go for lunch. Is that okay? Okay, great. So I'll now hand over to my colleague Umar.
Hi everyone. Hi again. How are you? Good. Okay. First of all, I would like to borrow a coin from someone. Yeah, a coin. Anyone with a coin? Good. You can. Yeah. Oh, thank you very much. Thank you. You can keep it for now. It's okay. So I'll be announcing the breaks or So first of all, the winners from each team, and you can clap for them if you feel like. If you don't, then video. So from room number 1, we had Egonda Ntende, applicant, versus Tibatema, respondent. Okay, drum rolls. Yes. Much better. Yeah. Okay. So and the winner in that particular room was Team Egonda Ntende. Guys, please, you can clap. This is the only part you're not allowed to be demure. In the second room, we have Team Batema, Justice Batema, versus Team Chisache. And the judges agreed that team that proceeds to the next round, which is the semi-final round, which is also the second last round of this competition, is Justice Chisache. In courtroom number three, we had Team Nagawa versus Team Gaswaga. And and from the consensus of the judges, Team Nagawa proceeds to the next round. And in the last room, we had Team Chiriabwire against Team Barishaki. And after a very, very heated decision, the judges agreed that the team that proceeds to the semi-final round will be Team Justice Barishaki. So all the teams can come forward. So in the first room, the first courtroom, which is going to be this courtroom, we are going to have Team Justice Egonda Ntende and Team Barishaki. And in the second room, which has been our room number 4 previously, but now it's room number 2, courtroom number 2. That room, the lower auditorium, we shall have Chisache and Nagawa. So both teams can come here, we toss a coin so we can get to know which side you're going to take. Heads is applicant, tails respondent. So we just want someone from Egonda Ntende and Barishaki first. Shouldn't do that hard. Sorry. Oh, sorry. going to tell all of you come.
Both should come. They will toss a coin to select the side. So one says head, the other one says tail. The other team, this is.
You have a contest. You have to. Where is it going down? You're going down. You're going down. Then where is Barishaki? Where is Barishaki?
So, which your head? So head is applicant, tail is respondent.
Applicant, the respondent. So that was the going to attend, eh? Okay. Chisache. Second take. Take 3. Okay. Who is that? Who is the head? The applicant. What's your team? Nagawa. So Nagawa is applicant, Chisache is respondent. Okay. So the guys who have just the 2 teams, the 4 teams, Egonda, Barishaki, Chisache, and Nagawa, please go for lunch now.
Please go for lunch right now.
And then the rest of us can follow later.
The rest of us will follow you shortly. DJ.
Oh, your coin. The one of this coin.
Someone owned this coin. So for all the teams that have not progressed to the next rounds, please do not leave after lunch. We have prizes for each particular school and each particular team. So please stay around for your prizes. Thank you so much. Yes, people handing over the gowns, please, you can submit them here. Anna, how's your team going? Which team is it? Come on, bro, you're saying about it. Sorry, they want us to experience which team Which team? That's what. How many are they? There are 2, eh? What's the First week, I have to just agree. Yeah, we. How many are they? There are 2, eh?
free. Oui. Kibatema. Wow. How many are they? Thank you. Another team? Which team is this? Ramada. That's it. Thank you. Anthony. Which is school? Okay, you have to return it. sing it with you. Come on, help me sing this song. Lord is my shepherd, everybody. Lord is my shepherd. He goes before me. He goes before me. Defender behind me. Defender behind me. Y'all been practicing. I won't fear. I won't fear. Filled with anointing. I'm filled with anointing. My cup's overflowing.
right. This right, sir.
Right, you're welcome to this semi-final. I believe you have been explained too that being a semi-final is a knockout round, which means that every single, like whoever gets the higher mark is the one who proceeds to the finals. Okay, so it's a mini final in and of itself. So we expect that we'll be getting the absolute best from each of you, from the teams. So make yourselves proud and make your schools proud. Yeah. With that said, let's have your names, please. You just write the team name and the names of the people who are.
This should be no, right?
It doesn't matter. So you just write the team name and then the names of the participants in the order of their. Thank you. Thank you. All right. So this is the respondent. This is the applicant. Right. All right. Let's hear from the applicant, please.
My lords, may it please the court. My name is Higa Eric, and I will be presenting alongside my co-counsel, Roman Asmerum. Our obligation today, in court today, is to represent the applicants Grace, Nambuya, and Samuel Katumba, My obligation within 10 minutes of this court's honorable time is to present on issue A, and within 8 minutes of this court's honorable time, my co-counsel will address issue B as well as say our prayers. My lords, we reserve 2 minutes for rebuttals. My lords, before I present, I seek leave of court to present my opening statement.
Please.
Within your time.
So within
my
the
lords,
time, yeah?
in a world that should have embraced their disabilities, these children were made to suffer for it. This case is about justice for children whose only wrong, whose only crime was being disabled. The issue I'm obligated to address today is whether the exclusion of children into separate alternative classes and the additional financial burden imposed onto their families was a direct violation of Articles 21, 30, and 35 of the Constitution of the Republic of Uganda and amounts to discrimination and denial of equal access to education. The applicant submits that it is indeed a violation, and to that we have two heads of argument. The first about the right to education, but secondly, about the right to equality and freedom from discrimination. My lords, on the first head of argument, which is the right to education, this right is provided for in Article 30 of the Constitution of Uganda and Article 13 of the International Covenant on Economic, Social, and Cultural Rights, interpreted under General Comment number 13, paragraph 6, by the Committee on Economic, Social, and Cultural Rights. It provides...
what is the probative value of that general comment before this court? And,
Pardon?
What is the value of that general comment as a source of law? Because you're relying on it, right?
Yes.
So what's its weight before this court?
I'm very much obliged to answer your question, my lord. General comments are interpretations within the respective committees that are interpretatory to international instruments by which we are bound as a nation. That is the significance of this general comment.
Yes.
It provides a four-part test.
And His Lordship has asked, what is the value of that particular comment? Like, should this particular court strictly follow it? Is it, do you get the question?
Does it bind the court? Does it give the way that you cited the Constitution, right?
Yes.
So this general comment and even the covenant that it interprets, what are they on the same value base as the Constitution, for example?
No, my lord. Okay. But Uganda is ratified. Uganda as a republic is ratified to this international instrument, and therefore general comments that are interpretative to this international instrument are something that should be considered in this case because we are bound to those international instruments. Perfect. If I may, the four-part test includes, first of all, availability, accessibility, adaptability, and acceptability. I'll be addressing accessibility first of all. Under this part test, education should be physically, economically accessible to everyone without any sort of discrimination whatsoever. Secondly, on adaptability, methods of teaching should be flexible to the needs of diverse learners and changing societies. My lords, these principles were violated as evidenced in paragraphs 8, 9, and 10 of the facts. I will address the issue of excluding them into separate alternative classes. Much as the side of the respondent is going to come and say this was to help them to better address their needs, we contend that separation into separate classes is actually segregation and does not amount in whatever logic to helping these students.
So what would the alternative be?
The alternative would be trying to come up with more reasonable means of reasonable accommodation to help these students study along with their fellow peers.
Such as, could you give us some examples? Has such a matter ever come up anywhere in the world where they were faced with a similar problem and they had a much more accommodative way of handling it, and how did they handle it? So guide this court so that we can know that you're not misleading it.
Yeah. Your Lordship, if I may, I would like to contend that in as much as the respondent is going to come and tell us that this is a very poor school, 3 million is not a lot of money for the inclusion of these students.
No, yeah, sure. I mean, we buy that. The question is, do you have any examples from anywhere around the world, anywhere where they have ever been faced with an issue of children with disabilities, and they had a good, much more inclusive way of addressing that issue, so that you can guide the court and it knows that, okay, this is what they should otherwise have done.
I'm very much obliged, my lord. I would like at this juncture to present the case of Sehad and others versus Mulago Hospital.
Okay.
This is a case that shows the principles that drive progressive realize and reasonable accommodation, if I may. It says that it should be targeted and deliberate. Under this case, the steps provided were targeted and deliberate. They were expeditious and very effective. They were targeted to the obligation and actually solved this. We contend that the measures taken by the respondent in excluding these children into separate alternative classes do not meet any of the above principles. How do I mean? Belonging matters. In as much as you claim you're separating these children to protect them, separating them diminishes their self-confidence, diminishes their social skills, it diminishes their self-worth.
My problem really is not with the separation per se. It's the fact that we are dealing with a very unique circumstance, right? You have these students who have disabilities. The school really would like to help them, okay? But within their means, there is no other way they can do it as of now without grossly impacting them. So this is what they come up with. We have an alternative. Look, we are going to get for you an alternative room, okay, where we are going to give you a kind of education that is going to meet your needs where you are, okay? Don't you think that's the whole concept of, reasonable accommodation? You're trying within your means to do, and isn't that really also what progressive realization is about? Do something as you wait for more money to do an even bigger and better thing. Isn't that the whole point of progressive realization and even reasonable accommodation?
Your Lordship,
Counsel, as you prepare to respond to his question, think about it also from the perspective of you telling us whether discrimination in and of itself is a bad thing or not. I think it would help you in answering his question.
Can there be positive discrimination? Can you discriminate well, or is discrimination always bad? Discrimination.
Okay. So I'll be addressing the issue of discrimination and the fact that there is progressive realization and reasonable accommodation. Discrimination, freedom, right to equality and freedom from discrimination is a civil political right. What that means is that it cannot be progressively realized. It must be achieved immediately. The issue we have as the applicant in today's...
Do you have an authority for that? That's a very strong statement you've just made. Do you have an authority for that, perhaps?
Yeah. According to Article 13, according to Article 1 actually, of the International Covenant on Economic, Social and Cultural Rights, in Articles 1 and 2, it's stated that rights like discrimination cannot be progressively
is that
realized.
In the ISSA? Are you sure? Because you seem to be quoting the wrong law. You said it's a civil and political right. I believe you probably are referring to the sister covenant to the ISSA. Isn't that what you're referring to?
My apologies, my lord.
So which is the correct law?
ISSA. Article 2, Clause 1.
But I've just told you that that ISSA would be the wrong law. Yeah?
ICCPR.
Beautiful. What is it in full?
International Covenant on Civil and Political Rights.
Okay, please proceed.
My Lord, why is it that discrimination is a very bad thing in and of itself? I want to begin, if I may, by citing the law, and I'll move on to the reasoning. According to the Convention on Rights of Persons with Disabilities, as interpreted in General Comment Number 4, Paragraph 11, by the Committee on the Rights of Persons with Disabilities, the right to inclusive education is incompatible with sustaining two systems of education, that is, separating a mainstream system of education from another for children who are disabled. Why is this? Because of the sense of belonging that matters. Separating someone into an alternative class is going to diminish their confidence, social skills, and self-worth. My lords, if
Time is
I,
up, but I'll give you a minute.
if
so
I
you
may,
can-
As you're
very
winding,
much obliged, my lord.
Yes, as you're winding up, does the ICCPR, ICESA, and even the Constitution of Uganda, do they recognize affirmative action? Do they?
Yes, yes, my lord.
Is affirmative action also a form of discrimination?
Positive discrimination, which is not regarded as discrimination, according to the...
Not regarded as discrimination? What is your definition of discrimination?
Discrimination is differential treatment on grounds of race, gender, economic standing, religion.
Yes, and so if we are positively discriminating this particular group on all those grounds, perhaps, is it not discrimination in itself?
And
and
are you certain that discrimination must, at all instances, be confined to those? Because you're saying discrimination is where you base on these grounds. Because yes, because my understanding of Article 21, which you've been citing, it reads that no one shall be discriminated on grounds of, meaning discrimination is different, but what is banned is that which is on those particular grounds you list.
I want to begin with your lordship's question. Why is differential treatment in a positive way not regarded as discrimination? According to the Disabled Persons Act.
Yeah? Which act is that? You mean the Persons with Disabilities Act?
Thank you very much, my lord.
Sure.
Yeah. According to the Persons with Disabilities Act, it is stated that it may not be regarded as discrimination if at all the conditions are reversed. We regard it as discrimination if the acts are affecting the disabled person. However, if differential treatment is given to a disabled person and not given to a person with full ability, that will not be regarded as discrimination. If I may move on to your lordship's question. Your lordship, it is stated under Section 4 of the Children Act, subsection 1J, that prohibits discrimination on grounds of disability. That means that even though I've not mentioned disability among the above stated grounds of discrimination that I've mentioned, it is still regarded as a form of discrimination by various acts, by various sources of law, and we contend that it should be considered in this case. My lord, if I kindly request for 1 minute to tie up my issue.
No, 30 seconds are enough.
30 seconds.
Actually, 20.
Thank you. Thank you, my lord. We contend that separate classes reinforce differences and strengthen stereotypes of discrimination, which further entrenches the problem. It doesn't fix the problem, which is not the children. It doesn't fix the society. Children's development doesn't pause. That means even though they come and tell us that they're going to progressively realize this, the damage is going to be so substantial. My lords, in light to these submissions, we pray that this honorable court will hold the respondent accountable for violating children's rights. We pray that they'll find them accountable for causing permanent damage for 3 good years to these children. If I may be of no further indulgence, my lords, I seek to yield the floor to my co-counsel.
Please. Thank you.
Much obliged, my lords. My name is Hermon Asmerum, second counsel for the applicant. I'll be using 9 minutes to submit our case and make final prayers. My lords, I'll be addressing issue B that states whether the compulsory collection of biometric and personal data without consent violates the right to privacy under Article 27 of the Constitution. My lord, as counsel for the applicant, we indeed contend that the compulsory collection of biometric and personal data without consent violates the right to privacy under two heads of argument. A, the right to privacy is protected, however, in this case, it has been violated, and B, under the principle of data collection. My lords, I proceed to my first head of argument. The right to privacy is protected by law under Article 27 of the Constitution of the Republic of Uganda, as well as Article 17 of the International Covenant on Civil and Political Rights. It's further interpreted by Committee on Civil and Political Rights under General Comment 16 that states to extend privacy includes personal data and information. My lord, we see this in a law case in the matter of an application for the enforcement of human rights by Kalali under Ms. Cos 88 of 2022. My lord, this is evidenced in paragraph 6A, where this was done without consent, but
Counsel,
B...
let me help you get to the point. Is the right to privacy an absolute right?
My lord, yes it is.
It is an absolute right?
Yes, my lord. My lord,
Expound.
human rights are inherent. So, even if respondent comes here and says that they are doing it for the good of the public, we believe and submit that the right is inherent and it cannot be deprived from
Counsel,
them.
yes, all rights are inherent to all humans, right? However, we have rights that are non-derogable, i.e. absolute rights, and those that can be derogated from under specific circumstances. So I'll ask again, is the right to privacy a non-derogable right?
Much obliged, my lord. In this scenario, it is not.
Okay, so what are some of those instances under which the right to privacy may be derogated from or may be violated?
Well, my lord, that could be in situations where the consent has not yet been legalized by a authority or by the law, but then too we can find this better in Article 17 of the International Covenant on Civil and Political Rights.
Have you addressed your mind to Article 43 of the Constitution?
Much obliged, yes, my lord.
Yeah, address the question from that perspective.
Much obliged, my lord. Article 43 of the Constitution talks about the limitations, which we concede that the right of privacy is indeed protected under 27, but in this situation from the applicant's case, it doesn't pass the permissible limitation test. My lord, for it to pass that test, it needs to pass the 4 principles: necessity, proportionality, legitimacy, and lawful. And in this situation, it doesn't, and we cannot base it off on one. My lord, I proceed to say that for 3 years, my lord, their rights have been violated, and we cannot accept this to continue. We see this in paragraph 1, where it was introduced in 2022, and it proceeds to 2025, and this needs to come to an end.
Counsel, you make a very passionate argument, okay? But I would like for you to take it back a little. To the Data Protection and Privacy Act, right? I believe you have addressed your mind to Section 8 of the Data Protection Act, have you?
Yes, my lord.
So Section 8 tells us, about collecting data for minors, right?
Yes, my lord.
And it gives 3 instances, okay? What I would like for you to satisfy this court on is whether, 1, those instances are cumulative, i.e. all of them must be fulfilled, or just 1 or 2 could be fulfilled, right? Because I anticipate that your main concern is that parental consent was not obtained for these children. Am I correct in that assessment?
Yes, my lord.
Sure. So if your main concern is that parental consent was not gotten, would you satisfy this court that even in the other instances, the other two instances, you still would have a case in case, the respondent says, I know we didn't need that because we're proceeding under some other argumentation. So what would your rebuttal to that be?
Much obliged, my lord. My lord, that's where I was heading to argument to. But to be brief, the law or the constitution cannot be read in bits. As a whole, however, that's how it should be read. And that takes me to my second argument of the principles of data collection. We believe that under consent, which should be cumulative, that is under Article 16 of the Covenant on the Rights of Children, it says that no child should be subjected to unlawful interference. Meaning that a child, since they're 16 years, that's what the Constitution says, that a child is a person below 16, and this is a school-going child.
The Constitution?
Yes, my lord.
The age of consent under the Constitution is 16. Are you sure of that?
Yes, that is Article 34, Clause 5.
Yes, you read it. You read it. Do you have a copy of the Constitution? I can help you. So if you have a copy of the Constitution, please read
Article 34, Clause 5. For the purposes of Clause 4 of this article, children shall be persons under the age of 16 years.
Yes, so, and what is in 4?
Children are entitled to be protected from social or economic exploitations.
Exactly. So the age of consent of 16 is only as far as contracting and getting a job. So a person above the age of 16 can get a job, in Uganda. But the actual age of consent is actually 18, according to the Constitution. 16 is only lowered so that they can actually get a job, but you cannot vote when you're 16, can you?
No.
Exactly. So
much obliged, my lord. Thank you. We believe and submit that a school-going child, most instances, is below still 18 years, and therefore they require the parents' consent. Why this is very important is because these are the birth givers of the children. Under Section 7 of the Data Protection and Privacy Act, it says that no data should be collected without consent. We see this has been violated in paragraph 6A and paragraph B, where there is automated predictions which affects the future of these children just because of not asking a consent.
I'm still having a problem because, yes, consent must be got. Still, you haven't answered why or instances under which consent may be dealt away with. So basically the exceptions to that general rule that you've just stated.
My lord, the exceptions is under Section 7, subsection 2, BA of the Data and Protection and Privacy Act that says this should be done by a public good, that is a public body. However, in this situation, we might be inclined to consider the 98% over the 2% of the disabled or even generally their privacy. But we think and believe that because human rights are inherent, we still should consider consent in this situation. My lord, if I may proceed.
Why should we consider consent in this situation when the school and the state are trying to come up with a system of smart learning that is supposed to help everyone in the long run? This is something that is in its pilot phase. So why do we need consent in this case, and yet the purpose for which this AI was introduced is for the greater good in the long run?
My lord, we submit that consent is important in this, even if it's for the good of education, because of the two principles of data collection that I had stated earlier. That's the non-infringement and security and confidentiality. mere fact that the respondent doesn't give the consent to the parents is going to affect on the security and the non-infringement part of the right of the children. We believe that we cannot undermine human rights because we think that education is something that is better. My Lord, again, human right of privacy is something that we cannot bear to forego.
But Council, have you addressed your mind to Section 8, subsections B and C, which are specifically on the collection of data of children or minors like your clients or the applicants? And those subsections do not actually have a requirement for consent. Have you considered that?
Much obliged, my Lord. Yes, we have. However, again, I think the law can't be read in bits. But even if that was the case, we submit that consent doesn't harm. It's just a matter of signing and giving the responsibility for the parents to be aware because they are part of the parties that need to take care of the children. And we believe in this situation that parents need to know what happens. Therefore, in Section 8...
Maybe as a wrap up, because I think your time is fast spent, but you have an extra minute so that you could wrap up and give us your prayers. There's it's just something that I would like. This is not really a matter of law, but a matter of public policy. How would you suggest you strike a balance between public interest or the desire to fulfill a public interest, such as education, and private interests, such as the right to consent? Okay, you have to consent to collecting your data and that kind of thing. How would you strike a balance? What would you say? So, for example, if the parents are told and 90% of them say, nope, we are not consenting, does the government then halt a program that would otherwise have helped the young citizens, or it can override that consent? Like, how would you strike that balance? Could you just advise the court?
Much obliged, my Lord. We submit that behind a yes or no answer, there is a reason. So if the parents refuse, we submit that this is because it's a compulsory collection of biometric. However, there is no bigger or greater between the public and private, but as long as it's violating human rights of these children, it should be done in the best interest of the children.
Okay.
So if
so
signing
in that instance, if the state feels that, well, we need these children to learn AI. It's good for the nation, it's good for the future, it's going to help our economy, right? And the parents are insisting, no, we don't want that, we want to give you consent. Would you say that the state would be correct in that instance to, override their consent and nevertheless do this thing that is in the public good?
Much obliged, my Lord. As applicant, we do not say that provision of education or study of AI is bad. However, we have a problem with signing the contract.
No, this is not as applicants. It's just a public consent kind of thing. It's not related per se to the question. So there is no wrong or right answer. It's just, what do you think? What if you were the president, for example, tomorrow, and you have this brilliant program, it's going to help the children, but the parents are saying, no, we are not giving consent. What would you do as a president? You resign and say, okay, people power, I'm not going to proceed.
Much obliged, my Lord. If there are no harms in it, then I believe that majority of the citizens within the country would agree to it, because after all, every individual wants the best. Well, if they don't agree, I believe still behind a yes or a no, there is a reason as to why.
So you'd let them have their way, right?
If it's affecting their human rights again.
Okay.
Well,
okay. That's a very politically correct statement. But okay, let's hear your prayers, please.
Well, if I may proceed, my lords, I make our final prayers and say that we pray that the court makes a finding that the nature of which the data was collected is a violation to the right of privacy. Therefore, the counsel of the applicant prays that this honorable court, under Section 9 of the Human Rights Enforcement Act, firstly, puts measures aimed at the cessation of the continuing violation of the human rights of privacy, education, and equality of children. Secondly, issues guidelines ensuring informed parental consent and protection for children. And lastly, restoring the dignity, the reputation, and the rights of the victim and the persons closely connected with the victim. My lords,
Right.
we so pray.
Thank you very much, and we'll see you again in Alberta. Let's hear from the respondent, please.
Much obliged, my lords. May it please this honorable court, counsel for the respondents, Hussein Kabogoza appearing jointly with my land counsel, Eton Bright, for the respondents in the case of Nakaseke Bright Future Secondary School versus Samuel Katumba and Grace Nabunya. My lords, this case raises fundamental questions on how Uganda can lawfully and progressively integrate technology and into education while upholding constitutional rights, given the fact that we live within a growing digital ecosystem. My lord, I beg that this court is alive to the fact that this is an exceptional case where we are dealing with a pilot project. By nature of pilot projects, one, they serve as testing grounds for new policies or interventions. Secondly, they help identify challenges, gather data, and refine strategies before large-scale implementation. Then three, they are usually time-limited and geographically limited.
Councillor,
However, my lords...
Could you just kindly guide us to your authority for that assertion?
Much obliged, my lord. My lord, in the next 11 minutes, I will address this honorable court.
No, I'm saying the authority. Like, you just gave us what a pilot project is. And I'm here wondering, was he born with this knowledge? Must have been a very brilliant person.
My lord, the nature of pilot projects is on intuition.
It's on intuition?
By their nature.
So you were born intuitively with the knowledge of how a pilot project really works.
His lordship is asking you to give the source for your definition, counsel.
So what's your source? In easy language, or Jawa? Because you could lie to the court and you mislead us. You tell us pilot projects, we don't have any idea.
My lord, much obliged, my lords. I beg to maintain the position of intuition and basic understanding of pilot projects in and of themselves.
Okay, maybe just to guide you. So in the future, courts of law do not really work on intuition. Yeah, they work on law and authority. So you need to have an authority for what you say. Otherwise, they could also come here and take us on a wild goose chase, something, and they say, well, intuition. So intuition is not a source of law. Yeah, you need to have an authority, something that affirms what you're saying. But please proceed.
Thank you for that guidance, my lord. My lords, I beg that in the next 11 minutes, I address this honorable court on the issue on whether the measures taken for children with disabilities, including alternative classes and optional specialized devices, represent reasonable accommodation and progressive realization within the school's financial and technical limits. And my co-counsel will address this issue, this honorable court, on issue 2 and our prayers. As a guide to my submission, my lord, allow me to argue under the following heads of argument. The first on whether the actions of the respondents amount to reasonable accommodation and progressive realization. The second, on whether the Smart Class AI program enhances rather than violates the right to education under Article 30 and 21 of the Constitution of Uganda. My lords, I beg to go on to my first head of argument on whether the actions of the respondents amount to reasonable accommodation and progressive realization.
Counsel, before you move on to your argument, you opened with a very interesting statement on how we are in the digital age and we have to move forward basically with technology. and I hope that you're going to address this as you make your arguments. Should we embrace technology and the digital age at the expense of people's rights?
My Lord, as a guide to my submission, I'll prove on principle the principle of progressive realization and the principle of reasonable accommodation as a guide to the pilot projects to prove that indeed the adaptation to the digital space shouldn't actually necessarily be to outrightly excluding the rights of human beings. My Lord, as a guide to my submission under this set of arguments, the applicants contend that separation into separate classes is segregation. They say that this reinforces the differences. My Lord, the question to this court then is, the alternative of leaving these learners within the same system, does it then actualize the right of the applicants to non-discrimination? My Lord, if at all Grace Nawunya and Samuel Katumba are left within the same system, we should not run away from the fact that they are individuals with disabilities and cannot actively use the Smart AI program just like the rest of the students. That then exposes them to more discrimination. But then secondly, my Lord, under Article 21, subsection 3 of the Constitution of Uganda, discrimination is treating individuals differently. My Lords, on the basis of discrimination, that's why we are guided by Article 32 of the Constitution of Uganda that permits affirmative action. That article permits us to treat individuals differently if at all we are then to empower them within that regard. Yes, my Lord.
Perfect point on affirmative action.
Yes, my Lord.
Do you believe that putting these two students in a separate class with outdated material is in fact affirmative action?
My Lord, according to paragraph 2 of the Statement of Facts, the pilot program is supposed to integrate AI learning into education. The alternative is leaving these students out of the system entirely.
Do you believe that by giving them outdated material and putting them in a separate class is affirmative action?
My Lord, according to paragraph 9, the outdated material supplemented with the AI information, we believe that is affirmative action.
Does supplementing it with the AI make it any less outdated?
My Lord.
And is the education then at the end of the day helpful? And if it is, then also address us on why you then decided that you will not have their results as part of your school's national records.
Much obliged, my Lord. My Lord, on the first part of your question, on whether it is affirmative action or not, my Lord, affirmative action in this sense is ensuring that these learners can actually get the quality education. In this particular case, they are taken to an alternative learning room where they are not only taught with outdated learning material, but are also given AI assistive help. Even the individuals within the general learning room don't only use the Smart AI program. My Lord, the program or pilot is not there to substitute the existing mechanisms of teaching. It is there to supplement them. That is why we believe there is affirmative action into allowing them to make their education better when you put them in an alternative learning room where they are given due attention, since they are children with disabilities, to ensure that they actually get the quality education at the end of the day.
Your argument, therefore, is that indeed the students with disabilities are in fact receiving the same quality education that their colleagues without disabilities are receiving. Is that your argument?
No, my Lord.
So what's the point of the disparity?
My Lord, my point of argument is that since it's
the disparity between the education that the students without disabilities are receiving and those with disabilities are receiving, why is there a difference between these two?
There is a difference because this is a pilot study, my Lord. We are still trying to fully actualize these individuals that are disabled and integrate them into the system. That is why the disparity exists, my Lord.
And that takes me back to the original point that I made. Should we embrace technology and whatever it is that you're presenting us today at the expense of the rights of other groups of people in society?
No, my lord, that should not happen. But if at all the embracing of this technology does fulfill the principles of reasonable accommodation, as I'm going to submit under my heads of argument, and progressive realization of rights, then we should actually do embrace this technology. My lords, the limitations of rights under domestic constitution and international human rights jurisprudence alive to Article 35, read with Article 32, read with Article 43, alive to the ICESA Article 2, subsection 1 and subsection 3. My lords, Ugandan and international jurisprudence recognizes 4 cumulative elements that amount to the lawful and legal test for reasonable accommodation. The case here, my lords, is in 2022 in the case of Kalali Stephen versus Attorney General. The first element, if this court permits, is on individualization. Did the actions of the respondents actually cater for the element of individualization? My lords, on individualization, the action must address the needs of a person. My lord, that the fact that these individuals, according to paragraph 9, they were taken to an alternative learning room, we submit that it actually then addresses their needs as individuals because one, you give them the due attention, but then secondly, you're able to allow them to fully to realize and make sure they do not suffer from the outright discrimination they would suffer into the general room. The second, my lords, is on effectiveness. The adjustment must enable actual participation in education. My lords, we submit that according to paragraph 9 of the statements of the facts, they were not only taught with outdated content, just like the applicants might allege. They were given assistive AI information, and we submit that this
So paragraph 9, I think you're reading into it what does not in fact exist. Because when you look at paragraph 9, it says that they were taught with both AI-generated material, okay?
Yes, my lord.
And some outdated textbooks.
Yes,
okay?
my lord.
Could you perhaps educate or elucidate this court on the nature of this AI-generated material? What's the nature of that material?
Seeing that my time is fast spent,
Your time
I
is
request
fast
this
spent.
honorable court.
We'll give you 2 minutes because this is a very important.
Much obliged, my lords. I beg that you repeat the question.
Yes,
I was
so
interrupted.
could you explain to this court the
Yes, my
nature
lord.
of this AI-generated material? What was that material exactly?
What was the material?
Yes. What's the nature of that material?
The nature of this material is that it is updated, it is diverse, and it provides a bigger platform for these learners to get quality education.
This court is finding it a little bit hard to follow that argument.
Yes, my lord.
Because there is overwhelming precedent already that illustrates that AI-generated material is often false, often an aspect of hallucination. It's also often inaccurate. We already have jurisprudence from the American Supreme Court, in New York Times versus OpenAI Technologies, for example, and a myriad of other such cases, which have basically told us that AI-generated material, for every time you generate something on AI, it even tells you, ChatGPT can make mistakes. Please cross-check. Please, So
yes,
these AI-generated materials that you're giving the children with disabilities, how confident are we that it is in fact accurate and on the same par as the material that their colleagues are learning using the smart technology? So I would like to be sure that you're not giving them katwa.
Much obliged, my lord.
Coupling that with the fact that the material being supplemented by the AI generated is also outdated.
It's also outdated. What you're supplementing with is outdated information. So how exactly does this work? I would like you to convince this court.
Much obliged, my lord. My lords, Grace Nabunya and Samuel Katumba were not thrown into the alternative learning rooms to teach themselves. There is guidance of teachers to ensure that they get the right information, just like the students in the general room are. That is why we cannot allege that they are getting the wrong information
That's a
or
little bit
outdated
difficult.
information.
That's a little bit difficult again. They are taught with outdated textbooks and AI-generated material. So I'm having a little bit of hard time believing these teachers are well qualified, because tell me a well-qualified teacher that gets a student who is already disadvantaged by disability, takes them to an alternative room, and is quite confident teaching them with AI-generated material and some outdated textbooks. If your teacher walked into the class and they said, okay, so this is what I got from ChatGPT yesterday, and also have this Backhouse, which was the first edition from 1990, would you feel so confident about that class?
Much of like...
and again, compounded by the fact that under paragraph 10 you threaten not to include their results in the national tally. Could it be that you know actually the repercussions of your
Much obliged, my lord. Let me first answer the direction of argument that comes from your lordship.
Please.
My lord, we cannot allege, I beg not to hold the teachers of this nation in contempt. We cannot allege that teachers are actually going to deliberately allow their students to necessarily get wrong information. They are taught with the AI-generated material. But that doesn't, the statements of facts don't say that they are only taught with the AI-generated material.
But also with some outdated textbooks. So
yes,
the
my
frying
lord.
pan into the fire.
Yes, my lord. But we beg to submit that definitely there is guidance of qualified teachers. Nakaseke Bright Future Secondary School is a government-aided school. Definitely, the government has provided quality teachers.
So you're very confident about what the teachers are doing?
Very confident,
then
my lord.
Why aren't the results being put in the national tally? In fact, the reason why, in addition, their performance reports will not be included to avoid distorting the improved national rankings. That means you know very well, your very qualified teachers know this, that if they should include these students, the results are going to go down. So they know that they are not really delivering as well as they really should. Don't you think so? Or maybe they're overwhelmed. The court can take cognizance of the fact
much obliged, my lord. My lord, I beg to submit that the reason as to why we then don't include the results of these students within the national rankings is basically because the education they are getting is still under progressive realization. And the reason as why that is important is that, one, we want to give them hope that they can actually get quality education even if they are individuals with disability, but also secondly, because under the Article 20 in the African Charter, on the article that addresses the right to education, it states that the right to education is an individual. You guide me on the verbatim, but it states that the right to education is individual and a collective responsibility. The moment you portray these results in the national rankings, and they are potentially bad, because we can't assume they're always bad, you discourage the parents from contributing towards the quality of education of their children.
Right.
That is why, my lords.
Yeah, your time is fast spent. Thank you for helping this court understand your point of view. So, do you have any other...
My lord, I beg to conclude that the authorities prove that the state is not required to achieve educational utopia overnight, only to act reasonably, progressively, and inclusively. Smart class AI is that progress, lawful, proportionate, and future-facing. What the applicants call exclusion, the law calls reasonable accommodation under resource constraints. I beg to submit, my lords.
Thank you very much. Let's hear from your colleague.
Much obliged, my lords. As previously introduced by my co-counsel, my name is Eton Bright, counsel for the respondent, Nakaseke Bright Future Secondary School. My lordships, the respondent school submits that the policy of collecting biometric data is necessary and proportionate in achieving a legitimate aim. As a guide to my submission, I will argue under the following heads of argument. Number one, the collection of data from these applicants serves a legitimate aim. Secondly, the collection of data is necessary for the achievement of this legitimate aim, and measures were proportionate. My lords, the applicants must accept that fundamental rights are not absolute. Article 43, read with Article 17 of the ICCPR, that allows limitations on rights in public interest.
So what is the ICCPR in full?
The International Covenant on Civil and Cultural Rights, Political Rights, I mean. Sorry. My lords, we submit that the subsequent test is affirmed by the Supreme Court in Charles Onyango, Obova, and Andrew Muguni versus Attorney General.
And what is the... Huh?
Just pardon us on that case, the case name?
Charles Onyango Obo and Andrew Muguni versus Attorney General.
I believe you mean Andrew Mwenda versus Attorney General. Yes.
Pardon, my lords?
Is that the name Mujuni? Oh. Okay.
So, what is the persuasive value of that decision?
The court held that limiting the enjoyment...
Before you go to the holding, yes. What is the probative value of that particular decision that you have cited from the Supreme Court?
That whether the limitation...
No. What is the persuasive value of that particular decision you have cited? That is different from me asking you what is the holding or what was held or what was the issue.
Does the decision bind this court? Does it not bind this court? Can this court... How should this court look at that case? Basically, that's what my colleague is asking.
My lords, the court should look at this case that limitation is acceptable and demonstratively justifiable.
True, we understand that. The real question is, again, does the decision you're citing, does it bind this court? Or can this court just gain from its wisdom without it really being binding on it? Or like what exactly is... It's an important decision, by the way.
Are we obligated? Are we obligated as this court to follow the ruling in that decision, or is it just persuasive and we made
we can depart from it?
We can depart from it.
It's persuasive, my lord.
You're certain?
May I proceed? The court held that the limitation and enjoyment of freedoms is an exception and only in...
So maybe just to guide you, so it's not persuasive, it is in fact binding because it was passed by the Supreme Court and you're in the High Court, and the High Court is bound by the decisions of the Supreme Court. So that's just for educational purposes. But please proceed.
My lords, we submit that the security of national education, of a national education program, is such an exceptional case. My lords, we contend that Nakaseke Bright Future Secondary School, as made in paragraph 1 of the facts, is a government-aided school. So the actions of the respondent of collecting biometric data helps in the execution of a government obligation, that is...
Councillor, the data was necessary, the amount of data collected was proportional to what was required, etc.
Yes.
Let's say we agree to that. Yes. Was the data collected legally?
Yes, my lord.
Yes?
My lords, we submit that while the applicants cite Section 8 on minors data, Section 8 8B of the Data Protection and Privacy Act explicitly permits the processing which is necessary for the purpose of performance of duty by a public body under the law. My Lord,
and in this case, you want to convince us that what you were doing was in fact a public body exercising its power or role, and hence it should do away with the obligation to get consent.
Yes.
Okay.
My Lords, we submit that the school's core function is to deliver high-quality education. The biometric data is necessary to guarantee the integrity of this educational system. My Lord, this pushes me to my second head of argument. My Lords, we aver that the respondents' actions of collecting biometric data such as the fingerprints, the voice recordings, and the facial recognition enables the school to achieve 3 paramount public objectives. Number 1 is promoting the integrity of education, and in this case we can say preventing malpractice. My Lords, we contend that the primary aim of this smart class AI system is to prevent fraud and ensure that the student registered under this AI class system with the biometric system collected is the one sitting for this examination. Unlike other methods that could have been use of passwords or IDs, which are transferable. But my Lords, we submit that...
Counsel, would your AI system suffer any setback had you tried to get consent from the parents?
It's possible, my Lord.
Basically, my question is, why was it so important that you skip the stage of getting the consent to go directly into implementation and collecting children's data without necessarily involving their parents, yet the law requires you to do so?
My Lord, we aver that the consent wasn't got from the parents, because in this case, when a parent takes his child to a school, he trusts the school and he signs that he has given the school, and he's trusting the school with his child. So in this case, give an example.
This is a statutory obligation, so you can't just rely on someone bringing their child to school as consent. There is a statutory requirement for you to get that consent before you collect the data. So my question still is, why did you decide to skip that stage?
My Lords, we submit that the respondents skipped the part of receiving consent from the applicants, because it's the school's obligation to promote education and integrity through the implementation of the smart class AI system. That's why consent in this case cannot.
Let me ask you a similar public policy question, right? So the government, you have this AI system. You believe the AI system is good for students, right?
Yes.
You go explain to the parents, and they have very serious concerns about it. Okay? What would you do as the state?
I beg this honorable court to repeat the question.
You have an AI system in this instance, okay? It's going to help the students. You go, you bring it to the public, and the public outright rejects it. They say, nope, we are not allowing our children. You explain to them, because consent means you explain everything you're going to be doing with this data.
Yes.
They realize that the risk outweighs the reward, and they decide, nope, we don't want it at all. What would you do as the state?
As a state, I would go on to implement it.
So you would override public will? You would force the program on the public that it has rejected?
For the greater good of the public, as implementing public interest.
So who would determine this greater good? If the public says we don't want it, So you would say, no, it's for your good. Biambamu. It's for your own good. We are going to do it either way. Do you think that if you did that, you would still be within the ambits of the rule of law? Or you'll be ruling by law?
I request this Honorable Court to repeat the last
No,
question.
it's a rhetoric question, really. If this court decided to follow what you're saying, and the public rejects it, you still insist they're going to take it, okay? Would you still be within the ambits of the rule of law, or you would now be in the territory of rule by law?
Rule by law.
Oh, so you are asking this court to basically endorse pure dictatorship and rule by law. The people reject it. Nope, I'm going to do it either way because I can understand for all of you guys don't know what you're missing.
My lords, I would like to refer to the case of Onyango Obo versus Attorney General, 2004.
I hope it helps you.
Yes, it does.
Please.
Privacy, in this case, privacy is not absolute. Reasonable restrictions are valid in public interest.
Yes, reasonable restrictions.
Yes.
And there is a 4-part test that case gives. A 4-part test to show that indeed that reasonable restriction criteria has been reached. Okay? So could you address this court on that 4-part test? And how exactly does your state fulfill that test? Because if you do that, then trust me, your case is solved. Once you can illustrate, according to Charles Onyangobo, these are the things that create, and then this is what the state did, we'll be good to go.
My lord, in that case, we argue under necessity, proportionality, lawfulness, and legitimacy.
Right, go one by one. Necessity.
My lord, in this case, it falls under the law as stated in section...
No, necessity.
Necessity.
Let's start with necessity. It's the first thing you said.
Yes.
Yes. His time is up, but let him first convince the court. We are very intrigued. We don't want you to run away. The rights of so many people are standing on this argument. So necessity.
Necessity, my lords, we submit that it is necessary. My lord, I would like to request on what am I arguing under what?
No, we have a 4-part test.
Yes.
So all we need is for you to tell us, okay, on the test of necessity, this is what it means, this is what the state did to show that that was fulfilled. On proportionality, this is what it means, this is what the state did to show that it passed. Like that, just go one by one. So, necessity.
Number 1, necessity. The respondents admit that in such a case, it is necessary to infringe on these laws. My lord, I'd like to submit that the data is necessary to improve the education system.
So you must get this data. If you don't get it, the system is not improved.
Yes.
That's the argument.
Yes.
And in this instance, you have already excluded 2 persons with disability. So whatever system you're improving, it doesn't have their data, does it? So you're improving a system with the data of able-bodied people. I wonder exactly how that system will cater for persons with disabilities whom you already admitted that you discriminated against, but in a positive manner because it was good for them. Okay? To have, so you get where I'm going?
Yes.
So, proportionality.
Proportionality, my lords, we submit only the required information is collected.
Okay.
And in terms of being lawful,
no, you haven't told us. So, how exactly did you fulfill?
Yes.
the
For
test of
instance,
proportionality?
under paragraph 6A, you list the data collected, but you only explain facial recognition, which you use for attention, under paragraph 5. So doesn't that mean the other data you collected is excessive?
My lords, we submit that the data collected is only required, only the required data is needed. Only the collected data is needed.
Okay. All right.
So-
Fine. Let's not disturb you so much on that one. Third criterion.
Lawful.
Yes.
Lawful.
Please.
My lords, we submit that rights are not absolute. That in this case,
Lawful means that there is a law that provides for collecting that data.
Yes, yes.
So.
Which law is that?
Yeah, which law is that tells you should collect that data?
that's Section 8 B of the Data Protection and Privacy Act, my lords.
Section 8
B. Yes.
Okay.
That explicitly permits the processing when it's necessary for the purpose of performance of a duty of a public body under the law.
And which duty is that, and under which law?
The duty is the legitimate aim, which is integrating, promoting education, that is under Article 30, that every individual has a right to education.
Okay.
And
lastly?
Legitimacy.
Legitimacy, yes.
That we submit that improving education is in public interest.
Now you've gone back to the first one. Legitimacy simply means that in a free and democratic society, this is what would ordinarily have been done. It's a test of legitimacy. So, tell us exactly in which country, in which polity, in which case has this kind of thing ever been done and it was accepted to be the correct thing to do. You just give us an example and you're good to go.
My lords, I would refer you to the case of Charles Onyango Obo and Andrew Bujuni versus...
Was there collecting of data in Charles Onyango Obo?
No, it's there is a legitimate purpose.
No. Legitimacy, it has to be specific. So in this instance, it's data collection, okay, of minors. So all you have to show us is that in this case, or in this country, or in this place, this indeed happened, okay? And it was found to be okay, it was found to be fine, there's no problem with it. That's all you have to do. And once you do that, your case has been properly solved. So do you have an example where anyone, anywhere, in any country has ever processed the data of minors without parental consent for an experimental project, and any law body found that that is okay to do?
My lords, we submit that we don't have any case.
Oh, okay. That's very sad, because this court would have been very, very happy to get something on which it can latch. Could you please give your prayers?
My lords, we submit under our prayers that the actions of the respondent Nakaseke Bright Future Secondary School was at achieving a legitimate aim, and that was promoting and integrating education. For issue A, we pray that this court declares that the Smart Class AI program lawfully promotes the right to education under Article 30. And secondly, we pray that this court finds that the measures for learners with disabilities constitute reasonable accommodation. And for issue B, that this court declares that the lawfulness of the collection of data as it's necessary, proportionate, and serves legitimate aims of promoting education. And thirdly, we pray that this court dismisses any deletion order, that no data collected from the students from these students must be deleted, because it plays a very instrumental role in further integrating AI into the learning of students. I beg to submit.
Thank you very much, Counsel. Could you have rebuttal quickly so that we can...
2 minutes.
Yeah, you had reserved 2 minutes, right? Please.
please.
Your Lordship, we are not against the introduction of the Smart Class AI system. We simply contend that this system has excluded and discriminated against our applicants, Grace Nambuya and Samuel Katumba. The measures of reasonable accommodation that they put in place are not enough to solve the pre-existing discrimination, and that goes on for 3 years, mind you. So why do we contend so? Why do we contend so? First of all, it is very clear from respondents' presentations that the content is not the same. The content these children that are able to get is not the same as the content that disabled get. That in and of itself is discrimination in the very first place. Secondly, because this content is not the same, there is reason to believe that these children are likely to perform even lower. And that's why they are not included in the national rankings, in the school statistics to prevent ruining their good national track record. Secondly, we contend that this excludes them from class, which violates Article 4, which violates Article 4 of the persons with which violates subsection 4 of the Persons with Disabilities Act, Section 6, which states that an education system must provide an inclusive education for a learner that is disabled in a case that they actually admit them. What happens? What happens is that Grace Nambuya feels like a second-class citizen in her own school. She feels left behind. This magnifies the differences because due to the separation, their peers end up seeing them and calling them and referring to them as a left-behind class for a time of 3 years. We contend that that's a very long time and the effects that these children have suffered are substantial, and we request that court makes a finding that this was a violation of their rights. We prefer a more inclusive means of reasonable accommodation. We contend that these disabled students should learn alongside their peers. We so pray.
Thank you very much. Because we are really time barred, we'll reserve our comments for the final. So I think I would pray that this court now gets dismissed so that we can prepare for the next rounds. Otherwise, thank you all very much, and we wish you the best in the next round. Oh yeah, we've been informed that there is tea for you, so yes, so please step out. You can go for tea and you have that.
These are yours? No, this is one.
Right. That's it. Thank you.
happens? At this stage, masitawag ako kayo. Ikaw, ano yung this time? Yung was the first. The second guy, sir.
Caffeine.
Actually, I'm busy here. I'm sitting up to the sheet.
91 plus 93.
Hello? I don't hear myself. Help me. Help me.
Is the person sitting there going to be speaking?
Yeah, they're going to be judging. But you can focus on these ones.
But I don't want the person to start talking and then there is no mic. So I want to put a microphone to the person.
Please put mics
Alright,
for
let me
both.
first stand.
Hello? Okay. So we are going to start our final right about now. All right. Let each of us get a seat. So my role here is simple. I am simply going to announce the judges who are going to be judging us for the finals. They will come and take their seats. And after they do, my very excellent tab master here, Umar, will announce the teams that are breaking to the finals. When those teams are announced, we will request them to come in front. They will choose the sides and then we shall have the final. All right. So, the first of our distinguished judges, who has been with us from the first preliminary round and who will be judging the final, is Mr. Kasivante David. Let's clap for him. The second, who has also been with us from the preliminary rounds, a distinguished lawyer and enrolled advocate of the High Court and subordinate courts there too, is Mr. Ruhayana Winston Churchill. The third, who is also a distinguished lawyer and a distinguished motor, who represented Uganda and Makerere University at the JESUP International Moot Court Competition, who won the All Africa Moot Court Competition in Egypt, who has also been with us from from the first preliminary rounds and was also among the best performing students in his year at Makerere Law School. None other, also the president of the Moot Society of Makerere University, none other than Mr. Edwin Sabiti. The next one requires no introduction. He's a distinguished mooter who won Moot since year one in law school. The first time I came to law school and I was asking who are the mooters, they told me, don't you know this guy? Eh? The best student, you see people fail LDC. I don't know. But the best student at the Law Development Center, Lira campus, who got a first class, is none other than Mr. Silas Onen. Oh, I forgot to mention, Mr. Kasibante is a PhD candidate. An expert in space law, the only one that we have in Uganda. And Africa at large, I've been told. He recently wrote an excellent paper that all of you should check out in the East African
Human Rights Project.
The East African Journal of Peace and Human Rights, on how stars, basically the proliferation of space objects, has affected the indigenous rights of ethnic communities in Uganda. I don't know how many of you have understood that, but that is the man who will be cheering her around. I also have the honor to introduce one of my greatest coaches in Moot, a very passionate man about technology law, a passionate man about law who spoke to you this morning and actually encouraged all of you to become lawyers and also join the law school. A man who has trained all of these people here. And they all owe their knowledge in Moot. All the questions they will be asking you, they derive them from him. He's the grandfather of mooting. Eh? In Makerere, in Uganda and East Africa in particular. None other than Mr. Nasa Konde. Oh, and Zambia. If he asks you questions, smile while answering him. He will be kind. And lastly, one of the most important mooters of our generation. The lady among ladies. I remember the first time I was in law school. Yeah. I think by that time she was around sorry. Guys, I've been with you so much, I'm now saying forms. She was in year 4. Yeah. And the first person who inspired me to start mooting, because I saw them win a moot court competition. Yeah. The first person who trained me with my teammate, she's called Prima. We were down there. Who is laughing? Let's be humble, please. Oh, the ones who are laughing, you don't get the joke. It's an inside joke. Yes, continue knowing. But she trained me and that girl, and we excelled in the moot court competition that we were preparing for. I owe my mooting career to her, which is an excellent one, by the way. None other than the most indomitable Martha Kawasinguzi Mweyonjere. We're glad to have you. Let's clap for her. Actually, let's give her a standing ovation as she moves Everyone stand up, guys, like, clap. Wait. This will be our most distinguished panel tonight. I've spoken many words, you must be tired of me. But before I go, I will invite the gentleman who has worked to make all this possible. This gentleman got a first class in his year in Makerere. First classes in Makerere are very rare. So rare. They're as rare as, what do they call it, an eclipse. Yeah? They've only become common in recent times. But in those years, it was so rare to get a first class. The gentleman who also proceeded to get a first class at the Law Development Center excelled in his studies. He proceeded to join Oxford University and obtained a Bachelor's of Civil Law. Thereafter, he joined Harvard University, obtained an LLM, a Master's of Law. And then he joined Pretoria University. All these are the best universities in the continents that I'm speaking about. In Europe, in the Americas, and in Africa. One of the most distinguished professors, if you may say that word, and lecturers in law. He's known all over the country. Some of you have read him. I've read his works if you get the Observer newspaper in your school. He writes a column called Constitutionally Speaking, which touches on some of the most pertinent matters in human rights. And is also the director of the Human Rights and Peace Center at Makerere University, the most premier human rights and academic organization in East Africa, in Sub-Saharan Africa, and also in the MENA region. Allow me welcome Dr. Businje Kawumba to join us here. Oh, he's a humble man. And he prefers to take the back seat. That is the nature of man we are dealing with. Humility in and out. But also greatness at the same time. Anyways, allow me hand over to Umar Wamboze to break your hearts. Oh, what? To break that? Not really. Allow me hand over to Umar, who will announce the finals. The people who have proceeded to the finals from the semi-finals. And then we shall proceed to have the final. Drum rolls, please. We hope he makes it fun and does not just give us the result. He's a boring man, but he will improve. All right.
Hello, everyone. Hello. So first off, apologies. I'm not as humble as Dr. Kabumba, so you'll bear with my voice one more time. Yes, I'm here to announce the breaks from the semi-finals. Yeah, of course, breaks, breaking hearts, stuff like that. So in the first room, where we had Egonda Ntende versus Justice Barishaki, where we had about 4 judges. We had one team score 166.166 recurring, and another team score 179.166 recurring. And the judges, on a consensus of 4-0, agreed that the team with 179.166 recurring proceeds to the final rounds. So my job here is simple, is to give you the name for the team with 179.166, which is that team, ladies and gentlemen, is Justice Egonda Ntende. or you can send a representative from one of the teams to come here. In the next room, courtroom number 2, where we had Justice Chisache versus Justice Nagawa. Still a panel of 4 judges. We had one team score 163.33 recurring and another score 174. And the team that wins the team that won rather in this particular courtroom makes the other team for the final round. Yeah. Still, my job is simple, as is boring, to give you the team with the name attached to 174, which is, guys, drum rolls. I don't hear them, so one more time. So the other team proceeding to the final round is, on a consensus of 4 judges, Team Justice Chisache. A representative from Chisache? So you won't be seeing this laptop again. We are closing it. So we have 2 ballots, so you'll choose one. Applicants, this is Chisache. Respondents. So Chisache will be applicants and Team Egona and Tende will be responding. Best of luck to the teams.
Yes, excuse me. Excuse me. Good evening. Yes, the session is going to kick off, and please would request you that you observe some silence. Yeah, so I'll now hand over to the clerk. For those standing, please get seated so that we can start our final round.
Good evening, everyone. You are most welcome to this final round, as earlier introduced. My name is Amperio Victor Rogaba. I'll be the clerk for this round. This is the matter of This is the matter of Grace Navunya and Samuel Katumba versus Nakaseke Bright Future School. I shall indeed hand over to the judges. Please indicate the time that you shall be using before you speak, as you've been doing, so that we can keep the time. Thank you very much.
Right. Thank you. Again, welcome to the final round of this moot. As always, the most entertaining outcome is the most probable. Yeah. So have fun, enjoy yourselves, and give us a show, and give yourselves a show. All right? So who are the applicants? Applying, responding? All right. Could we have a list of your names? Yes. Just list down in the order of appearance with the team code, so that we can reassure which teams are before us. Okay. And with that said, we are ready when you're ready. Please, the applicant. Yes, please. Oh, yes. Those of you who are rich enough to own mobile phones, could you kindly put them in silent or flight mode? Please observe decorum. It's not just for the people who are at the bar, but also people in the gallery. Please observe decorum. So we'll not be expecting you to walk around, move around, or otherwise disrupt the process. Okay? Once you sit, make sure that you're settled and you're not going to move once we're done with that. We're good? Right. With that said, let us have the applicant, please.
May it please this honorable court, I am Namirembe Juliana, the senior counsel for the applicants. Along with me, my lords, is my co-counsel Muzachi Alana. We shall divide this honorable court's time as follows. I will use 8 minutes to handle issue 1. My co-counsel will use 10 minutes to handle issue 2, reserving 2 minutes for rebuttal. My lords, I maintain that this honorable court has unlimited and original jurisdiction as provided in Article 50 of the 1995 Constitution. In addition to that, Section 3, which is read with Section 2 of the Human Rights Enforcement Act, describes this High Court as a competent court. However, my lord, my clients are claiming compensation of 70 million, which exceeds the pecuniary jurisdiction of the Magistrates Court.
However, I'm not sure what the probative value of that is. You said, however, your clients
are claiming a
Yes.
compensation of 70 million, which exceeds the pecuniary jurisdiction of the Magistrates Court, hence cementing
the
our,
Magistrates Court.
hence
Okay,
cementing
fine.
our case in this court, my lord.
But, counsel, is this a rights enforcement case, or you're more interested in compensation?
It is a right enforcement case,
Yes,
my
so why
lord.
exactly are you telling us about the value of the case?
It's because this case involves violation of human rights, such as a right to education, the right to respect and dignity of persons with disabilities, as stated in Article 35, my lord, Clause 1 of the 1995 Constitution, And yes, my lord.
Counsel, I think what he's driving at is the end goal for you to get the money, or is it for the enforcement of those rights? And why are we having the 70 million figure, for example, when you have rights violations?
No, my lords, it is
Counsel,
not.
Counsel, to further help you with that, if the value was less than 50 million, would this court still have jurisdiction?
No, my lord, because Section 2 of the Human Rights Enforcement Act states that the magistrate's court does not have jurisdiction over a court case that claims compensation of over 50 million.
Yeah, but counsel, you're in the High Court.
Yes, my lord.
You just said, I think you're confusing the two. Yeah, the reason why I brought the first question is that the pecuniary jurisdiction in and of itself is not in question. So you should not have gone there at all. Yeah, the High Court can hear, as you said, original jurisdiction in all matters. So it doesn't matter how much money you're asking for, it doesn't matter. That's not in contention at all.
Okay, my lord, I beg to withdraw my statement of the compensation.
No, it was a correct statement. The statement is correct, but it was just in the wrong place. But it's okay. Maybe if you could address the other question.
Counsel, to further help you, the High Court in human rights enforcement matters has jurisdiction regardless of the value of the subject matter. So if it's a human rights enforcement matter, then the High Court has jurisdiction regardless of the subject matter. You understand?
Yes,
that's what we're trying to drive you at, but at least now you understand it, so you can proceed with your arguments.
Yes, my lord. Without further ado, I will handle issue 1, which is whether the exclusion of my clients, Grace and Samuel, into alternative classes and the financial burden imposed on their families violates Article 21, 30, and 35 of the 1995 Constitution. My lord, my argument will center around 3 arguments, my lord. First of all, my lords, education is both a human right in itself and an indispensable means of realizing other rights as described in General Comment number 13 of the ICESA. With this, my lord, the applicants aver that their right to education, which is provided in Article 30, was violated by the respondents. Our Constitution provides that my clients have a right to education, and with this, we believe that the respondents did not fulfill this particular right in this regard. At Article 24, my lord, under the United Nations Convention on Rights of Persons with Disability, it provides for inclusive education. However, my lord, it is evidenced in paragraph 9 of the facts that my clients were told that they were going to be taken to alternative learning classrooms and hence moved to alternative learning classrooms. Inclusive education, my lord, is not about separate rooms. It is not about being given outdated materials as it was stated there. And my lord, I would want to make this court alive to the fact that outdated does not have a specific meaning in our books of law. However, the 4th edition of the Black's Law Dictionary explains outdated as something that is no longer in use. With such means, my clients cannot have an inclusive education. They are being told to use outdated materials. In addition to that, they have been taken to an alternative learning classroom, my lord, where they are referred to as a left-behind class, evidenced in paragraph 9 of the facts, my lord. This violates their right to education. This takes me to my second argument, my lord.
Counsel, before you proceed, inclusive education is your point, right?
Yes,
however, does inclusive education also take into concern the different capabilities of different learners requiring special treatment for each group?
Yes, my lord, it does take into account that different learners need different things. However, my lord, it is evidence that my clients were given outdated learning materials. Outdated means that there's a disparity in the standard that they're receiving, contrary to that which other students are receiving. Does that mean that Article 30 only complies with the other students that receive this quality standard, while my clients are not able to receive the quality standard that they deserve? I do not think so, my lord.
Counsel, are you conveniently ignoring the fact that these books were complemented by AI material?
I beg your pardon, my lord?
Are you conveniently ignoring the fact that this, what you refer to as outdated textbooks, was in fact complemented by AI material that perhaps one could argue meant that these students were in fact getting better and more quality education?
My lord, it is seen in the facts that my clients were taken to an alternative learning classroom with AI generated, yes, and the outdated learning materials. However, the other students were able to have this AI itself use it presently, in addition to the fact that there were teachers in those classrooms, but in no way were there teachers with the other students, my lord, because it is not shown in any of the facts, my lord.
Counsel,
Yes,
can one argue that the outdated material are in line with the progress of the students? Is there any way you can tie the material to the progress that some students, due to slow progress, require, let's say, edition 2 as opposed to edition 8 of a given textbook?
My lord, I really do not believe that if the others need something more, they're supposed to be given outdated. They're supposed to, if they require more, then they're supposed to be given something of standard to ensure that they are able to meet their right to education, my lord.
So the learning progress of someone has no bearing on the type of book that they should get? A slow learner doesn't require a lower edition than a
They do
fast
not
learner?
require something that is substandard because it is their right to quality education.
Proceed.
Thank you so much, my lord. This takes me to my second argument. The applicants aver that their right to respect and dignity was violated in accordance to Article 35, Clause 1 of the 1995 Constitution. My lord, Sub-Article 2 mandates Parliament to enact laws for protection of persons with disabilities. Hence, the Persons with Disabilities Act Cap 115, which provides inclusive education. My lord, Grace and Samuel dreamed of being part of their peers as they are studying. But when they were taken to what is termed as a left-behind classroom, they were ripped of their dignity and their respect. Yet it is provided for them as a right in Article 35, Clause 1 of our Constitution, my lord.
Wouldn't the respondent argue that that was in fact positive discrimination to give the students special attention?
Whereas the respondents may argue that it's positive discrimination is supposed to be taking forward steps. Yet they were not taking forward steps because they were giving my client substandard quality, my lord.
Counsel, what would you rather that should have been done in this instance?
My lord, I would rather that my clients would have been assisted with sign language helpers in the other smart class AI classes alongside these other children, because that would make them feel included in the education. My lord, education is not just about learning material, but it's also about the experience of learning from your peers. When they're excluded, they're unable to learn from other people as they ought to be in regulations with Article 30, my lord.
Please proceed.
This takes me to my third argument, my lord. In the words of the renowned humanitarian and diplomat Eleanor Roosevelt, where after all universal human rights begin, in small places like homes and schools, the exclusion of my clients was a violation of Article 21 of equal protection in all spheres of life.
What is the value of Eleanor Roosevelt's words that you've just referred to?
My lords, it is just an opening statement to open the House's mind on the fact that human rights begin in the smallest places, such as schools and those alternative learning classrooms. That is also where our universal human rights begin. The exclusion of my clients was a violation of Article 21 for protection. My clients have not been protected as the alternative learning classrooms have been a field or a route of discrimination and further bullying. When my clients assert that they feel like second-class citizens. With my time first spent, my lords, it is our prayer that the respondents be held that their actions were a violation of Article 21, Article 30, and Article 35 of the 1995 Constitution, with a compensation of 70 million to the applicants and a public apology for the psychological torture that my clients suffered in those alternative learning classrooms. Much obliged, Your Honor. I submit.
Ladies and gentlemen of this honorable court, my lords and our learned friends for respondent, as earlier introduced by my co-counsel, I am Muzachi Alana Chirabo, and I'll be addressing issue 2. My lords, I am here to demonstrate that the collection of biometric and personal data without consent violated the right to privacy. Under this issue, I'll be fronting 3 arguments. Argument 1 is that the collection of biometric and personal data without consent violated the Data Protection and Privacy Act. Argument 2 is that the same collection of biometric and personal data violated the ICCPR. Argument 3 is that the respondents' actions did not pass the test of limitation under Article 43 of the Ugandan Constitution. My Lord, it is the applicant's submission that the respondents' actions of collecting data without consent of the parents violated Section 8, subsection A of the Data Protection and Privacy Act, which states that no one will collect prior consent.
Council, when
Yes,
you
please,
mentioned
Mayana.
that there is no consent that was given, yet in paragraph 2, the Ministry of Education rolls out this program in this specific school. Secondly, by virtue of the fact that parents actually brought their children to these schools, it seems to me that there is prior consent, given the fact that they are not required to give any other written consent in regards to the curriculum, the meals provided by this school. I'm wondering what's so special about this consent that was required when it's not given on other services that are provided by the school.
My Lord, I'd like to first address your first question that's saying merely bringing a child to school does not amount as consent to take their data anyhow. My Lord, especially since we're dealing with AI, which is a high data security risk technology. And secondly, addressing the issues of the national curriculum and the meals provided by the meals provided by schools. These are duties done by the school. The parent has taken their child so that the school can fulfill these duties of feeding them, of providing for them a right curriculum, and the curriculum falls under the
Council.
government of Uganda. Yes, please, mate.
Question. Do parents always have to have a say in the means or the mode of teaching that is offered to their kids that they take to school? Or can the school make the determination?
Council, further in line with that, is there a distinction between consent to curriculum and consent to the data that is taken from students?
I think the determination of school meals should be held by the school because the school knows its budget and it will plan according to that budget, as well as the curriculum. My Lord, it is not of the school, but it is of the state. So if the government imposes a curriculum on the school, then the school is under duty to perform that curriculum. And addressing your issue, my honor, would you please repeat your question?
Is in line with, is there a distinction between obtaining consent for curriculum and obtaining consent for data obtained from students?
Yes, my Lord. This is because data can be used anyhow. We have seen instances of people forging nudes, of people forging pornographic videos from this very data. Yes, the national curriculum is a decision made by the government, but whatever happens with this data may damage the mental health of a child, which no one would want.
We agree with you. However, still to the question, you have the ministry saying we are rolling out this system of learning, and we are saying, to your own admission, if the curriculum is from the government, then the school should in fact implement. So what happens in the case where the implementation of said curriculum requires the collection of data for the system to work? Do parents need to give specific consent in such cases, or can the school just proceed to implement by collecting data and implementing said curriculum?
My Lord, could you please rephrase that question for me?
The question is simple. Do parents need to give extra consent in cases where the school is just trying to administer a curriculum that has been imposed onto them by the state? The point being, the collection of data in this case was in line with the requirement for the smart AI classes, right? So did parents need to give specific consent for their kids' data to be taken before the school rolls out this AI technology?
Yes, my Lord, the parents needed to give consent.
Yes. Why? And that's what we want to know.
Because the education of a child befalls both on the state and on the parent, as of Article 34, Clause 2 of the Ugandan 1995 Constitution, meaning that the parent should be held accountable for the education that their child is receiving. And if the state is implementing a curriculum, then parents should be aware of how this curriculum would work.
Council.
Yes, please.
Would I be right to say that you're trying to put the right to privacy at the same footing with the right to education, and I find that problematic?
My Lord, I'm not putting them at the same footing. I'm saying that the right to education has extended its limitation on the right to privacy.
In what way?
My Lord, in the Supreme Court case of Charles Onyango Obo versus the Attorney General, it was stated for a limitation to be held that it must be lawful, that it must achieve a legitimate aim, that it must be necessary, and that it must be allowed in any democratic society. My Lord, whereas I understand that the Data Protection and Privacy Act is a law and the objective is education, Requirement 3 and Requirement 4 were not met. On the necessity, the Supreme Court in Charles Onyango Obo versus Attorney General stated that for any limitation to be necessary, it must be proportionate. The respondents collected a lot of data which is more than necessary for education. For example, they collected fingerprints and voice recordings which were not accounted for in any of the facts. They only accounted for facial scans which were said to monitor attention in class and to monitor attendance.
The respondent would argue that the fingerprints and voice recordings are being collected for the mode of examinations that these AI tablets are going to use for the integrity of the examination.
My Lord, I'd use the analogy used in the Supreme Court case of Charles Onyango Obo versus the Attorney General, that the state should not use a hammer to hit a mosquito. They have overly done the collection of data without accounting for any of the data that they have collected.
And so, on proportionality, what is your view that perhaps the state could have sought consent, that being the less or least intrusive way or measure that could have been adopted, as opposed to just doing whatever they did without seeking prior consent of the parents?
Counsel, further to that, the respondent could argue that the logistics involved in getting that consent would be tedious and lengthy, hence justifying the need to roll out the program since it's a pilot anyway and won't be that harmful. So for example, imagine a parent reporting to Gayaza with their daughter or any other school in the country, and at the entrance they are required to sign a consent form, as opposed to maybe the school saying, look here, let's see if this works. And if it works, then we can go to the parents and get the consent. Would everyone argue like that?
Could you please help repeat your question for me, my honor?
What I'm saying is that the respondent could argue that the logistics involved in getting the consent, okay, would mean that the project wouldn't go ahead. So they said that since it's a pilot, let's test and see how it works. If we define that it works, then we shall get the consent for the actual system rollout. You understand?
Yes. My Lord, I believe that any parent would want to see their child succeed in school, to receive education that is more than substandard. So I don't think that asking for consent is tiresome or tedious, as you said. I think that it is necessary because a parent needs to know what's happening in their child's life. A parent needs to know if their data is being collected, because you never know what could happen with this data, as I earlier stated. Your Honor, could you please help me repeat your question as well?
My question was simple, that the proportionality test that you make reference to requires that the measure of interference that you adopt should be the least intrusive of the available alternatives. And my question is, do you think that asking parents to consent was the least intrusive measure that perhaps the state should have adopted?
No, I do not, Your Honor. May I proceed to my argument?
Please.
Under Requirement 4, I'd like to inform my lords that no democratic society would allow excessive data collection of minors, especially if it's being stored on servers outside of Uganda.
I'm sorry. You keep speaking to excessive collection of data, but what test are you using to determine that?
My Lord, I am going to refer you to paragraph 5 of the facts that said that the facial scans were used to monitor attendance and attention in class. My Lord, it is the only form of data that is accounted for in all of the others that have been collected.
Thank you. Does the data collector or even processor need to always account for the data that is being collected? And where does that obligation come from?
Yes, my Lord, I think that the data collector should always account for the data that is being collected, because at the end of the day, it's not their data being collected. They have no right over the data that is being collected.
Where does the obligation come from?
My Lord, I have not addressed myself to that question.
Counsel, do you happen to understand the principles of data collection? And do you know where those are found in the Data Protection and Privacy Act?
My Lord, I know that they are found under Section 7, but I do not know the principles of head. So if you may allow me to look through my resource back.
Counsel, what we're trying to ascertain here is that a data processor has obligations, okay? And one would argue that accountability would be that obligation. So, in your view, how accountable should a data protector be, given that you say that the data doesn't belong to them? So, in your view, what kind of accountability should, let's say, a company like MTN give you for what is obtained from you via your national ID?
I think that MTN should give me in detail the data that they're collecting, so that at the end of the day, if I was to ever complain, I already knew that MTN already had my data. So it would lessen the work of MTN if it just gave me the data it was collecting, and we could end hearings like this on data collection and data privacy. Imagine if the Nakaseke Bright Future Secondary School had asked for consent. We would not have come to this hearing to be addressing this issue.
Counsel, are you saying that giving consent waives all the rights of complaining from the effects of collecting that information?
No, my Lord, but I'm saying that it reduces the amount of complaints that are going to be made.
Yes, my question was about your complaint that this data is being stored outside Uganda. If you look at that part of the facts, they say this is just a rumor.
My Lord,
I find it problematic that you want us to base our decision on rumors.
My Lord, the fact that such an outrageous rumor has not been responded to is an adverse inference, which means that it is a dangerous hint to something bigger. Why haven't the respondents addressed this issue if it is not true?
Proceed.
My Lord, I'll now proceed to the second head of argument. My Lords, the applicants aver that the respondents' actions of storing data outside Uganda, contrary to Section 19.
Your time is up, but just
make my prayer.
Summarize the argument and then you make your prayer.
Okay. Contrary to Section 19 of the Data Protection and Privacy Act, that section requires that before data is stored on outside servers, that it must have the data subject's consent, and adequate measures must be put in place to store this data. Under paragraph 6A of the facts, it is seen that the respondents did not seek consent, neither is there any evidence to adequate measures of protection. With this, my Lord, I hereby pray that this court grants us a compensation, the applicants a compensation of 70 million, and that the collection of biometric and personal data was deemed to have violated Article 27 of the 1995 Ugandan Constitution. Much obliged, Your Honours.
Thank you very much. Respondent.
Very much obliged. May it please the court. My name is Iga Eric, and I'm appearing alongside my co-counsel, Roman Asmero. My obligation today, within 10 minutes of this court's honorable time, is to address issue A of this case, and within 10 minutes still of this court's honorable time, my co-counsel will be handling issue B of this case as well as saying our prayers. Before I present, my lords, I seek leave of court to make my opening statement. Thank you very much. What stands before this court is not injustice, it's a very difficult balance between rights and responsibility. The case today is not about neglect. It's about the respondent, Nakaseke Bright Future Secondary School, trying its best within its financial and technical limits to see that every child gets the best that they're entitled to. My lords, I'm going to be addressing whether the measures taken for children with disabilities, including separation into alternative classes and the specialized devices presented as an option, represent reasonable accommodation and progressive realization within the school's financial and technical limits. We contend that they indeed do. And to that, we have two heads of argument. The first about reasonable accommodation, but second also about progressive realization. But first, I want to respond to some of the issues and contentions that were raised by the applicants in today's case. First, they come and tell us that the exclusion is discrimination, separation is discrimination. And to that, they say this is because these children are having outdated material. The AI systems don't match the AI data, and the extra financial burden imposed onto these parents. Chair, my lords, separation is not discrimination. Let's get into the facts. According to Article 21 of the Constitution of Uganda, Clause 3.
Council, how do you reconcile that argument with the leading case in the world on the separate but equal doctrine, which is Brown Board of Education versus Topeka, where the Supreme Court of the US said that providing separate schools for black students from white students was separate but unequal, hence being unconstitutional. So how do you justify a separate classroom in a school where a court somewhere in the world is saying a separate school is unconstitutional?
I'm very much obliged, my lord. That brings me to the next submission, which is, in the case of separating blacks from whites, it's discrimination. Why do I say so? Because this differential treatment is based on grounds of race. That is to say, if you're black, even though you're better than the whites,
isn't doesn't discrimination recognize disability as a ground?
yes, my lord, and it recognizes that in Section 4, subsection 1J of the Child Act. However, as I submitted earlier, discrimination is supposed to be on grounds of that particular aspect. That is to say, in the case of the blacks versus the whites, in the case stated by our dear honorable judge, this differential treatment was attributed specifically to race. That is to say, you're black, I'm white. We don't deserve to be in the same place. What happens within the facts? These children are not separated because they are disabled. They are separated. The grounds for this separation is to help them, is to provide them with extra help.
Counsel, why were they separated from their colleagues?
They were separated from their colleagues in order to help them learn better.
Why did they want to help them?
They wanted to help them because they were disabled and because they were unable to use the AI tablets.
So it was because of the disability that they had to separate them?
Yes, my lord.
Okay, then we can proceed.
Counsel, if we were to agree with your argument that the basis for separation was not discrimination, is discrimination only defined at the point the separation is done or at the effects that the separation actually causes, like them being called second-class students or those who are left behind? Isn't it discrimination even at that point?
My lords, it is discrimination at the point that they are called the left behind class. However, when you look at Article 21, sub 6, clause 3 of the Constitution, it's differential treatment. That means that if the school carried out this separation on grounds of helping them, that does not account as discrimination from the school itself. To add more to the issue of discrimination, I will go into my first head of argument, which is reasonable accommodation.
Yeah, Council, before, okay, yes, as you go into your first argument, especially on reasonable accommodation, I want you to, in addressing that, to show us how giving them outdated materials is reasonable, and then the alternative of requiring them to pay more money if they are to access this service. Just show us how reasonable that is.
Very much obliged, my lord. If I may, I would like to start by stating the legal instrument I'm going to be referring to and further diving into the logic. Reasonable accommodation, according to Article 2 of the Convention on Rights of Persons with Disabilities, read together with General Comment Number 6 on Equality and Non-Discrimination by the Committee on Rights of Persons with Disabilities, provides a four-part test of what reasonable accommodation is supposed to look like. The first is that it should be interactive and flexible. Second is that it should be individualized. Third is that it should be timely. And fourth is that it should be proportionate. In this case, proportionality means that in as much as it needs to balance the needs of the person it's targeted toward, it must fall within the provider's capacity. We contend that Nakaseke Bright Future is a poor school that have limited resources. That is attributed in the low pass rate. The low pass rate is an indication of underlying problems such as shortage of teachers, shortage of learning materials, and all that, That means that they were doing whatever they could within their reasonable capacity as a poor school to accommodate these students by separating them from these classes where they couldn't benefit and putting them where they could help them better. Secondly, on that submission, why we think that this kind of separation is good in and of itself. These classes were made for these students to have translators such that they can help them understand what these AI tablets are actually doing, putting them at the same level as the other students that were learning in class.
Council, does the court consider, in terms of obligations, what a party meant or what a party did? So, in that context, I can give an example of my mother. She would beat me for what I did, but not what I didn't intend to do. So, should this court look at what you intended to do, or should it look at what you did?
My lords, according to the facts, it is stated that these students were put into separate classes with special help. That special help means that the school targeted these students particularly, putting them in classes where it was able to better help them in means such as providing for them teachers to interpret this AI data. Does that answer your question, Honorable Judge?
What I'm saying is that as a courtroom or as a judge, I would prefer things that are tangible, things that I can feel or see. It would be hard for me to read what you intend to do as opposed to what you've done. So from what you've done, what shows that you have good intentions? From what you've done, from the facts, what have you done that can at least tell us, look here, we are resource constrained, but in future we shall do better. Because for you to say, I'll do better, you must at least do something now.
My lords, according to paragraph 1 in particular and paragraph 4, there is a 46% increase in pass rates. That is something positive that has been achieved by this. In addition, according to paragraph 8, the head teacher assures the parents in a Parents-Teachers Association meeting that the ministry is exploring inclusive upgrades in the next phase when the special devices are going to be launched and they would...
Yes, so thank you for that, Council. What is stated under paragraph 10, the very last sentence?
The Board of Governors, the very last sentence.
Yeah, from in addition.
They exclude these children's results from the school statistics to avoid distorting improved national rankings. However, this exclusion is not still based on the fact that they are disabled. This is a pilot study. That means that we are going to give you an AI tablet and we want to assess its benefit, its effect on you as a scholar.
No, my point is that the improved performance you're telling us about appears to be a smokescreen because you've excluded these students from the statistics.
If I may, my lord, the exclusion from the school statistics represent the people that were using AI tablets. That is to say, the class that was studying along the other learners that were using AI tablets and had no problem. They were the test subjects of this pilot study. However, the disabled students that were separated into alternative classes, not because they wanted to discriminate against them for being disabled, but because they wanted to help them better in a system that was not favoring them. These students were not test subjects for this pilot study because they weren't using specialized AI tablets. They were simply being taught with teachers using AI materials and some outdated books.
Counsel, what my learned brother is trying to point at is that if you're excluding some people from your statistics,
yes,
why should we trust the other statistics? Because the others could also be something that you're giving us to make us happy. So what kind of assurance can we have that the improved performance is genuine to justify your separation of those that are not improving to improve them? Because the separation could be a reason of something else, because we are not sure even the improvement is genuine. Because if you're removing those that are not doing well, what makes us believe that you're not including others that are not doing well, but you're making it look like they're doing well?
My lords, if I may, I would like to use an example to explain the matter. The example I'm going to use is about a company trying to introduce a new headset technology on the market. What they do is that they get a group of 100 people and they want to test their technology on them. So they give each and everyone a pair of headsets and they ask them for the quality of the music. However, some of these 100 people that are listening to this music are unable to hear. Therefore, they are excluded from therefore their results are excluded from the statistics when they're publishing their report. Does that answer your question?
Proceed.
My dear Honorable? Yeah. I would like to proceed to explain Article 2 of the Conventions on Rights of Persons with Disabilities, which is that reasonable accommodation shall not impose disproportionately on the provider. That is to say, as already explained, it's not right for reasonable accommodation. My lords, I please request 1 minute to conclude my case. It's not proportionate to this school because it's poor and it's imposing disproportionately on them. My lords, we pray that this honorable court makes a finding that the respondent realized the rights to the best of their abilities, given their limited resources and capacity. The exclusion of students from the normal classes wasn't based on the reason of discrimination. These students were excluded as a means to help them better within the society that they existed. And furthermore, we've achieved a 46% increase within 2 years of introduction of smart class AI system. It's a pilot study. That means there is room to make mistakes. However, the essence of this is that we can improve these mistakes when the real project is actually being launched. If I may be of no further indulgence, I seek leave of court to yield the floor to my co-counsel.
Please. Thank you.
You're very welcome.
Much obliged, my lords. My name is Herman Asmerum, second counsel for the respondent, and I'll be using 10 minutes to submit our case and make our final prayers. My lord, I'll be handling issue B. My lords, I seek leave of court to make my opening statement.
You don't need to, just proceed to.
Much obliged, my lord. My lord, I'll be handling issue B that states whether the data collection is lawful, necessary, and proportionate and serves legitimate aims such as promoting education, safety, and preventing exam malpractice. My lord, as counsel for the respondent, we indeed contend that this is lawful, necessary, and proportionate and serves legitimate aim. Under two heads of argument. A, the right to privacy isn't absolute, and B, this passes the permissible limitation test. My lord, I proceed to our first head of argument. The right to privacy isn't absolute. My lord, under Article 27 of the Constitution of Uganda, which protects the right of privacy just like our applicant submitted, however, this is as well read alongside and interpreted by Article 43, Clause 2C, that states any limitation shall not be beyond what is acceptable and demonstrably justified in a free and democratic society. My lord, this is further evidenced in law case of Charles Onyango Obo and Anor versus Attorney General, Constitution Appeal 2 of 2002. This is very important or evidenced in our facts of paragraph 5 that states that already Nakaseke is within the Uganda premises, which Uganda concedes to be a democratic society because of the constitution. But then also too, we submit that this has been done for the good of the education sector to monitor the attendance as well. My lords, I proceed to my second head of argument, that is...
No, before you proceed, just because it's for the good, as you say, it's going to promote education, does that mean that you bypass consent?
Much obliged, my lord. My lord, due to the social contract that citizens who are part or under government has the absolute powers over their rights, we submit that privacy isn't absolute because at the end of it all, this is for their better goodness of their children's interests.
Counsel,
my lord?
Counsel, are you saying that in the sense of a social contract, what we understand as a social contract is that the citizens elect the government to serve them?
Yes,
so
my lord.
If the citizens, including the parents, give a mandate to the government, how best can the government include the parents in decision-making process?
Much obliged, my lord. Yes, parents elect the government. This simply means that it's democratic, as I stated above, but then also parents have a lot of trust within government. But secondly, they didn't give the consent simply, just like our applicant submitted, because the process through which the consent is going to go will not provide immediate effect. My lord, we see this that in paragraph 1 from 21%. Yes, my lord.
What was the rush on your end?
Well, my lord, this was a pilot survey and it needed to be done in order to implement.
Did it need to be done immediately to the extent that you do away with consent?
My lord, the effect of this was that it improved from 21% to 67% in a short time, but also this pilot study...
And should we then take the improvement of results above constitutionally guaranteed rights?
Much obliged. As long as the violation passes the permissible limitation test, then we submit that because it's for the betterment of the children, then we deserve to take it ahead.
Okay, thank you. I think it's good that you mentioned the limitations. However, before you get to the limitation provision in the Constitution, right, you need to first deal with the general rules that are set out in the under the different provisions that provide for the different rights in the Bill of Rights. So, did you even attempt to get consent first before you move to the limitation? You can't just jump to the limitation. The limitation is, in fact, an exception to the general rule. So you can't just jump to the exception unless you have very specific, concrete reasons for doing so. So that's what we want to hear.
Council, in simple terms, okay? When you have an agency, okay? Let's say I'm trying to get married tomorrow, and I need permission from my parents to get married. At the moment, my parents are in London, so I can't get permission from them. You understand? So can I go to a mosque tomorrow and I tell the sheikh, you know what? I know you need my parents' consent, but they're not in the country. Let me reverse it. Supposing my parents are in the country, they're at home chilling, and they don't want me to marry the person I want to marry. And I know that. So I don't bother going to them because I know they will say no. So I just go to the mosque and tell them, you know what? My parents died. Can you marry me? So in that scenario, okay, should the government say, look here, this is a pilot study, let's see how it happens, then get the consent? Or should the government say, let's try to get the parents, and those that accept, we do this pilot study on their children. Those that say no, we let them go. Do you think that is better?
Much obliged, my lord. My lord, addressing the first question of why jump, we believe that at the end of it all, it's for the betterment of the education sector. But then, to respond closely to your question with my lord's question of why jump, we believe that mere fact or by default that a parent takes their child to the school simply means two things. A, they believe in the authorities of the school and as well as the government that is passing that rule. Meaning, consent has a longer path that it has to take, yet this is something that needs to be taken urgently. But then two, we believe that due to the stereotypes that exist within society, parents, not largely, but to minority, could refuse this, yet this is in better interest of the people. My lord?
Wouldn't it be well within their rights to actually decline to give you consent?
Well, I believe that some of them, out of ignorance, may refuse. Therefore, the government is in better position to do this for the best interest. My lord?
Council, you talked about the test for limitation.
Yes, my lord.
Address us on that test and demonstrate to us how you passed that test.
Thank you, my lord. My lord, just to highlight, the applicant came here and said that we did not pass the limitation test. However, they did not efficiently show us how that was done, so we cannot base on their case. Back to my argument, that is where I was heading to argument 2.
No, address us, demonstrate to us that your limitation was justified.
Yes, my lord, that's where I'm proceeding. So, the permissible limitation test is a 3-part test under lawful, legitimate, necessity, and proportionality. Under lawful, this is seen under the Syracuse principles that the right to privacy may be limited under situations in Section 7, subsection 2 of the Data Protection and Privacy Act, which is by a public good for by a public body for a public good. Therefore, this is further evidence in paragraph 2, Part A, which shows that the Ministry of Education, which is in charge of education and is a body, did this.
Address us on what is most contentious. I believe it is the necessity and the proportionality component.
Yes, my lord. To the point of necessity, this simply means that it's needed to achieve a legitimate aim, which we show you is education. This is further got from Section 7, subsection 2 of the Data Protection and Privacy Act, that no data is to be collected unless authorized by law. This has been authorized by law. But moving forward, under the general comment on general comment number 25 on children's rights in relation to digital environment by the Committee on the Rights of the Child, paragraph 67 states children's personal data on process to offer educational, health, and other benefits to them. This simply means it was in the best interest, and according to paragraph 67, it shows the necessity. My lord,
Council,
it's...
Yeah, given, if we are to believe that, but the applicant made an argument that I would like you to respond to. They say that
Yes,
you're collecting too much data.
Well, My Lord, we believe that is not too much data. To break it down, that goes to the proportionality part of it. The facial recognition is used for monitoring the attendance and the attention span. The biometrics and the fingerprints are used to monitor the exam malpractice.
Let's go one by one. Don't you find monitoring someone's attention span very intrusive, especially for a child?
Well, my Lord, in my first head of argument, I said the right to privacy isn't absolute. So, infringing on their right for a better cause.
Yes, we have moved from that, but now we are interrogating the proportionality of that and how intrusive it is.
Yes, my Lord.
So here you're monitoring a learner's concentration span. Couldn't that be achieved in some other means?
No, my Lord.
So especially with paragraph 6b indicating that with this information being collected, predictions by these machines are being made and predicting that these students will most likely not to succeed beyond a certain education level, which can be very discouraging and clearly not in the best interest of that child.
Thank you, my Lord. Much obliged. To answer your Lord's first question of, isn't that too much? I believe this is not too much because at the end of it all, it's not excessive and arbitrary. This is got from Article 17 of the International Covenant on Civil and Political Rights under the Syracuse Principles. It says that it shall not be excessive or arbitrary, but proportionate. And in this case, it has been proportionate.
I'm going to give you an example. From this competition, imagine we monitored how your colleagues in the gallery are paying attention to you while you're submitting. That's his attention span, right?
Yes, my
So how
Lord.
would that benefit this moot court competition?
Thank you, my Lord. Your question answers her question. Monitoring the attention of the children.
Counsel,
Monitoring.
the gallery, please be calm. We are here to learn. So what I'm saying is, okay, the attention span of the students
Yes, my Lord.
may be a good thing, right? But don't you think that attention span and performance are not correlated? I'll give an example. For most of my high school life, I was a backbencher, okay? I don't think I paid attention in any English class, but I had a D1 in English. So my attention in an English class had no correlation with my getting a D1 in English. So one could argue in this particular set of facts that attention span, in as much as it may be a good thing, it doesn't determine how someone performs better or less. For example, some students have autism, okay, which means that they are never attentive in class, but they're very good at math and they pass math. So do you think that it is right for the school to monitor attention span? Don't you think it would have been better for them to limit it to classroom attendance? At least that one is measurable, because if someone is not in class, they won't learn.
Much obliged, my Lord. We submit that they shouldn't use only the roll call or attendance because now it's a new system that's being introduced, the Smart AI Classroom. But how attention works hand in hand with performance is the level to which a student pays focus in class is to what extent they perform well. Therefore, why this monitoring is important is teachers are able to know the weaknesses of their students and now find possible solutions on how they can help them. This is why now the alternative classroom has been created, not for the people that have disabilities, but for the people that are unable to study with the rest of the children. I hope your question is answered. My Lord.
I have a question that I asked the applicant. Proportionality in this instance, don't you think it would have been less intrusive had you asked the parents for consent?
Much obliged, my Lord. To answer your question, I believe that consent could have been the less intrusive, but it wouldn't achieve the aim within today's case.
How did you determine that it wouldn't have achieved that? And second, what entitled you to a yes from the parent?
My Lord, By default, that parents took their children to school simply meant that they consented. However, why we did not take the longer route is because we wanted to handle this urgently to improve, and this is evidence in paragraph 1 and 4. My Lord, to answer your question of predictions, indeed, true, it shows them their future prediction, but it has benefits and harms. For those that it shows their future is going to be bright, they are motivated to keep working hard and to be better. For those which it shows that their future isn't going to be bright, now teachers find a possible solution to make sure that they work towards making their future bright. Therefore, inclusive education is then got. My Lord, I proceed to make our prayers. We therefore pray that this court to make a finding that the data collection is lawful, proportionate, necessary, and legitimate. Our final prayers for the respondent is that this honorable court, firstly, declares the respondent's collection of biometric and personal data of students was lawful, legitimate, and constitutionally permissible, and we prove this, which applicants failed to do that. Secondly, dismiss the applicant's petition in its entirety with costs of 70 million because they fail to show us its importance. And thirdly,
I'm sorry,
affirm.
Just on that prayer, just a little. Would you help this court understand why? I mean, you said that you've been making a very passionate argument that your state, I mean, the school is very sympathetic. It really does care so much
Yes,
for
my Lord.
human rights and all of this. And yet you're asking the court to penalize the students with disabilities with 70 million. They could not afford 1.5 million to pay for the tablets. But you want the court to penalize them with 70 million. Do you think that's a fair thing to? Does it show that you really care, or you're now mad, you're pissed? You want them
Much
to know?
obliged, my Lord.
Yeah?
That is not what I intended to say. I intended to say that the applicants want a compensation of 70 million without showing us the necessary importance as to why we need to give them
But
that.
you just said the court should penalize them.
No, my Lord.
I
said-
did not hear you well. His Lordship
I am
is a
sorry
bit deaf.
for my...
Did I get that right?
Counsel, in further to that, do you think that this court ordinarily should award costs in human rights matters, given their public importance, or to improve constitutionalism and to enable people bring public interest cases to court? This court should, in some instances, say, let the costs wait. This was very important for us to address, and maybe another time.
Much obliged, my Lord. I believe that is according to the rule of the court to be ruled whether they should consider the human rights first or the cost. I proceed to make a second prayer, which is dismiss the applicant's petition in its entirety with costs. And lastly, affirm that educational institutions...
So just quickly,
yes,
as-
my
as
Lord.
you wrap up on that. So I'm having a little bit of trouble with this whole costs thing, yeah?
Yes, my Lord.
So dismiss the matter with costs, yeah?
Yes, my Lord.
Costs to who?
My Lord, we submit that the costs weren't submitted by the respondent
Yes, I'm
to the
saying, so
applicant.
if you say dismiss with costs, means
Yes, my Lord.
that the applicant should pay you the costs of these proceedings, okay? So it's basically saying they've really wasted our time. We would have been somewhere else doing something else. They've wasted our time, we've paid lawyers, so they need to pay us for the time that we have lost. That's what costs really means.
Much obliged,
So-
my Lord. That is not the intention of the message. The message...
So you forgive them? If the court finds, do you forgive them and you're like, okay, fine, we get it, let the costs lie where they fall, let each one of us bear their costs and we are good, kumbaya.
My Lord, according to the case that has been presented before the court, I believe the judges will make a fair hearing.
Oh, beautiful. What was your last
Yes,
What was your
that
last?
is where I'm proceeding to.
Hmm.
To affirm that the educational institutions in implementing reasonable and proportionate dictator systems act within the permissible limitation of rights to safeguard students, maintain accountability, and promote well-being. My Lord, we so pray.
Thank you very much. You've been. Thank you very much for that very passionate presentation. We have a rebuttal. Thank you. Remember that in rebuttal, you're responding to what they have said and you're not introducing any new arguments.
Yes, my lord.
Thank you.
Much obliged, your honors. Whereas our land friends, the respondents, argued that the alternative rooms were not injustice, my lords, justice is not disparity in standards, nor is it being excluded from the school's national rankings as my clients were. Hence, this is discrimination on grounds of disability, my lord, which the respondents failed to acknowledge. The respondents also failed to account for the fact that they did not provide protection for my clients, which is provided in Article 21 of the 1995 Constitution, my lord, as the alternative learning rooms were being termed as the left behind class, which was never dealt with by the school, yet it is their obligation, my lord. In addition to this, whereas we acknowledge that the school, Nakaseke Bright Future Secondary School, has resource constraints, it was not in order that my clients were asked to contribute 1.5 million. My lord, students that go to government-aided schools are not of those of wealthy backgrounds. The requirement that one has to that one is made to pay for what is nature is absurd and violates Article 21, which is supposed to be protecting persons with disabilities. It is therefore with this that I note that my client suffered psychological torture because the state and through the school failed to protect the people with disabilities, my lord. With therefore, I submit. Much obliged, your honors.
Thank you very much. With that said, I believe that we have come to the end of the litigation process. Congratulations to all of you. I for one, have had a very entertaining, as I said, the most entertaining outcome is the most probable. I've had a very entertaining time, so thank you, each one of you. So the judges will now retreat to compile their marks and come up with a decision. So thank you very much once more, and this matter is now adjourned.
Okay. Thank you so much for that amazing round. Let us clap for our finalist teams. Uma Trife and Boise. Uma Trife. Okay. So we are now going to proceed to give the awards to the schools. So those, we have certificates. We also have an award for the best oralist. Yeah. But before we do that, I'll request everyone to sit. I request everyone to sit. Thank you. Allow me, let us give a standing ovation as we invite Dr. Wesenje Kawumba to give us his remarks.
Maybe here. That's fine. Good evening, everyone. It's a very difficult thing to stay from morning until this time. What time is it? It's now 9:15. So even just in terms of stamina, what you have done is it's quite impressive. Now I'd like to start by, I don't know, should I thank you, the Mooters, first, or the partners? The partners. Okay. Maybe let me start by explaining what this whole process is about. I think in the morning there was orientation and there was some explanation about that. And I think in the course of the day that has become apparent. What this is not about is winning. It really isn't. I know there are trophies there and there are plaques and there are, awards. But it's really not about winning. It's really about a pedagogical method. Some call it clinical ego method, but it's about a kind of pedagogy, a kind of teaching that doesn't involve teaching. That doesn't involve a lecturer or a teacher standing and talking to a student or a learner. Rather, it is an interactive participatory process where you discover for yourself by doing. And by doing, you're thinking. And by thinking, you imbibe the ideas that you're articulating. So it's an idea of a different kind of pedagogy. That's really what it's about. It's not about, and for many of you, I think the real value of this evening's process will become apparent 10, 15, perhaps even 20 years from now. Some of you might become lawyers, but some of you may go on to do many other things. Because the law it's about logic. I think it was Holmes, one of the judges, who said the life of the law has been experience, but also logic. And some of the greatest lawyers have been mathematicians. The example that's normally given is Denning. That what we've been talking about is the logic of argument that you'll carry with you to very many other contexts. So, regardless of what you do in life, the skills that you have demonstrated here and that you've been practicing over the course of the past couple of weeks as prepared are valuable. It's about identifying principles, certain values, in mathematics, first principles, for those of you who are mathematicians, and then you derive from those principles, you apply them to changing facts and you distinguish them, and does it apply here? If does this principle, ideally a principle should apply in all like cases. So if it applies here, why should it not apply here? And you distinguish, you logically apply your mind to that particular situation, and you convince the other party about the correctness of your position. So that logic is important regardless of what you're going to do in life. So that in itself, it's an intrinsic value of this process. It's important by itself without and beside the trophies or other awards. Now, relatedly, it's also about the importance of talking and working through disagreement, through dialogue. That's also important, especially now in a context where Sudan is on fire, right? It seems the world is on fire because people have failed to talk. People have failed to work through their disagreements logically. So that's also quite important. Also, learning how to deal with contestation. of course, I know the judges have been disturbing you, they interrupt you, the questions come at once, and you have to keep calm, collected, and respond respectfully, even if you believe that the questioner that has just asked has no connection whatsoever with what you just said. Diplomacy, the art of speaking respectfully to the other side. All those are values that are going to be very important to you going forward. So today has been extremely useful. The past days, weeks have been extremely useful, and the values and the techniques you've learned, you'll carry with you for a very long time. I know you don't quite believe it, and maybe the sugar levels are down, so you are like, this guy is just talking, when are we going back to school? But it's quite important. So for us, as Huripec, and I dare say as the School of Law, because I also bring greetings from the Dean of Law and the entire staff, we're extremely excited about this. It's the beginning of what should be an annual event going forward. In that regard, I'd like to thank our partners, Lex Amica, Harry Mwesigwa. They have done incredible work putting this together. The Makerere School, Law School of Law Club, Ashaba, where are you, Ashaba? The Makerere School of Law itself represented, the Dean was not able to come, he was traveling, and the Deputy Dean is also indisposed, but certainly they are following with great excitement. The Dean asked where Mwiri is, and I told them Mwiri feared, and where Butiki is also, and they also feared. So those of you who did not fear, it's the first step. Hopefully next year, the others who feared will also get the courage to turn up and put up a show. The Initiative for Social and Economic Rights, ISA, has also been an incredible partner, and we appreciate their support. Without their support, this would not have been possible in the way it has been. The Uganda Law Society has also been incredibly supportive. Chapter 4 Uganda has also been quite supportive. I don't think I've left anyone out, have I? No. So really it has been a collaborative effort putting this together. Now, for the schools that participated, thank you. 10 initially for this first year, and that can only become more participatory the next year. Of course, there are going to be challenges about how to limit numbers going forward and how to ensure it remains competitive, but also not too big, so that you can actually have a meaningful engagement. So to all the schools represented here, some have left because of the time, thank you to the patrons, the coaches, the teachers. And I know by and large you have trusted the process and seen that the process is fair. Has the process been fair? Based on objective criteria that has been explained to everyone, and the raw results are available. The judges, many of them not around, but incredibly supportive. The volunteers, the student liaisons, I see Victor, Brita, the rest are probably sleeping. They have collapsed, out of sheer exhaustion. Alicia and others, thank you so much. Peter, Sweetie, that's actually her name, so it's just, yeah. Angelo. Really, all of you, thank you very, very much. Harry, I think I've spoken all the English that was supposed to be spoken at this time. I can't think of anything I've not said. Victor, should I add on something there? Any questions for me before I go away? For us, if I can just wrap it up in just one word. Okay, I think that's the sign for me to stop talking and hand over the mic back to the judges. Thank you all and good evening.
I think you can have a seat.
You're going to get my back.
Thank you so much, Doctor. Our judges have returned. And right now we are going to proceed with awarding. the certificates, firstly to the participants who are still with us this evening, and then also to the schools in appreciation over the excellent work that they have done in making this competition a success. Allow me invite Angel Ashaba from the Rule of Law Club of Makerere University. Give me that. Firstly, Yiga Eric. Let's clap for him. Congratulations. Mercy Judith. Let's clap for her. Let's try to be a little quick as we come so that we can wrap this up in the shortest time. There. Have a photo moment. Congratulations. Mirembe Juliana. Namugenyi Cynthia Maria. Says Namugenyi. Congratulations. And that is Mirembe Namirembe Juliana. Muzaki Alana Kiravo. Congratulations. You'll forgive me if I don't pronounce this rightly, but Hamon Asmarum G. Congratulations. Thank you so much, Angel. Allow me invite it's back on. Allow me invite Dr. Usinje Kavumba. Okay. To do the honors and award the schools which have remained with us up to this time, we had 10 schools in this competition. Most of them have left because of time, but we thank you who have remained up to this time Firstly, I'll request the patrons of these schools to come forward as I read and have a photo moment with the good doctor. Gayaza High School. Mengo Senior School. Congratulations. Chitante Hill School. Okay. Now, when this competition began, all of us participated in 2 preliminary rounds where everyone had a chance to showcase their oralist skills. And from the preliminary rounds, the 2 speakers who scored the highest speaker points and impressed the judges in terms of their oral advocacy get to be specifically awarded and have a photo moment with the good doctor. The second best oralist of the first Ugandan National Schools Moot Competition 2025 is, drum rolls again, none other than Yiga Eric. Congratulations, congratulations. Such a fine gentleman. Future Chief Justice of Uganda. Now the second best oralist gets a framed certificate together with a plaque award. Oh, the best oralist, guys. This is an appreciation award from the Uganda National Schools Moot Court Competition. It's presented to the best oralist in recognition of their outstanding advocacy, eloquence, and excellence in oral presentation. All the skills that are necessary for a lawyer and an advocate, to be specific. It also celebrates their exceptional performance, their confidence, and their persuasive skill that they have demonstrated during the competition. It's quite heavy. The best oralist. Drum rolls. Of the first Uganda National Schools Moot Court Competition 2025. Who also qualifies to be a president of the International Court of Justice is none other than Harry Mwesigwa. Thank you for celebrating me. Indeed. So the best oralist of the first Uganda National Schools Moot Court Competition. This one is better than many law students. I'll stop there before the members of Makerere School say we. Is none other than Harmony Asmarom G. Congratulations. So she gets a certificate. Congratulations, Harmony. From Mengo Senior School. And an award. Congratulations. Now, we are going to the
As Harry does something small, let me also take a moment to, off the program, just recognize a certain gentleman I'm sure you've been seeing around. Maybe some of you know him, maybe some of you don't. Mr. Malema Virizi, who is quite well known as the rule of law champion. The rule of law champion has been with us since morning and has had the stamina and fortitude and really the good grace and passion and eagerness to be with us for most of the day. We appreciate you, Mr. Malema Virizi. Thank you for joining us today.
And he's amazing photographer and videographer. I think he has stepped out, but we also appreciate him too. Now, the time has come. However, before I announce the result of the finals, I'll request the two teams to just come. Yeah, that's right. I request the two teams that argued the final. You can sit on your representative sides or just, you can sit for the meantime. Let us clap for them, guys. Getting to a Moot final is not a mean feat. Okay. So at this stage, we are allowed to disclose the names of the teams. We had two teams. We had two teams. In the applicants, we had Team Justice Kisache. Justice, you'll allow me briefly speak about the names and the choice why we selected those names. We selected some of the most eminent jurists in Uganda. Particularly, Justice Kisache is a champion of the rule of law who was exiled because of her dissent in an election petition. We thought it was honorable to have her name here and mentioned because of the work that she has done. Another one was one of the most celebrated jurists in Uganda, a former Chief Justice of Seychelles, a former Chief Justice it was a former Chief Justice of Seychelles. There's another nation which skips my mind. Was it Kosovo? The United Nations UNITA, the UNITA, it's a United Nations body on transitions, none other than Justice Engonda Ntende, is one of the only justices who dissented in the Susan Chigula case concerning the death penalty and argued that the death penalty, specifically the method of hanging, is unconstitutional. He's also one of the only justices who dissented in the recent decision filed by one of our partners, Chapter for Uganda, and Dr. Usinje Kawumba, and declared that no ground, the requirement for you to have a ground in order to divorce in Uganda is unconstitutional. He was arguing that the moment you withdraw consent in a marriage, that should suffice to dissolve the union. So he's a man who understands what consent means within our constitutional dispensation. And that was this second team. Now, before we proceed to the call of the judges, allow me to also award the second runners-up. The second runners-up are the team which is placed third, and which was the third best team according to their speaker points in the semi-finals. That team is none other than Chitante Hill Secondary School. Congratulations to Chitante Hill School. Those are the two amazing youngsters who argued the case together with their patron. Chitante Hill just started training last week, and in 1 week, they have done an exceptional job. I will also call Sweetie, who is the coach of Chitante, to come here with them. Congratulations, Chitante Hill School. Give them from ahead there. Congratulations, congratulations. Congratulations. Okay, now, I'm sorry for keeping the good doctor standing, but he's a very fit man. Now, to the final call. Drum rolls. Drum rolls. Drum rolls. We had a panel of 6 judges. This was, they tell me, it was an exceptionally impressive round. One of the best rounds that they have judged in all their careers. And they are exceptionally impressed that secondary school students could argue these things. Things that even some of us could not argue while we were in secondary school. This was a split ballot. Of 4-2. Someone tell your neighbor, 4-2. 4-2. Which one is in the majority? Exactly. So you need a majority of the judges. So one team convinced 2, another team convinced 4. Well. And the judges tell me that the team which won, or which wins, the first Uganda National Schools Moot Court competition is none other than, drum rolls, it's none other than the team which is going to take this trophy. Guys, okay, let me mention that team, we don't have time. The team which wins the first Uganda National Schools Moot Court competition has a girl. It also has 2 students who are wearing gowns. So this certificate will be presented. I'll first announce the first runners-up. When I announce the first runners-up and we award them, we shall automatically know the winning team, right? Guys, the excitement is too much. Or we go back and come back tomorrow. We shall send the results via email. Doesn't that work? Okay. Dr. Kavumba. This is a silver trophy of the first Uganda National Schools Moot Court competition. And it's for the first runners-up.
Thank you very much. I can see this. It's silver.
Very silver, with a black base. Yes. With stripes, I don't know how they call them.
It's for the first runners-up.
Yeah, exactly. It has a crown on top, as you can see.
And it's very silver.
Very silver, entirely. So you can even see your reflection. Anyway. Oh, we also have medals. I had forgotten. Silver medals. Judges are impatient. These are for the first runners-up, 3 of them. 2 for the oralists and 1 for the patron. And also a certificate. Okay, now, guys, if you want me to announce, we are going to count from 5. Yeah, I am the owner of this competition. Okay, 5, 3, 1. The first runners-up of the first Uganda National Schools Moot Court competition is none other than, drum rolls, drum rolls, drum rolls, breathe in and out, Mengo Senior School. Congratulations to Mengo Senior School. DJ, give us celebratory music. Congratulations, congratulations. Congratulations. We have had a system of trainers. I think they can share in this victory. I'll invite Melissa also to bask in the glory of Mengo Senior School. Mengo Senior School, DJ? Mengo Senior School started training 3 days ago. Guys, 3 days ago. And they have done something exceptional. A feat that no one can easily achieve. Congratulations. Mengo Senior School, apart from being the first runners-up, also has the best and second best oralists. Wow. Champions. Congratulations. And now for the team that you inevitably know. The winner, which you know, of the first Uganda National Schools Moot Court competition, taking home a golden trophy and golden certificate. For these ones, doctor, you have to put certificates in them. Yes. A ceremony. Oh. Yes, the medals, but you can as well put the certificates on the head. I'm kidding. Anyway, is none other than Gayaza High School. You're welcome, Gayaza. Congratulations. Patron Gayaza High School. Congratulations for winning. Congratulations. Let's take a photo moment with the good doctor. Let's come here. Let's have a photo moment with also the 2 amazing coaches who were sent by the organization. Doctor? Raise the trophy. I know it's heavy. Congratulations, Gayaza High.
Who am I not to join? Champions of the first National Schools Moot Court competition. Okay, we shall see you next year. In the meantime, we will engage some of these participants. But thank you so much for gracing this event. Safe journey home. Oh, a minute before we leave. I want us to all stand up. Thank you. I know I've asked a lot from you. But I want us to clap for all our amazing judges who have done the best to deliver for us the best competition and the most successful event of the day. We thank you, the organizers thank you. We are extremely grateful. These are not the only judges. We also had other judges who did not judge the final. I can mention them. Dalton Kisule, Melissa Ankunda, and also Harry Mwesigwa. Clap for him, that good gentleman. Thank you so much. Okay, have a good evening, and bye-bye. For the teams that haven't handed over the gowns, please hand them over to Kato Joram, that gentleman raising his hand. Thank you so much. Thank you, Doctor. Maybe have a session.